Part 5. Under Color of Law. Legal Duels over Compulsory Masking. We can have intellectual individualism and the rich cultural diversities that we owe to exceptional minds only at the price of occasional eccentricity and abnormal attitudes. When they are so harmless to others or to the state as those we deal with here, the price is not too great. But freedom to differ is not limited to things that do not matter much. That would be a mere shadow of freedom. United States Supreme Court, West Virginia Board of Education v. Barnett, 1943. During the COVID crisis, a small cadre of lawyers demonstrated why doctors of law are every bit as essential as medical doctors. I am not a lawyer, and what follows is not legal advice. Take this section on the legal arguments surrounding masking as you would take editorial material from a journalist, a blogger, or a friend who did a lot of homework. Sources are cited in the footnotes. An entire book could be written on this topic alone. This section is intended to be a broad overview of the legal aspects involved with compulsory masking, especially the constitutional issues, and a jumping-off point for your own researches. Do not spend money or file a lawsuit based purely on what you read here. Consulting a lawyer, and, most importantly, doing your own research, are essential prerequisites for success pushing back on masking through any judicial or administrative route. Quite apart from the specific legal issues involving masks, administrative and courtroom procedures are complicated and difficult to navigate in and of themselves. At the time of this writing, mask-related litigation is still very active, and much remains unresolved. When mask mandates hit the scene, they were just one out of many types of unprecedented and invasive mandates. These mandates were issued, changed, repealed, and reissued with modifications so quickly that it was practically a full-time job just to stay up to date on what was allowed and what was not. In the face of such a policy-making frenzy, imposed in an atmosphere of widespread uncertainty and fear, plenty of people, even among those inclined to push back against COVID crisis overreach, simply acquiesced to mask mandates as a comparatively minor nuisance. For many, that is truly all masks ever were. For others, fighting mask mandates was a priority, but still had to be put on the back burner. Business owners facing financial ruin through mandated restrictions on their operations, and parents whose children were now at home 24/7 had more pressing concerns. Still, many Americans recognized the deeper threat that mask mandates presented, and fought back as best they could, whether in the court of public opinion or in the courts of law. Even unsuccessful lawsuits were helpful, functioning like artillery rounds that served to hone in on a target by trial and error. As is the case with mask science, upon close examination, the laws, regulations, rulings, and arguments cited to sustain compulsory masking turn out to be far weaker than advertised. Just who, precisely, is putting these mandates out, and how are they doing it? The legal powers invoked to mandate masks varied depending on the mandate, involving a labyrinthine maze of statutes, emergency powers, and administrative authorizations. Though House Speaker Nancy Pelosi implemented a masking policy in the House of Representatives as a matter of decorum, to its credit, the U.S. Congress never passed a mandatory masking law, despite shrill howls for such unconstitutional legislation from many quarters. It was mostly the executive branches of state and federal government, state governors, federal agencies, and local municipalities that mandated masks using interlocking disaster declarations and their respective emergency powers, playing an administrative shell game of diffuse the responsibility. Official emergencies give executives and other authorities broad powers to bypass normal processes and constitutional safeguards, allowing them to enact orders that infringe rights normally sacrosanct. Naturally, then, the first step in mandating masks was a chain reaction of public health emergency and disaster declarations that started well before most people were even aware of SARS-CoV-2 or the administrative avalanche bearing down on them. On January 30th, 2020, the World Health Organization declared that COVID-19 constituted a public health emergency of international concern. This third-party declaration provided political cover and psychological impetus for United States Health and Human Services Secretary Alex M. Azar to declare a public health emergency for the entire United States pursuant to the Public Health Service Act, PHSA, the next day. 4 days later, on February 4th, 2020, the HHS Secretary put out a separate public health emergency declaration under a subsection of the PHSA known as the Public Readiness and Emergency Preparedness Act, PrEP Act for short. This second public health emergency declaration, based on his authority under Section 564 of the Food, Drug, and Cosmetic Act, set the stage for immunity from liability regarding the use of multiple medical countermeasures to COVID-19, including masks. This HHS Public Health Emergency Declaration was followed by an Emergency Use Authorization Declaration, which took effect on March 27, 2020. Federal-level emergency and disaster declarations provided additional cover for state governors already empowered to declare emergencies through their own state laws and Emergency Health Powers Acts, known by various names in each state. Each state had its own separate but similar process. Giving just two examples from Texas and Massachusetts, in Texas, Governor Greg Abbott issued a disaster proclamation on March 13th, certifying, based on a mere 30 confirmed cases, not deaths, but cases, that COVID-19 poses an imminent threat of disaster, and renewed the disaster declaration monthly thereafter. When he mandated masks in July, Governor Abbott cited to Texas Department of State Health Services DSHS Commissioner Dr. John Hellerstedt's determination that COVID-19 counted as a public health disaster within the meaning of the Texas Health and Safety Code. In Massachusetts, Governor Charles Baker declared an emergency 3 days earlier on March 10, 2020, and made masks mandatory on May 6th, citing only a vague reference to the CDC's advice to wear cloth face coverings. Other states followed their own version of this pattern. Most of these executive orders were easy to locate and were neither lengthy nor complicated, and contained numerous broad exceptions that undermined their stated rationale of infection control. Governor Abbott's July 2020 mask mandate, for example, was just 5 pages long, and made exceptions for medical conditions, eating and drinking, voting, security identification, religious worship, giving a speech to an audience, and exercising while more than 6 feet away from other people. Massachusetts Governor Baker's mask mandate outright said, "All persons are strongly discouraged from using medical-grade masks to meet the requirements of this order," on the rationale that healthcare workers needed medical-grade masks more. In practice, mask wearing often went far beyond what was required by the mandates, as everyone wanted to signal that they were part of the solution and feared being seen as part of the problem. Too many people who were enforcing these orders simply treated them as applying to every person engaged in all activities in a public setting, ignoring exceptions or construing those exceptions as narrowly as possible. Children and adolescents who were never at any real risk from COVID were frequently forced to wear face masks while playing and exercising outdoors by adults who could have and should have known better. Many local districts issued their own mask mandates weeks or even months before their state governors did so. In El Paso, Texas, for example, where I lived at the time, Mayor D. Margo and Health Authority Dr. Hector Ocarranza mandated masks on April 24, 2020. Under D. Margo's mayoral successor, Oscar Leeser, El Paso was zealously suing to keep those mask mandates in place more than a year later, months after Governor Abbott finally banned mask mandates in July 2021. At an even more local level, school boards, businesses, and private institutions implemented too many mask mandates to count. Foremost among the federal agencies pushing for compulsory masking was the CDC. When asked to provide medical justification for compulsory masking, public health authorities universally gestured in the general direction of CDC recommendations and publications. CDC Director Robert Redfield co-authored a July 2020 editorial in the Journal of the American Medical Association calling for universal masking. In a September 2020 Senate hearing, Dr. Redfield famously declared while brandishing a surgical mask, "These masks are the most important, powerful public health tool we have," and "I might even go so far as to say that this face mask is more guaranteed to protect me against COVID than when I take a COVID vaccine." If Dr. Redfield's successor, Dr. Rochelle Walensky, was not a true fanatic for masks, then she was at least truly committed to faking it. As late as January 11, 2022, she was testifying, double-masked, before the Senate Health Committee, next to a conspicuously unmasked Dr. Anthony Fauci. It is no exaggeration to say that the CDC served as the most important linchpin for the policy of compulsory masking. The Department of Defense, which provided over one of the healthiest subpopulations of the United States and one of the least vulnerable to COVID, was nevertheless the fastest to jump on the mask mandate bandwagon. On April 5th, Secretary of Defense Mark Esper issued an order mandating the use of cloth face coverings for all individuals on DoD property, installations, and facilities. By then, plenty of local hospital, clinic, and medical unit commanders had already been effectively mandating masks since March. Citing CDC recommendations, other federal executive agencies like the Food and Drug Administration, FDA, enthusiastically facilitated mandates by providing carefully lawyered emergency use authorizations, EUAs, for face masks, including cloth face masks, as well as for other paraphernalia like goggles and face shields. The FDA also put out enforcement policy guidance recommendations regarding masks as medical devices. Notably, the FDA's EUA, even for surgical masks, only mentions protection from respiratory droplets and large particles, not aerosols, despite the fact that on the ground, then and later, virus-containing aerosols were cited as the reason for forcing people to wear cloth and surgical masks. This was just one of many internal contradictions in masking doctrine. The Occupational Safety and Health Administration, OSHA, already had detailed regulations for certain workplace personal protective equipment, PPE, in healthcare settings. These regulations were further extended in the name of controlling COVID while referring and deferring to the CDC. On June 21, 2021, OSHA adopted a Healthcare Emergency Temporary Standard, ETS, and promised to vigorously enforce the General Duty Clause and general standards of personal protective equipment and respiratory protection standards with regard to COVID-19. In spite of all these EUAs, cloth face coverings never met the criteria to serve as personal protective equipment under OSHA standards. COVID theater with a sharp point. Like other anti-COVID measures, masks were imposed on the unwilling using threats of harsh fines and even prison time, backed up by force. In the United States, Hawaiian Kauai County Mayor Derek Kawakami issued a particularly harsh mask mandate prescribing up to $5,000 fines and 1 year of prison time for violators. Doctors exercising their rights of free speech to oppose masking could and did have their licenses threatened, investigated, or revoked if medical boards did not like their speech, as happened to Dr. Stephen LaTulip in Oregon. In a bitter irony, these draconian measures were often justified on the rationale that dissident doctors' speech and teachings violated medical ethics. This, despite the fact that dissident doctors maintained their positions based on science and their sense of duty to speak the truth. Ordinary citizens fared no better. In Ohio, Alicia Kitts was tased and arrested for not wearing a mask outdoors at a middle school game. Idaho church deacon Gabriel Wrench was arrested in September 2020, along with fellow congregants Sean and Rachel Benet for not wearing masks while singing psalms at an outdoor protest worship service. Citizens throughout the country protesting mandatory masks at school board and city council meetings were denied entry or not allowed to speak against masks without first putting on masks. In El Paso, Texas, months after Governor Abbott banned school mask mandates, 17-year-old Skylar Brown was arrested for disrupting an El Paso Independent School Board meeting by refusing to put on a face mask. Even as late as October of 2022, when Gregory Hahn of North Carolina appeared in person to serve on jury duty, Judge Charles Gilchrist sentenced him to 24 hours in jail for contempt of court because Mr. Hahn refused to put on a mask. What the irony of this whole thing is that the judge was talking to me without a mask on, Hahn said in an interview. Even sitting congressmen, including Thomas Massey, Marjorie Taylor Greene, Ralph Norman, and Andrew Clyde, were fined for not wearing masks. Bad as mask hysteria was in the United States, other countries had it worse. In Mexico, a 30-year-old bricklayer named Giovanni Lopez was arrested for not wearing a mask and died from police-inflicted blunt trauma to the head. China's ruthless lockdown measures, including masks, could fill a book on their own, and India saw multiple incidents where brutal police beatings were precipitated either by not wearing a mask or by wearing a mask improperly. When German judge Christian Detmar courageously ruled that continuing to mask school children would violate numerous rights of the children and their parents under the law, the Constitution, and international conventions, his office, private premises, and car were shortly afterwards searched, his cell phone was confiscated, and he had to retain an attorney to defend himself. In August 2023, he received a suspended sentence of 2 years imprisonment on criminal charges of incorrectly applying the law because of his ruling. Jacobson v. Massachusetts. Humans are rational beings, but human rationality is often the most vigorously employed to justify decisions made on non-rational grounds. Long before the dawn of the American Republic, it was proverbial that you cannot reason people out of a position they did not reason themselves into. This tendency is every bit as characteristic of people in highly educated professional and intellectual occupations as it is of people who make up the general population. As Thomas Sowell insightfully pointed out, although the talents and education of intellectuals would seem to enable them to be proficient at engaging in logically structured arguments, using empirical evidence to analyze contending ideas, many of their political or ideological views are promoted by verbal virtuosity in evading both structured arguments and empirical evidence. Judges are people too. They possess every foible, fault, and potential virtue that comes from being human. Judges are not unbiased because humans are not unbiased. Judges are no less prone to fears, confirmation bias, or motivated reasoning than anyone else. They are no less vulnerable to propaganda, psychological manipulation, or social pressures than are doctors, dentists, scientists, politicians, and the general public. A judge's context and experience form the lens through which they read and interpret the law. The multi-layered judicial system, with its appellate courts, assumes that judges make mistakes. Just as doctors were subjected to professional pressures during the COVID crisis, so were judges. Additionally, the career path of becoming a judge tends to favor personality types that like rules and defer to authority figures more than average, and the lengthy timeline for progression in this occupation ensured that, compared to the general population, a higher proportion of judges fell into the age brackets most vulnerable to COVID. The COVID crisis threw all of this into stark relief, as courts across the United States employed great ingenuity and verbal virtuosity to undermine or dismiss legal challenges to lockdown measures, challenges which many judges found inherently repugnant for much deeper reasons. For most of 2020, and even into 2021 and 2022, the 1905 case of Jacobson v. Massachusetts proved to be one of the most convenient, powerful, and widely recycled additives making up the legal formulas used to scour away challenges to COVID mandates. Jacobson v. Massachusetts lurks behind almost every ruling that upheld compulsory masking. If courts did not cite it directly, they cited other cases which relied on it. Illinois Federal District Judge Sarah Ellis provided a good summary of the standard COVID crisis interpretation of Jacobson. Over a century ago in Jacobson, the Supreme Court developed a framework by which to evaluate a state's exercise of its emergency authority during a public health crisis. Jacobson explained that, upon the principle of self-defense, of paramount necessity, a community has the right to protect itself against an epidemic of disease which threatens the safety of its members. Jacobson v. Commonwealth of Massachusetts provides the applicable standard in cases challenging public health orders, ruled Judge Robert C. Chambers in West Virginia. Since the challenged orders are public health measures to address a disease outbreak, Jacobson provides the proper scope of review, said United States District Judge Catherine C. Blake in Maryland. Judge Martin Feldman in Louisiana said, "The police power outlined in Jacobson precludes this court from second-guessing the wisdom or efficacy of measures taken by state officials in response to the COVID-19 pandemic." In reviewing the role played by Jacobson v. Massachusetts during COVID crisis court battles, law professor Josh Blackman observed, "Jacobson or no Jacobson, courts still would have deferred to unprecedented lockdown measures. Yet Jacobson proved to be a useful prop." The precipitating issue in Jacobson v. Massachusetts was compulsory vaccination, which Swedish pastor Henning Jacobson challenged under the 14th Amendment, and that is what the case is best known for. In Jacobson, the United States Supreme Court ruled that the 14th Amendment did not prevent states from using their police power to enact a compulsory vaccination law with a modest one-time fine for refusing the medical procedure. Yet, over and over again during the COVID crisis, courts across the United States relied heavily on this 1905 Supreme Court decision as an indispensable tool for rejecting a far wider range of legal challenges to COVID crisis measures like lockdowns and compulsory masking. The mask mandates are emergency measures to which this court should apply the highly deferential standard articulated in Jacobson v. Commonwealth of Massachusetts, 197 U.S. 11, 1905, rather than the usual constitutional framework, declared Judge Susan Mulway in Hawaii. During the 9 months from March through December 2020 alone, Jacobson was cited in court decisions more than 200 times. Illinois District Judge Stacey M. Yandel pointed out in November 2021 that her own reliance on Jacobson was hardly unique. Relying on Jacobson, courts across the country have consistently declined to enjoin state and local restrictions aimed at protecting the public against the spread of COVID-19. One article in the National Law Review summarizing the results of legal challenges to compulsory masking up through September 2021 wryly noted, "Often, the only question the courts ponder in these cases is whether to apply the Supreme Court's tiers of scrutiny analysis or the older framework articulated in Jacobson v. Massachusetts." In Part 4 of this book, we saw how the cancerous legacy of Jacobson v. Massachusetts metastasized over the course of later rulings. Even if taken at face value on its own terms, however, the original 1905 decision, when taken as a whole, does not support the extreme interpretations put forward to justify its widespread COVID crisis application. The Jacobson case is usually cited as an automatic checkmate that an individual's rights over their body are not absolute, but it actually makes an even more effective argument that governmental power to override individual liberty does not become absolute even during a public health emergency. Setting aside its own closing statement that we now decide only that the statute covers the present case, which limited its future broad usage, the Jacobson decision actually affirmed multiple limitations on the scope of state power which future courts had to construe as narrowly as possible in order to wield Jacobson the way that they did. In Jacobson, the majority opinion delivered by Justice Harlan explicitly affirmed that state police powers are not unlimited, citing previous Supreme Court decisions where the court had invalidated sanitary laws which had invaded the domain of federal authority and violated rights secured by the Constitution. The court also affirmed that the Massachusetts vaccination law would not have been valid if it was primarily for some purpose other than public health, i.e., pretextual, and that a reading of the Massachusetts law which excluded reasonable medical exemptions could justify intervention to protect the individual. Moreover, while the police power of the state of Massachusetts might be able to extend to imposing a one-time modest fine on an individual for refusing vaccination, it did not extend to vaccinating that individual by force. Perpetual quarantine or exclusion from civil society seems not to have crossed anyone's mind. When Jacobson v. Massachusetts was decided in 1905, the First Amendment had not yet been incorporated to apply against the states via the 14th Amendment. In fact, the Supreme Court had yet to strike down any law based on the incorporation doctrine even by the time of Buck v. Bell in 1927. The Supreme Court transcript of the Jacobson trial reveals that Massachusetts' mandatory vaccination law made it an outlier among the other states of the Union. 3/4 of the states of the Union have not entered upon the policy of enforcing vaccination upon their inhabitants by legal penalty. Not one of the states undertakes forcible vaccination of its inhabitants, while the states of Utah and West Virginia expressly provide that no such compulsion shall be used. Moreover, despite courts citing Jacobson to dismiss free exercise and other First Amendment challenges to COVID crisis mandates, the Jacobson decision provided no such governing precedent because Henning Jacobson never raised any defenses based in the First Amendment. Finally, and so important that it is worth repeating, the Massachusetts law at issue in Jacobson imposed only a modest penalty for refusing vaccination, a one-time fine of just $5, a little over $150 in 2023 dollars. This fact was part of the reason that Jacobson's conviction under the compulsory vaccination law was upheld. As law professor Josh Blackman writes, the $5 penalty operated in a similar fashion as nominal damages. The amount was large enough to prosecute in court, but not large enough to actually punish offenders, and a one-time fee of $5 was unlikely to deter opponents of vaccination. Because there was no possibility for jail time, an offender could simply pay the penalty and move on with his life. The Massachusetts vaccination law Henning Jacobson was charged under was, thus, in effect, a low-cost form of public health commutation fee, analogous to paying a fee to avoid a military draft. Damningly for anyone citing Jacobson to uphold draconian public health measures and societal exclusion for the unmasked and unvaccinated, an unvaccinated person who paid the Massachusetts fine was then fully in compliance with the law and remained free to spread smallpox. Unvaccinated Pastor Henning Jacobson remained completely free to engage in large social and political gatherings during the years his case worked its way up through the courts, and did so across multiple states, including when he served as part of a delegation to the St. Louis World's Fair of 1904. Since COVID-19 never came close to approaching the same league as smallpox, even according to the most apocalyptic divinations, a truly consistent application of the Jacobson standard in the case of COVID would have resulted in even smaller one-time opt-out fees for both masks and vaccines, and no societal restrictions. Instead, the unmasked and unvaccinated faced vitriolic ostracization and demonization by pundits, politicians, and public health officials, including but not limited to job loss, fines of hundreds or thousands of dollars, and, in a few cases, deprivation of further fundamental rights through jail time. Mask and vaccine mandates during the COVID crisis went far, far beyond anything resembling a proportionate extension of the Jacobson decision. In his dissent from the majority that was upholding Japanese Americans' World War II internment without trial or conviction in Korematsu v. United States, Justice Robert Jackson warned that when the court validates a bad principle, the principle then lies about like a loaded weapon, ready for the hand of any authority that can bring forward a plausible claim of an urgent need. In his own analysis, Professor Blackman applies this quote to the creeping, overextensive myth of Jacobson v. Massachusetts. During the COVID crisis, politicians, pundits, public health officials, and judges picked up Jacobson and applied it to everything they could get away with in a constitutional reign of terror. In so doing, they often misused it not only on unenumerated rights, but on every other right explicitly recognized and protected by the Constitution as well. Traditional doctrine does not control during a pandemic. Jacobson does, United States District Judge Martin Feldman bluntly ruled in Louisiana. New Mexico District Judge James Browning cited Jacobson to restrict churchgoers' enumerated First Amendment rights of assembly and free exercise of religion. Judge Sarah Ellis did the same in Illinois, declaring that during a crisis where Jacobson v. Massachusetts is implicated, constitutional claims have a less than negligible chance of prevailing. Even within the Fifth Circuit, which in many ways was a bastion for embattled federal employees and military service members fighting unlawful vaccine mandates, two judges, Stuart Kyle Duncan and Jennifer Walker Elrod, insisted in April 2020 that Jacobson created a pandemic exception to the Bill of Rights. Jacobson instructs that all constitutional rights may be reasonably restricted to combat a public health emergency. Jacobson governs a state's emergency restriction of any individual right. Fortunately for Americans, other judges rightly and vocally disagreed, and even more privately questioned the scientific, moral, or legal legitimacy of various COVID crisis mandates. Judge Daniel Collins of the Ninth Circuit wrote, "Nothing in Jacobson supports the view that an emergency displaces normal constitutional standards. Jacobson says nothing about what standards would apply to a claim that an emergency measure violates some other enumerated constitutional right. On the contrary, Jacobson explicitly states that other constitutional limitations may continue to constrain government conduct." Judge Lance Walker, for the District of Maine, quoted and affirmed a dissent by Supreme Court Justice Alito. "It is a mistake to take language in Jacobson as the last word on what the Constitution allows public officials to do during the COVID-19 pandemic. Language in Jacobson must be read in context." In the same dissent, Justice Alito rightly pointed out that a public health emergency does not give governors and other public officials carte blanche to disregard the Constitution for as long as the medical problem persists. In September 2020, while coronaphobia was still very much at its peak, Judge William S. Stickman IV issued a lion-hearted ruling against Pennsylvania Governor Thomas Wolfe's lockdown measures despite Jacobson. Judge Stickman ruled, "An extraordinarily deferential standard based on Jacobson is not appropriate. The Constitution cannot accept the concept of a new normal where the basic liberties of the people can be subordinated to open-ended emergency mitigation measures. Rather, the Constitution sets certain lines that may not be crossed even in an emergency." In November 2020, a majority of the Supreme Court indicated that they too disagreed with the overextended reading of Jacobson v. Massachusetts. The Supreme Court's holding that month in Roman Catholic Diocese of Brooklyn v. Cuomo was a critical turning point for embattled unalienable rights everywhere. In that decision, the court used traditional First Amendment jurisprudence to grant relief against the severe and discriminatory restrictions New York Governor Cuomo placed on houses of worship in the name of public health. In addition to the majority's now famous pronouncement that, even in a pandemic, the Constitution cannot be put away and forgotten, Justice Neil Gorsuch wrote a concurrence which directly addressed the widespread erroneous readings of Jacobson v. Massachusetts. Jacobson hardly supports cutting the Constitution loose during a pandemic. That decision involved an entirely different mode of analysis, an entirely different right, and an entirely different kind of restriction. Put differently, Jacobson didn't seek to depart from normal legal rules during a pandemic, and it supplies no precedent for doing so. Even if judges may impose emergency restrictions on rights that some of them have found hiding in the Constitution's penumbras, it does not follow that the same fate should befall the textually explicit right to religious exercise. In fact, Jacobson explained that the challenged law survived only because it did not contravene the Constitution of the United States or infringe any right granted or secured by that instrument. Like a painfully slow turning of the tide, challenges to COVID crisis overreach after November 2020 began to make gradual headway as lower courts followed the Supreme Court's lead in Roman Catholic dioceses. Even so, progress was incremental, and multiple courts stubbornly clung to Jacobson well into 2021 and 2022. Like a painfully slow turning of the tide, challenges to COVID crisis overreach after November 2020 began to make gradual headway as lower courts followed the Supreme Court's lead in Roman Catholic dioceses. Even so, progress was incremental, and multiple courts stubbornly clung to Jacobson well into 2021 and 2022. District Judge William Young countered, "A chorus of scholars, justices, and courts argue that Jacobson's standard is improper, particularly when applied to First Amendment challenges. The Supreme Court, however, has not yet ruled on whether the tiers of scrutiny overrule Jacobson, despite recent opportunity to do so." In March 2021, 5 months after the Supreme Court's decision, Judge Cynthia Béchamp dismissed a substantive due process claim against masks by saying, "Because Jacobson remains good law, the court will apply it to plaintiff's substantive due process claim." Although Jacobson is more than a century old, recent case law shows that it is still good law, insisted Judge Robert Chambers 3 months after the Supreme Court's ruling. After being reminded of Justice Gorsuch's concurrence and the U.S. Supreme Court's admonition that we may not shelter in place when the Constitution is under attack, Judge Chambers proceeded to do that very thing, upholding a mask mandate with the snippy retort that this court has not sheltered in place, it simply finds no invasion of fundamental constitutional rights here, even under plaintiff's preferred standard. Likewise, Ninth Circuit Judge Jennifer Dorsey cited Jacobson to uphold a mask mandate in late December 2021. The mentality behind the erroneous Jacobson standard continues to subtly infect court decisions. Many courts that did not quote Jacobson directly still used it indirectly by citing to court rulings which relied on it. Even if Jacobson had been good law, the Supreme Court still specifically referenced Jacobson prior to the COVID crisis, saying that a state's interest in the protection of life falls short of justifying any plenary override of individual liberty claims. Regardless of how many courts refuse to recognize it, the fact remains that even under the Jacobson standard, compulsory masking was and is a plain, palpable invasion of rights secured by fundamental law. The first major legal victory against compulsory masking would have to wait until 2021, and it would come in state rather than federal court. In the following sections, we will review constitutional and other challenges brought against compulsory masking and explore the reasons why some legal challenges succeeded where others failed. Challenging mask mandates. It is one thing to know or sense that one's rights are being violated, but it is much harder to explain precisely which rights are being violated and how. Articulating that explanation within a legal system to obtain relief is at a still higher level of difficulty. Compulsory masking is no exception to this rule, and as we have already seen from the psychology and philosophy involved, most legal challenges to compulsory masking started with severe hidden handicaps. What specific natural rights and legally protected interests does compulsory masking violate? Whose rights and interests are they? How are these natural rights and legal interests recognized and protected under local, state, or federal law? What kind of judicial scrutiny do these violations have to survive, and what standard of review do judges apply when adjudicating them? At the time of this writing, in the late summer of 2023, precise answers to these questions are still being hammered out. The direction that process takes, as well as the outcome, are by no means set in stone. In a sense, it will never be completely resolved, because the issues underlying compulsory masking are as old as mankind. This makes it worth the time and effort to look at some of the mask lawfare to date. Challenges to mask mandates fall into one of two broad categories: rights-based constitutional claims and procedure-based or administrative claims. If it is not sneaking in a Jacobson v. Massachusetts type standard, under current jurisprudence, a court will subject the challenged mask mandate to either rational basis scrutiny, strict scrutiny, or some form of intermediate scrutiny, depending on the type of challenge and what criteria that challenge meets. Where rational basis scrutiny is applied, mask mandates are generally upheld. Where strict scrutiny is applied, mask mandates are generally struck down. Legal challenges to mask mandates are inevitably met with motions to dismiss. For the purposes of deciding whether or not to dismiss a lawsuit, judges are supposed to assume that well-pleaded allegations of fact in an initial complaint are true, and draw all reasoned inferences in favor of the plaintiff. Even if it seems almost a certainty to the court that the facts alleged cannot be proved to support the claim may not be dismissed so long as the complaint states a claim. When it came to lawsuits challenging compulsory masking, however, this presumption was effectively flipped to favor the mandates. Before the political tide started turning against masks and the CDC's general malfeasance during the COVID crisis became widely known, only a handful of allegations challenging compulsory masking managed to qualify as well-pleaded enough to survive a motion to dismiss. Pure coincidence, no doubt. Rational basis and strict scrutiny. For all the loud insistence that mask mandates were just following the science, compulsory masking was always driven far more by fear, social pressure, and a pathological obsession for control than by anything else. Mask mandates proved effectively immune to direct challenge by any volume of science because the standard of review applied to mask mandates was generally rational basis scrutiny. In the words of the Supreme Court, this standard of scrutiny is the most relaxed and tolerant form of judicial scrutiny. Rational basis scrutiny starts by presuming the authority's actions are justified and legal, and the burden is placed on the challenger to prove otherwise. A plaintiff must prove, or at least convincingly allege, largely in advance, that no conceivable legitimate governmental purpose could serve as a basis for the mandates he is challenging. The rational basis test is so easy for a defendant authority to satisfy that it is just one level removed from being a rubber stamp approval, and it was the go-to torpedo used for sinking legal challenges to compulsory masking that could not be dismissed using technicalities or by referring to Jacobson v. Massachusetts. Under rational basis scrutiny, mask mandates are accorded a strong presumption of validity from the moment of inception. Not just a nominal presumption, mind you, but a strong presumption. All rational basis scrutiny requires of mask mandates in order to be valid is 1. That they promote a legitimate governmental purpose, and 2. That there be a rational relationship between the mandates and that purpose. Regardless of any fundamental philosophical disputes about the role of government, when masks are examined using rational basis scrutiny, the legitimate governmental purpose criterion is always satisfied because decreasing the spread of any disease is always considered a legitimate governmental purpose. As for the second half of the rational basis test, the working definition of rational in rational relationship is so broad that it includes judges and legislatures' intuition, regardless of how irrational, uninformed, or tainted by mass hysteria that intuition may be. As a practical matter, in an emergency where more than half the population is scared witless, anything that might theoretically possibly maybe work will pass the rational basis test. By the same token, reliance on a public health expert or institution is also always considered rational for purposes of passing the rational basis test. In other words, an expert opinion that masks work is the only thing necessary to pass muster under rational basis scrutiny unless the judge decides to go out of their way to give the standard of review some genuine teeth. In practice, judges treated the CDC as a source that cannot reasonably be questioned. CDC recommendations and statements in favor of masking functioned as ex cathedra pronouncements of public health doctrine from an institutional Pontifex Maximus. Heresies or minority beliefs that contradicted this masking dogma were given short shrift, no matter how well argued and supported. When challenged, authorities and judges who privately supported mask mandates or who were unwilling to contravene them for other reasons simply gestured in the general direction of the CDC's recommendations to justify leaving everyone's masks firmly in place and punish any self-centered, anti-masker heretics. The bottom line is that under a rational basis standard of review, numbers, evidence, and actual science were and remain optional depending on the judge's whim. One district court judge was very blunt about this when applying the rational basis standard to dismiss a legal challenge to masks. The authorities issuing the mask mandate had no obligation to produce evidence to sustain the rationality of the mask mandates, she declared, and when it comes to containing a pandemic, the government's choice of means is not subject to courtroom fact-finding and may be based on rational speculation unsupported by evidence or empirical data. In other words, under rational basis review, authorities could and did get away with imposing mask mandates based on pure speculation, and the balance of the scientific evidence was only one step up from irrelevant. Like the Jacobson v. Massachusetts standard, the onus was then thrown on the plaintiff to show that there was no real or substantial relation between the mandate and its objective, and this was effectively impossible to do because scared and biased courts simply either deferred to the public health authorities or declared that rational speculation was good enough, even when faced with a mountain of contrary evidence. When the numbers, evidence, and actual science contradicted pre-existing biases that favored masking, the uncooperative evidence and science were simply dismissed or ignored. When these could not be ignored, courts simply said that the most such evidence could show was that there was a debate among experts concerning the effectiveness of face masks. That does not mean it was irrational for state and local officials to follow the CDC rather than plaintiffs' chosen experts. Mask mandates were imposed in the name of the science, but upheld because they were allowed to be illogical and unscientific. In order for a mask mandate to fail the rational basis test or its administrative counterpart, it must be irrational, or arbitrary and capricious. Most mask mandates actually were arbitrary and capricious and irrational, but showing that to be the case took both Herculean effort and great good luck in reaching a judge who would grant a genuinely fair hearing on the subject. In order to survive a motion to dismiss, the initial complaint not only needed to allege that the mandate in question was irrational, but explain in enough excruciating detail why that was so. As at least one lawsuit proved, this is not impossible, but we will look more at the heroic lawsuit which showed mask mandates can fail even rational basis type scrutiny later on. Strict scrutiny, by contrast, is the most demanding test known to constitutional law. It is rare that governmental actions fail rational basis scrutiny, and it is almost as rare for governmental actions to pass true strict scrutiny. As one judge put it, strict scrutiny leaves few survivors. It should come as no surprise that governmental defendants hate being subjected to strict scrutiny and will do everything they can to evade it. Under strict scrutiny, the burden of proof is not on the plaintiff, but on the defending authority to justify their policy. Moreover, to survive strict scrutiny, a mandate must actually further a compelling governmental interest. The merely legitimate governmental purpose required in rational basis scrutiny is nowhere near enough. A compelling governmental interest is something that the government must do as a legal duty, rather than something discretionary which it merely wants to do or can perhaps justify doing. For example, providing national defense is a compelling governmental interest, whereas providing education past a certain level may be a legitimate governmental purpose, but does not rise to the level of a compelling governmental interest. In the case of COVID-19, the Supreme Court has already ruled that stemming the spread of COVID-19 is unquestionably a compelling interest. But this concession still does not give mask mandates a free pass under strict scrutiny. Far from it. Under strict scrutiny, a policy must not only serve a compelling governmental interest, but it must be substantially related to furthering the compelling interest, rather than just reasonably related or rationally related, as in rational basis scrutiny. Under strict scrutiny, vague appeals to fear-saturated intuition, hand-waving in the direction of experts with conflicts of interest, and magic words like health and safety or risk of transmission are not enough to meet the burden of proof to show that something is substantially related to its objective. Under strict scrutiny, it actually matters on an evidential level how well the policy works. To meet the evidential requirements for a compelling interest test, courts have ruled that a generalized statement of interests unsupported by specific and reliable evidence is not sufficient. Additionally, unlike the more permissive rational basis scrutiny, the compelling interest test bars defending authorities from coming up with after-the-fact explanations to do some borderline cheating by retconning their rationale. As the U.S. Supreme Court has pointed out, for purposes of strict scrutiny, the justification must be genuine, not hypothesized or invented post hoc in response to litigation, and it must not rely on overbroad generalizations. Mask mandates fail all of these criteria when closely interrogated. Mask mandates were defended on the grounds that the state has a compelling interest in slowing the spread of COVID, but the real, unstated, far less legitimate interest was in creating artificial solidarity and uniformity, showing that everyone was doing their part while displaying a not-so-subtle reminder of coercion and abnormality. Even under strict scrutiny, however, the scientific evidence regarding masks has relevance only insofar as it affects governmental defendants' ability to satisfy part of their total burden of proof. Those lawsuits that successfully challenged compulsory masking took pains to make clear to the courts that the issue being litigated was not about whether or not masks worked. Even if the balance of empirical evidence could be shown to favor a challenged mask mandate, or if the mandate could somehow be shown to have some effect in achieving the stated goal, this still may not be enough to survive strict scrutiny and justify burdening individual liberties, because strict scrutiny also requires that the policy be narrowly tailored and use the least restrictive means of furthering the compelling interest. A policy is not narrowly tailored if it is excessive or overbroad, and the Supreme Court has consistently affirmed that the least restrictive means standard is exceptionally demanding. As the U.S. Supreme Court said in NAACP v. Alabama, a governmental purpose to control or prevent activities constitutionally subject to state regulation may not be achieved by means which sweep unnecessarily broadly and thereby invade the area of protected freedoms. This also applies to a governmental purpose to control or prevent the spread of infectious disease. It is easy to see why strict scrutiny is lethal to COVID crisis mandates, including compulsory masking. Quarantining individuals who are sick and symptomatic is narrowly tailored and historically effective. Universal masking, on the other hand, was always grossly overbroad by definition. Forcing everyone to wear a medical device regardless of their individual medical history, immune status, and other risk factors is self-evidently neither narrowly tailored nor the least restrictive means available. At any given time during the COVID crisis, the vast majority of the population being forcibly masked was either uninfected or recovered, and either way was incapable of transmitting SARS-CoV-2. According to the CDC's own numbers, this non-infectious, overwhelming majority was virtually always over 98% of the population and never dropped below 94%, with the largest recorded relative peak in COVID infections coming during January 2022, by which point a large segment of the population being forced to wear masks had already acquired natural immunity. Historically, the government has a compelling interest in preventing crime, but anti-mask laws designed to further the government's compelling interest in crime prevention were unconstitutionally overbroad if they also banned expressive mask wearing. As a 1992 analysis by attorney Stephen J. Simoni pointed out in the Fordham Law Review, anti-mask laws that explicitly permit only certain expressive mask wearing unnecessarily ban First Amendment exercise, as individuals engaged in political expression do not generally pose the danger that individuals intending to commit crime do. Therefore, such laws fail the narrowly tailored requirement. Likewise, mask mandates also unnecessarily ban First Amendment exercise because individuals engaged in political expression overwhelmingly do not pose the danger to public health that infected individuals do. Under these circumstances, mask mandates fail the narrow tailoring requirement as badly as mask bans. Analogously, even though the state has a compelling interest in preventing crime, speculative, even rational fears about masked individuals' higher potential to commit crimes have often been insufficient to overcome First Amendment protections for expressive mask wearing. The same reasoning applies with equal force to speculative fears about unmasked individuals' potential to spread disease. When it comes to face coverings, mandates and bans are both wrong. True liberty resides in the middle ground, where people decide on an individual basis whether to put on or take off a face covering. Grounds or excuses for dismissal. Standing. In many cases, just getting to any kind of scrutiny was an achievement in its own right. During the COVID crisis, many judges saw challenges to compulsory masking as inherently offensive, dangerous, or both, and found multiple technical ways to simply dismiss them outright without really investigating the actual merits. Judges possess a host of subtle discretionary tools that can nudge a case towards a particular outcome. They can decide what evidence to admit or not admit. They can rule the plaintiff does not have standing to sue in the first place. They can admit the plaintiff has standing to sue, but declare the case unripe for adjudication. And they can defer to bodies like the CDC without meaningful analysis. In addition, many of the litigants challenging compulsory masking were pro se, meaning they filed suit on their own without attorney assistance, usually for financial reasons, and made errors that gave judges easy outs, such as bringing a challenge under federal law to a state court, or a state law challenge to a federal court. Whether a mask mandate had to be challenged under federal law or state and local law depended on whether a federal or a state authority was imposing the mandate. The requirement that a plaintiff have « standing» was a common tool used to cull lawsuits challenging mask mandates. In order to have standing to sue on masks, plaintiffs needed to allege an injury to one or more of their own personal legally protected interests. That injury had to be fairly traceable to the conduct of the defendant they were suing, and it had to be something a favorable judicial decision could redress. The requirement for standing, as well as the fine distinction between who was issuing the mandate being challenged and who was enforcing it, led to multiple lawsuits against mask mandates being dismissed on what were essentially pedantic technicalities that refused to acknowledge the full weight and threats, both implicit and explicit, behind many of the mask mandates. For example, in Minnesota, Judge Patrick Schiltz ruled that, because plaintiffs have not clearly alleged that they intend to enter public indoor spaces without face coverings, they likely lack standing to pursue their challenges to the validity of the mask mandate under the Elections Clause and First Amendment. In Massachusetts, the generalized threat of a fine for noncompliance was not deemed sufficient injury to establish standing. A plaintiff who fell under Massachusetts Governor Baker's mask mandate had her case dismissed because she failed to allege that she has personally been forced to wear a mask or to require her employees to wear a mask on any occasion. She thus has not established that she suffered any concrete and particularized injury with respect to the mask requirement. The dismissal of a Louisiana plaintiff's challenge to mask mandates focused on the idea that the requested redress was too speculative to confer standing because an injunction against the governor's mask mandate would not necessarily prevent private actors from imposing their own mask mandates in the vein of no shirt, no shoes, no service. In Pennsylvania, a challenge to Governor Wolf's mask mandate foundered on a combination of all three of these excuses. Plaintiffs have neither sufficiently established an intention to engage in the prescribed conduct, nor have they persuaded us that they face a credible threat of future enforcement by the defendants, ruled Judge John Jones III in Parker v. Wolf. An injunction here will simply not alleviate the injuries plaintiffs claim to suffer when they wear a mask. Those injuries will almost certainly persist even in the absence of state-level enforcement of the mask mandate. While businesses who no longer face a threat of state enforcement may, subject to local orders, allow plaintiffs to enter their establishment without a mask, it is too speculative to conclude this would actually happen. In plain English, the mandate's enforcement by the authorities in Governor Wolf's administration was not credible, but the threat of enforcement by other local authorities was so credible that any injunctive relief against the governor's mask mandate would be too inadequate or speculative to justify. Who knew that the standard for judging threat credibility could be so flexible? These categorical all-or-nothing applications of standing doctrine also ignored the fact that standing does not require perfect relief. As long as the requested redress will at least lessen the injury, standing can be established. Just because an injury cannot be redressed entirely is no excuse for refusing to acknowledge that an injury has occurred in the first place. The plaintiffs in Parker v. Wolf vigorously appealed, but delay was another common judicial avoidance tactic. By the time the appellate court issued its ruling, Governor Wolf's mask mandate had been rescinded, and the Court of Appeals simply dismissed the case as being moot, on the grounds that the plaintiffs had not shown a reasonable expectation that the statewide mask mandate was likely to be reinstated. Never mind the fact that Governor Wolf's administration continued to claim the authority to impose a mask mandate again at any time, and never mind the experiences of 2020 and 2021, the threat of future mask mandates simply wasn't credible enough. Constitutional claims against masks. So, which of the many constitutional and procedural claims against compulsory masking got to rational basis scrutiny? How were some able to reach strict scrutiny, and what were the results? Mask mandates implicate a wide range of constitutional and procedural rights under federal, state, and local law. Mask mandates violate all three of the absolute rights of individuals listed by William Blackstone that we examined in Part 4, personal security, personal liberty, and personal property. They violate personal security and personal property by interrupting people's enjoyment of their most fundamental and intimate property, their own bodies. Mask mandates violated personal liberty when people's movements in public and access to places of public accommodation were conditioned on restraining their face behind a piece of snug cloth or other material. Depending on the individuals and mandates involved, compulsory masking can involve the First Amendment, the 14th Amendment, the 9th and 10th Amendments, and potentially even the 4th and 5th Amendments. This does not include any procedural statutes that compulsory masking potentially violates. Some of these rights have already been upheld against masks in several critical cases. Others, courts have so far failed or refused to recognize, either willfully or because the claims involved were inadequately formulated and pled. A few claims against masks have not yet really been tested, and some were simply never ruled on because courts used other claims brought by the plaintiffs to strike down the mask mandates being challenged. Many constitutional claims against masks have never been fully developed and articulated simply because the few times they were alleged or pleaded, the pleadings were based on a layman understanding of the terms involved, or composed in a way that made professional jurists discount them almost immediately. We will look at these in turn, starting with the most important, the First Amendment. The First Amendment. Free speech. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. United States Constitution, Amendment 1. Background and intermediate O'Brien scrutiny. Freedom of discussion, if it would fulfill its historic function in this nation, must embrace all issues about which information is needed or appropriate to enable the members of society to cope with the exigencies of their period. The health of the present generation and of those as yet unborn may depend on these matters. United States Supreme Court, Thornhill v. Alabama, 1940. The most intuitive and common constitutional challenges to compulsory masking were made under the First Amendment and the 14th Amendments on grounds of free speech, free exercise, privacy, and due process. As the United States Supreme Court has repeatedly recognized, conduct and speech are not mutually exclusive. Conduct can be a form of speech, though this does not mean that any and all conduct is expressive enough to count as speech protected under the First Amendment. The U.S. Supreme Court put it like this: it is possible to find some kernel of expression in almost every activity a person undertakes, for example, walking down the street or meeting one's friends at a shopping mall, but such a kernel is not sufficient to bring the activity within the protection of the First Amendment. According to the U.S. Supreme Court, an act of expressive conduct falls within the scope of the First Amendment if an intent to convey a particularized message was present, and, in the surrounding circumstances, the likelihood was great that the message would be understood by those who viewed it. Symbolic speech and expressive conduct protected under the First Amendment include both actions and non-actions. Symbolic speech jurisprudence prior to 2020 has gradually refined the legal understanding of when conduct becomes speech that brings the First Amendment into play. Cases involving expressive conduct from the state level all the way up to the U.S. Supreme Court involve a wide range of specific precedents, including, but not limited to, picketing and demonstrating, parading, dancing, including erotic dancing, conducting a sit-in protest, flying a particular flag, saluting or refusing to salute a flag, altering or defacing a flag, burning a flag, contributing money to your own political campaign, wearing particular articles of clothing such as armbands or freedom buttons, sharing food in the park, baking a customized wedding cake, building an expressive website, and, yes, wearing or not wearing masks. These historical court rulings in the context of symbolic speech are crucial for understanding why masking and non-masking indisputably involve fundamental First Amendment freedoms. In a particularly important sequence of cases beginning in the 1960s, the Supreme Court ruled that defacing or burning an American flag constituted symbolic speech protected by the First Amendment, whereas publicly burning a draft card did not. What was the difference? 3 things. First, burning a flag is more inherently expressive than burning a draft card. Flags are inherently symbolic objects. That is their purpose, whereas this is not true of draft cards. Second, any power to make laws against desecration of a venerated object, like the American flag, are nowhere near as directly and closely related to explicitly granted constitutional powers as are draft card laws passed pursuant to Congress's constitutional power to raise and support armies. Finally, even though the flag as readily signifies this nation as does the combination of letters found in America, the state's interest in preserving the flag as a symbol of national unity or a form of national intellectual property is nowhere near as strong as the state's compelling interest in national defense or an individual's First Amendment liberty interests. This sequence of cases was important because it gave rise to what is known as the O'Brien test, named after the 1968 United States v. O'Brien Supreme Court decision involving draft card burning described above. O'Brien's scrutiny is a type of intermediate scrutiny that falls between rational basis and strict scrutiny, and one which has been applied to masks both before and during the COVID crisis. Under the O'Brien standard, a governmental regulation burdening free speech must pass 4 criteria. 1. It must be within the constitutional power of the government. 2. It must be that the regulation furthers an important or substantial governmental interest, which is 3. Unrelated to the suppression of free expression, and 4. The restriction on alleged First Amendment freedoms is no greater than is essential. If a law or mandate which burdens speech fails this test, then it is unconstitutional. The more lenient O'Brien scrutiny may be used when speech or non-speech elements are combined in the same course of conduct, and the restrictions being challenged are an incidental side effect of measures pursuant to an important governmental interest which is unrelated to the suppression of expression. Restrictions on pure speech require strict scrutiny, but restrictions on symbolic speech or expressive conduct, which would fail strict scrutiny, can often sail through under O'Brien scrutiny. Judges typically apply O'Brien scrutiny when, in their opinion, the symbolic speech in question is not so inherently expressive that the presence of speech in the conduct is indisputable. This wiggle room, combined with motivated reasoning, allowed mask mandates to evade strict scrutiny and survive First Amendment challenges that should have been fatal. In the hands of several judges during the COVID crisis, O'Brien scrutiny was hardly better than rational basis scrutiny. Yet, when applied impartially and objectively, O'Brien scrutiny has historically vindicated First Amendment rights in a number of important cases. Unlike destroying a draft card, the inevitable effect of wearing masks is potent communication. But when reading COVID crisis cases challenging compulsory masking under the First Amendment, one gets the impression that judges would have preferred to catch COVID themselves rather than acknowledge the speech inherent in mask wearing and non-mask wearing. Based on such cases, a rather one-sided September 2021 summary in the National Law Review concluded, "Courts have roundly rejected claims that masks unlawfully regulate speech or expression. Mask mandates regulate conduct, not speech, and therefore do not implicate the free speech clause at all." Some judges, perhaps not 100% convinced free speech claims against masking were truly without merit, expended a great deal of effort to dismiss First Amendment challenges on other grounds such as standing. Judge John Jones III in the Pennsylvania Parker v. Wolf case described earlier may be one of these. The point of Judge Jones' ruling in that case was that even assuming masks implicate free speech, the plaintiffs still failed to bring a justiciable claim because they supposedly could not meet the particularity and redressability requirements needed for standing. But as a prelude to dismissal, Judge Jones rightly conceded that, assuming for the sake of argument, a mask does indeed constitute compelled speech, then we initially find that plaintiffs have stated a concrete de facto injury, because, while the harm associated with compelled speech might be intangible, the Supreme Court has held that such a First Amendment injury may nevertheless be concrete. Even when a court or governmental defendant would concede that masks do indeed involve symbolic speech, they would still argue that mask mandates were justified under O'Brien scrutiny because the purpose of the mask mandates was to further a compelling governmental interest unrelated to speech, and the incidental restrictions placed on First Amendment freedoms by mask mandates were no greater than is essential, or no greater than necessary. A good example of this comes from a March 2022 ruling. A group of Republican congressmen, led by Kentucky Representative Thomas Massie, sued House Speaker Nancy Pelosi over the House of Representatives' internal mask mandate. Both parties acknowledged the symbolic speech inherent in masking or non-masking, but District Judge Reggie Walton dismissed the suit anyway, using the O'Brien criteria. Judge Walton asserted that the mask mandate, 1. is within the constitutional power of the government, 2. the governmental interest is unrelated to the suppression of free expression, and 3. the incidental restriction on alleged First Amendment freedoms is no greater than is essential. As we shall see, Judge Walton and every other judge who similarly dismissed First Amendment challenges to compulsory masking got it wrong. Clothing can be speech. As we saw in our examination of the psychology behind masking, mask wearing is such a powerful expressive act that not only is it symbolic speech, but it is an unusually potent and persuasive form of symbolic speech. Even though wearing or not wearing a mask lacks the precision of spoken or written words, it still conveys a particularized message, with a great likelihood that the message will be understood by those who view it. This was especially true in the context of the COVID crisis. The sheer volume of lawsuits filed challenging masks on free speech grounds is, on its own, a powerful attestation to widespread intuitive awareness of the fact that mask wearing or non-wearing is, indeed, a form of speech. Both supporters and detractors of compulsory masking recognized this, and many experts and authorities were remarkably frank about the non-medical ulterior communicative motive behind mask mandates. Some articles of clothing, like patches on uniforms, are purely symbolic, and the utility of other articles of clothing is often vastly outweighed by their symbolism. In ancient times, wearing rough sackcloth was a sign of distress, grief, penitence, or humility. Political party members show their affiliation by wearing iconic hats, pins, and shirts. Judges and priests wear special garments indicating their legal and religious roles and status, as they have throughout human history. Mennonites and Amish have distinctive forms of dress that make them immediately identifiable. Quakers have historically refused to wear certain common symbols based on what such things communicate. Articles of clothing worn on or about the head and face are especially prone to symbolic communication, from the metal collars that designated enslaved thralls to Roman use of the pileus felt cap for signifying manumission and liberty. Traditional veils, a bishop's mitre, and the artistic full-face costumes and armor that appear in cultures everywhere from ancient Greece to feudal Japan all attest to the special communicative significance of the head and face. Historically, some feminists used public unveiling as a symbolic declaration of emancipation, as when Egyptian Feminist Union founder Huda Sharawi caused a commotion in 1923 Cairo by removing her veil. Some sources report that she also threw it into the Mediterranean. Conversely, in Oman, where female slaves were not allowed to wear veils, some female ex-slaves put on veils as a symbolic statement of their newly improved legal status after slavery was legally abolished in 1970. Debates over burqa wearing highlight the inescapable symbolic speech and fundamental rights involved in face coverings. French President Nicolas Sarkozy called burqas a sign of subservience, and German feminist Alice Schwarzer argued that such veiling is dehumanizing. France banned face coverings in 2011, threatening stiff fines for violators, and proclaiming, "The Republic lives with its face uncovered in all public places, public roads, public transport, shops and shopping centers, schools, post office, hospitals." The French Republic lived with its face uncovered for all of 9 years until it mandated face coverings in 2020, without bothering to repeal the earlier ban. This contradiction reveals the real driving mentality underlying both measures, a pathological desire to control sources of collective anxiety by imposing artificial uniformity. Masks are directly expressive, and intuitive recognition of this fact prompted people to wear masks in an exaggerated or hyperbolic manner as a means of speech when engaging in protest long before COVID. Protesters against human trafficking wore cloth masks on a 2017 march in London to represent the silence of victims, and pro-choice protesters donned medical masks to convey the idea that they were being censored following the U.S. Supreme Court's 1991 Rust v. Sullivan decision. Medical masks are inherently symbolic the same way that white lab coats are inherently symbolic, but to an even greater degree. In the context of the COVID crisis, masks were more akin to a military uniform or an emblem of ideological allegiance like the tricolor cockade of the French Revolution. Less than a year after the United States had finished ratifying the Bill of Rights in December 1791 to protect against all such forms of ideological tyranny, the French Revolutionary Legislative Assembly mandated that all men residing or traveling in France wear the national form of this decorative disc in July 1792. In fact, the French Legislative Assembly went even further and declared that the wearing of any cockade other than that with the 3 national colors is a sign of rebellion. During the COVID crisis, refusal to wear a mask was likewise widely interpreted and treated as a sign of rebellion. Based on how they dismissed challenges to compulsory masking, no doubt most of the COVID crisis judges would have called such bald-faced tyranny by the French Legislative Assembly a trivial imposition on an individual's freedom. But like being forced to wear a French Revolutionary cockade or any other ideological badge, there was nothing trivial about being forced to wear a mask. The fact that virtually everyone was forced to do it just made the violation of fundamental liberties that much worse for being so widespread. The presence or absence of a mask indisputably sends a message, especially when the act is performed by a minority in the context of a declared emergency mask mandate. Even if masks were successfully shown to have a practical function in controlling viruses, that would do nothing to diminish the compelled speech inherent in COVID crisis masking and non-masking. As we shall see, masks are so close to what the Supreme Court has called pure speech that they involve direct, primary First Amendment rights. The surprise should not be that so many people perceived the compelled symbolic speech in compulsory masking, but that anyone managed to claim masks were not symbolic speech while keeping a straight face. Steel-manning the arguments for dismissing First Amendment challenges to masking. Despite the extensive historical and legal precedents pointing to masks as a form of speech, when compulsory masking was repeatedly challenged under the Free Speech Clause of the First Amendment, courts stubbornly refused to acknowledge the reality that masks are symbolic speech. Mask mandates regulate conduct, not speech, and do not implicate the Free Speech Clause at all. They require specific conduct, wearing a mask in public. That conduct does not include a significant expressive element, insisted Hawaii Judge Susan Mulway, dismissing a mask lawsuit in mid-2021. Individuals can still engage in expressive activity, they just have to wear masks while they do. Those challenges to compulsory masking that were not dismissed on technical grounds were shut down using a broadly two-pronged constitutional and pragmatic approach. Sometimes a judge dismissing on technical grounds would employ this formula anyway for good measure. On the constitutional side of the equation, this approach would start by playing up COVID-19 as a national emergency of the highest order, then entirely denying or heavily downplaying the First Amendment implications of compulsory masking. After all, the First Amendment can't apply if masks are not speech. Even if masking and non-masking are speech under the First Amendment, with this reasoning, mask mandates can only warrant rational basis scrutiny, or at the very most, intermediate O'Brien scrutiny, both of which they easily survive. On the pragmatic side of the equation, the invariable starting point finding would be that masks work well enough to qualify as basic, essential, common-sense safety measures. After all, the CDC said so. The clincher would be that masks have no significant side effects and leave ample alternative channels for communication of any objections to mask wearing. Plaintiffs challenging mask mandates were somehow never quite able to carry their burden of proof in these courts. In Florida, Magistrate Judge Jared Strauss recommended dismissal of a free speech claim against mask wearing because neither wearing or not wearing a mask is inherently expressive. In the context of COVID-19, wearing a mask does not evince an intent to send a message of subservience to authority, or any message at all. Thus, wearing a mask is not inherently expressive, such that the challenged mask mandates constitute compelled speech subject to First Amendment analysis. The act of refusing to wear a face covering does not carry a meaning that is overwhelmingly apparent such that it is protected speech, ruled Federal District Judge Robert Chambers in West Virginia. Here, although plaintiffs feel that refusing to wear a face covering expresses nonconformity with unconstitutional and un-American laws, that meaning is not overwhelmingly apparent. But, said Judge Chambers, even if refusing to wear a mask is protected speech, the mask mandate withstands intermediate scrutiny as a content-neutral time, place, and manner restriction. It is a trivial imposition on an individual's freedom outweighed by the reasonableness of such precautions during a pandemic. For support, Judge Chambers quoted from the Supreme Court's 2006 decision in Rumsfeld v. Forum for Academic and Institutional Rights. The fact that such explanatory speech is necessary is strong evidence that the conduct at issue here is not so inherently expressive that it warrants protection as symbolic speech. Judge Chambers' 2020 use of this quote was, itself, later directly cited to strike down another 2022 free speech challenge to compulsory masking at the appellate level in Washington state. Using almost identical reasoning, the Washington state court claimed the First Amendment was never really involved. The mask mandate does not implicate speech, therefore we do not address whether the mask mandate survives strict scrutiny or compels speech. The expression must be overwhelmingly apparent, and not simply a kernel of expression. The fact that explanatory speech is necessary is strong evidence that the conduct at issue is not so inherently expressive that it warrants protection as symbolic speech. The act of wearing or not wearing a mask is not expressive conduct, and thus does not invoke the protections of the First Amendment. According to the Washington Court of Appeals, possible alternative interpretations of masking and non-masking somehow prevented these gestures from rising to the level of protected speech. The choice to wear a mask is not expressive conduct because there are several non-political reasons why one may not be wearing a mask at any given moment. Failing to wear a face covering would likely be viewed as inadvertent or unintentional, and not as an expression of disagreement with the governor. While an individual may choose to wear or not wear a mask as a way to make a political statement, the subjective intent of the person engaging in the conduct is not determinative. In addition to the person's intent to communicate a message, that message must also be overwhelmingly apparent and understandable by the person viewing the message. Here, there is a host of reasons why a person may not be wearing a mask. Therefore, not wearing a mask is not overwhelmingly apparent as communicating a political message. When the appellant plaintiffs argued that if the judges could not affirm masks are speech, this finding of fact should be left up to a jury to determine, as provided for by the Seventh Amendment, the Washington Court disagreed and refused to permit a jury trial. Minnesota Federal District Judge Patrick Schiltz derisively described a First Amendment claim against compulsory masking as meritless and having no chance of success. Compulsory masking either does not implicate the First Amendment at all, or at most has an incidental and trivial impact on First Amendment freedoms. Minnesota Governor Tim Walz's mask mandate, he said, is clearly constitutional, whether analyzed under O'Brien or Jacobson. To merit First Amendment protection, explained Judge Schiltz, the conduct regulated by the challenged law must be inherently expressive. But, he said, wearing or not wearing a face covering is not inherently expressive. Why? Because an observer would have no idea why someone is not wearing a face covering. Absent explanation, the observer would not know whether the person is exempt, or simply forgot to bring a face covering, or is trying to convey a political message. That fact takes the conduct outside of the First Amendment protection. After all, Judge Schiltz went on, the incidental restriction on alleged First Amendment freedoms is no greater than is essential. He concluded, plaintiffs are free to express their opinions about the mask mandate in every conceivable way except by violating its provisions and putting at risk the lives and health of their fellow citizens. In short, plaintiffs have no chance of success on their claim that the mask mandate standing alone violates the First Amendment. The preferred default was to find that mask mandates either did not involve the First Amendment or were subject only to rational basis scrutiny which they easily passed. As Judge John Kastrenakis put it, this court finds that no constitutional right is infringed by the mask ordinance's mandate to wear a facial covering, and that the requirement to wear such a covering has a clear rational basis based on the protection of public health. However, when complaints specifically alleged an intent to convey a particularized message by not wearing a mask, or raised another constitutional argument that was harder to ignore, such as that the mask mandates were not, in fact, neutral and of general applicability, a few courts took it in hand to address intermediate O'Brien scrutiny. Even assuming that mask wearing is expressive conduct or symbolic speech, these courts would argue, freedom of speech is not absolute, and the government generally has a freer hand in restricting expressive conduct than it has in restricting the written or spoken word. Mask mandates can only be construed as a content-neutral time, place, and manner restriction that is subject to intermediate scrutiny, said Judge Robert Chambers. Judge Patrick Schiltz said that mask mandates easily pass muster under the four intermediate scrutiny O'Brien tests of 1. Being within the constitutional power of the government, 2. Furthering an important or substantial governmental interest, 3. Being unrelated to the suppression of speech, and 4. Being no greater than essential. Mask mandates generally breezed through the first three O'Brien criteria. As part of its general police powers, a state government has the constitutional authority to enact measures to protect the health and safety of its citizens. Thus, to most courts, there was no question that, assuming mask mandates do not unacceptably infringe any rights, they are within the constitutional power of the government. In that same vein, the substantial governmental interest supposedly furthered by mask mandates, that of controlling the spread of a highly contagious and potentially deadly disease in the name of public health, is unrelated to the suppression of free expression. In practice, any semi-plausible rationale for compulsory masking presented by a governmental defendant, no matter how pretextual it may be in reality, will satisfy the third O'Brien criteria of needing to be unrelated to the suppression of speech. As the Georgia Supreme Court put it in a 1990 case on masks, under settled principles of constitutional law, the court will not strike down an otherwise constitutional statute on the basis of an alleged illicit legislative motive. With so much benefit of the doubt, there was never a realistic chance that mask mandates would be found to target speech. Discussions of the first three O'Brien criteria in court rulings were usually framed by a formulaic recitation of the death toll from COVID, an assertion that there was no cure or effective treatment, a mention of transmission by droplets or aerosols, a citation to the CDC, and an appeal to scientific consensus. This framing set judges up to vault the biggest hurdle in intermediate O'Brien scrutiny, the requirement that universal compulsory masking be no greater than essential, in other words, narrowly tailored. In the hysteria-charged atmosphere of the early COVID crisis, judges were under great internal and external pressure to uphold mask mandates. Once things calmed down, they found themselves under pressure to appear consistent and to avoid admitting their own errors or calling out their colleagues' errors that were nearly as strong. This makes it less surprising, but still every bit as appalling, that courts during the COVID crisis repeatedly found any limitations on First Amendment freedoms from universal compulsory masking to be incidental, no greater than is essential, and outweighed by the strong governmental interests behind the policies. Judge Robert Chambers in West Virginia provided one of the best succinct summaries of the combined reasoning that got mask mandates past intermediate O'Brien scrutiny. Even if refusing to wear a mask is protected speech, the mask mandate withstands intermediate scrutiny as a content-neutral time, place, and manner restriction. Being required to wear a mask in conformity with the governor's order may be an inconvenience or annoyance, but it is a trivial imposition on an individual's freedom, outweighed by the reasonableness of such precautions during a pandemic. The mask mandate passes this test. 1. It is a justifiable exercise of the state's police power under the United States Constitution. 2. It furthers a compelling interest by slowing the spread of the coronavirus and saving lives. 3. That interest is unrelated to the alleged restrictions on plaintiff's speech. And 4. It imposes no greater restriction than is required because it is limited by age, activity, and place. In a separate opinion earlier in the same case, Judge Chambers also wrote, "The court also finds that the mask mandate is narrowly tailored. Although the statewide order is undeniably broad, it is no less narrowly tailored to its purpose. The order is geographically broad and indefinite, but so too is the virus. The order applies to all individuals regardless of their apparent health, but the evidence shows that asymptomatic individuals are nonetheless contagious." Another factor that courts repeatedly cited to show that universal masking was no greater than essential, and therefore not violative of fundamental human or constitutional rights, was that mask mandates left open ample alternative channels for any desired communications inhibited by compulsory masking. As federal judge Susan Mulway said in Hawaii, "People wearing masks can still speak. The mask mandates do not impose more than an incidental burden on speech. To the contrary, individuals can still engage in expressive activity. They just have to wear masks while they do." In his dismissal of Republican congressman's legal challenge to compulsory masking, Judge Reggie B. Walton said there were myriad means of communicating the congressman's message opposing masks, including wearing masks or other clothing containing the messages they wanted to convey, or making speeches from the House chamber or elsewhere on the subject. The real overriding reason mask mandates survived scrutiny was that COVID-19 was a public health crisis, the pandemic, a plague, an emergency. Individual liberties, no matter how inalienable, simply had to take a back seat, especially in light of Jacobson v. Massachusetts. A Florida court stated this attitude the most directly. The spread of infectious or contagious disease or other potential public calamity presents an exigent circumstance before which all private rights must immediately give way under the government's police power. In every decision, the assumption that masks work was omnipresent, an unquestionable finding of fact which no judge or jury of ignorant laypeople could be qualified or permitted to evaluate for themselves. After all, the CDC said so. Contrary to the plaintiff's assertion regarding the existence of recent scientific findings that the use of face coverings has no appreciable effect on slowing or halting the spread of COVID-19, the consensus within the scientific community is clear that masks, and in particular well-fitting protective masks, are effective in slowing the spread of the COVID-19 virus. Massey v. Pelosi, 2022. Face coverings and other social distancing restrictions are effective at slowing the spread of the virus. Stewart v. Justice, 2020. The West Virginia mask mandate serves to slow the spread of COVID-19 by requiring individuals to wear masks indoors. Stewart v. Justice, 2020. The evidence for the efficacy of wearing masks in preventing the spread of COVID-19 is indisputable and is in accordance with CDC guidelines. Stewart v. Justice, 2021. Plaintiffs do not deny the existence of COVID-19, or that it is a dangerous disease, or that it is easily spread, including by people who do not know that they are infected, or that face coverings slow its spread and thus save lives. Minnesota Voters Alliance v. Walz, 2020. For example, the CDC stated that face coverings are one of the most powerful weapons we have to slow and stop the spread of the virus, particularly when used universally within a community setting. Simmel v. Shaw, 2022. It has been proven that the wearing of masks can slow the transmission of the spread of the coronavirus. Delaney v. Baker, 2021. Additionally, requirements for face coverings also reduce the chance that respiratory droplets containing the virus will infect others. Antietam Battlefield KOA v. Hogan, 2020. COVID crisis rulings on masks and mask mandates present readers with one long slogan-infected litany after another. We do not have a constitutional or protected right to infect others, and one cannot plausibly claim that anyone has died as a result of having had to wear a mask. Wearing or not wearing a mask is conduct, ran the arguments. It cannot be speech protected under the First Amendment. There are multiple non-communicative alternative reasons to wear or not wear masks, so it is not inherently expressive, or it has only a kernel of expression. Explanatory speech is necessary, and so the meaning of masking and non-masking is not overwhelmingly apparent. Universal masking is a basic common-sense safety requirement, like seatbelts and safety helmets. Masks are a minor, trivial inconvenience. Any injury masks might cause is speculative. Masks do not inflict harm, especially any kind of irreparable harm. Opponents of masks failed to carry their burden of proof or show adequate threat of irreparable redressable harm to establish standing. A mask mandate in church did not constitute a redressable injury sufficient to establish standing against a governor's mask mandate because it was the archdiocese, not the governor, imposing the church's mask mandate. Mask mandates in public locations might constitute a redressable injury sufficient to establish standing, but the mask mandate being challenged survives every type of applicable scrutiny. On and on it went. Under no circumstances would COVID crisis jurisprudence subject masks to strict scrutiny on the basis of the First Amendment Free Speech Clause. According to these courts, under the Free Speech Clause of the First Amendment, universal masking warranted either no scrutiny, rational basis scrutiny, or, at most, remarkably deferential intermediate scrutiny. Such was the majority consensus. But the majority consensus was in error, and every court that dismissed or ruled against a free speech challenge to compulsory masking got the law in this area badly wrong. The COVID crisis is far from the first time in American history that courts have stubbornly refused to uphold citizens' rights until the political atmosphere made it safe to do so. Rulings that dismissed challenges to compulsory masking reasoned in circles, used brute force denial, or often completely ignored the central allegations in the First Amendment claims they dismissed. Virtually every premise in such decisions remains erroneous. They presume that masks work. They nonsensically presume that masking everyone, including the healthy, the least vulnerable, and the already recovered, is both reasonable and no greater than is essential. They deny the incontrovertible communicative effect that mask wearing or non-wearing has, and they ultimately forced the plaintiffs to symbolically affirm masking even while trying to verbally argue against it. Judges who said plaintiffs had no chance of success challenging masks on a free speech basis were correct, at least insofar as they were describing their own courts. What they were not correct about was the actual law and legal precedents involved. Masks are speech. Mask speech prior to COVID. The fact of the matter is that going into 2020, there was already extensive case law precedent holding that mask wearing can be inherently expressive. Mask speech cases have involved everything from cloth masks and dust masks to V for Vendetta and KKK masks. Masks have been used to communicate everything from threats and intimidation to protesting against politicians, banks, and financial institutions. Even if mask wearing or non-wearing were not inherently expressive when judged in isolation and out of context, the critical context of the COVID crisis made it expressive. Eating and drinking or walking from point A to point B are not inherently expressive either,
but case law precedents decisively show that both of these can be symbolic speech protected under the First Amendment in the right surrounding circumstances. In their 1890 joint essay, The Right to Privacy, U.S. Supreme Court Justices Samuel Warren and Louis Brandeis explained how multiple earlier Supreme Court rulings assumed and protected both a broad individual right to privacy and to the control of one's speech, regardless of the form that speech may take. The common law secures to each individual the right of determining, ordinarily, to what extent his thoughts, sentiments, and emotions shall be communicated to others. Under our system of government, he can never be compelled to express them, except when upon the witness stand. The existence of this right does not depend upon the particular method of expression adopted. It is immaterial whether it be by word or by signs, in painting, by sculpture, or in music. Deliberately hiding or showing one's face to others has been understood to communicate a message for millennia. This form of communication is as old as the Bible. See the appendix for a few dozen examples. In the United States, this was so widely understood that Stephen J. Simone's review of court cases and laws involving mask wearing through 1992, published in the Fordham Law Review, concluded, "Virtually all existing anti-mask laws violate the United States Constitution, because mask wearing can itself serve an expressive function, as well as enable speakers who need anonymity to express their beliefs publicly. Anti-mask laws both directly violate and inhibit the First Amendment's free speech and free assembly guarantees. Furthermore, as many instances of mask wearing are completely innocent, anti-mask laws likely violate the 14th Amendment's substantive due process guarantee." The review noted, "Demonstrators often use masks only to express ideas and not to conceal their identities." The review included a proposed model anti-mask law with an explicit umbrella exemption for expressive mask-wearing speech protected by the First Amendment, including expressive mask-wearing when the wearers do not desire their resulting anonymity. There would be no point including a provision for mask speech if, as many courts asserted during the COVID crisis, mask wearing is not or cannot be speech protected by the First Amendment. Another 2012 mask law analysis, published in the Hastings International and Comparative Law Review, pointed out that anti-mask laws failed the First Amendment neutrality requirement for similar reasons. The enumerated lists of exceptions in general anti-mask laws belie such content neutrality. For example, the inclusion of exemptions for masquerades, but not for political protests, implicitly discriminates between entertaining and persuasive content. The truth is that mask wearing can be, and often is, speech, and if wearing a mask can be speech, refusing to wear a mask can also be speech, especially when the wearers and non-wearers are in the minority or acting contrary to a mandate. The more charged the surrounding circumstances become, the more likely masking and non-masking are to be a form of speech. In the context of the COVID crisis, because universal mask mandates effectively restricted expressive unmasking based on the content, whether political, medical, and/or religious, they did not serve the state interest in reducing the spread of COVID-19 in the least restrictive manner needed to pass scrutiny under the First Amendment. Just 10 years after the U.S. Supreme Court's 1968 expressive conduct decision in United States v. O'Brien, the O'Brien standard was applied directly to masks in the 1978 Texas case of Arian v. McKay. Texas Tech University granted a permit to students to hold a protest march with the proviso that they were not allowed to wear masks while doing so. Students who wanted to wear masks as a means of preserving their anonymity and as a form of symbolic speech sued for violation of their First Amendment rights. In his ruling, Judge Patrick Higginbotham recognized two distinct functions which the masks serve. The first is non-communicative. The second is communicative. The masks have become symbols of protests. Serious First Amendment questions arise, however, when there is such a nexus between anonymity and speech that a bar on the first is tantamount to a prohibition on the second. Judge Higginbotham's insight did not suddenly become untrue in the context of SARS-CoV-2 simply because public health was substituted for anonymity. If anything, even more serious First Amendment questions arise when there is such a nexus between public health and speech that a mandate imposed ostensibly to serve public health becomes a content-based bar on speech or an outright form of compelled speech. Judge Higginbotham also rightly pointed out in his ruling that the burden of proof was not on the plaintiff's students whose rights were being violated, but on the defendant university authorities to prove that the regulation on masks did not violate the First Amendment. During the COVID crisis, many courts wrongly placed this burden of proof on the plaintiffs who sought to challenge mask regulations. As in the COVID crisis, the potential harm the university authorities sought to avoid in 1978 was related to masks' non-communicative functions, and the O'Brien standard required the university authorities to demonstrate a substantial causal relationship between the restriction and the interest the restriction is supposed to further. In other words, under O'Brien scrutiny, evidence makes a difference. It matters how well masks work. Texas Tech University lost in court. It was not even able to get to the final no greater than essential part of the O'Brien test because it could not show that its rationale for forbidding masks was based on anything other than speculation. In upholding the students' First Amendment rights, Judge Higginbotham quoted another 1969 Supreme Court decision on symbolic speech, Tinker v. Des Moines Independent Community School District. In our system, undifferentiated fear or apprehension of disturbance is not enough to overcome the right to freedom of expression. Yet, time and again, during the COVID crisis, courts allowed studies and institutional pronouncements, which were no better than elaborate speculation, to satisfy this criterion despite the mountain of contrary evidence. The symbolic speech inherent in masks came up in court again in 1994, when an Illinois man, Timothy Ryan Jr., was concerned about possible airborne Legionnaire's disease in the ventilation system of a courthouse. Ryan insisted on wearing a mask into the courthouse, was briefly arrested by a sheriff's deputy for refusing to remove it, and promptly sued, charging violations of the First and Fourth Amendments. The Seventh Circuit Appellate Court, which reviewed this case and issued its final ruling in 1995, was headed by Judge Richard Posner, the most cited legal scholar in the United States during the 20th century. The panel's unanimous ruling held that the rule against mask wearing in the courthouse, which led to Ryan's arrest, was reasonable and constitutional because of what mask wearing communicates. The panel took it for granted that mask wearing is communicative and that a mask can be a symbol. The wearing of a mask inside a courthouse implies intimidation. It would be the height of irresponsibility to allow masked people into courthouses. Even if the wearer did not verbally explain why he was wearing a mask, Judge Posner said, most people would assume that he had a respiratory disease, or allergies, or an impaired immune system, or some other condition. One assumes when one sees such people that they have a problem peculiar to themselves, that they are not in normal health. The court also did not dispute that a mask wearer could very conceivably cause a panic among the unmasked if he verbally told them that the air was not fit to breathe unless one was wearing a protective mask. During the COVID crisis, many people strenuously and very reasonably objected to being forced to broadcast propositions like these at everyone who saw them, and Judge Posner's hypothetical was proven correct. Mask wearing accompanied by words that the air was not fit to breathe unless one was wearing a protective mask did cause widespread panic, more contagious than any virus. Ryan's lawsuit defending his mask wearing failed in part for the same reason that some of the COVID crisis lawsuits against masks did. He failed to allege that his primary purpose in wearing a mask was to engage in symbolic speech. Ryan did not say he was wearing it to protest the poor quality of the air in the courthouse. He said he was wearing it to save his throat and lungs from the bad air. The mask was not being used as a symbol. It was being used for its original purpose as a medical appliance. Ryan was not allowed to invoke the First Amendment after the fact because his own stated primary purpose in wearing a mask was not communicative. At the same time, Judge Posner and the rest of the panel held that the rule against wearing masks under which Ryan was arrested was constitutionally valid because the menacing messages sent by wearing a mask interfered with security and decorum in the courthouse, in which rational reflection and disinterested judgment will not be disrupted by intimations of violence or by the subtler hints of coercion. Subtle hints of coercion might be involved in mask wearing? You don't say. I, for one, am shocked. Judge Posner's ruling was not charting entirely new territory. In 1990, a case involving intentional symbolic speech using a KKK mask went up to the Georgia Supreme Court in State v. Miller. It was simply taken without controversy for purposes of analysis that wearing a mask was conduct sufficiently imbued with elements of communication to implicate the First Amendment. In that case, the Supreme Court of Georgia held that Georgia's anti-mask statute was constitutional because the implied threats and intimidation associated with KKK mask wearing had helped to create a climate of fear that prevented Georgia citizens from exercising their civil rights. In order to uphold Georgia's anti-mask law, however, the Georgia court had to read an unwritten degree of specificity into the statute. The court held that a conviction under the anti-mask statute required an intent or reasonable expectation on the part of the mask wearer that their mask would provoke apprehension of intimidation, threats, or impending violence. This narrowing judicial interpretation was needed to ensure that, to the extent that the statute does proscribe the communicative aspect of mask-wearing conduct, its restriction is limited to threats and intimidation, which is not protected expression under the First Amendment. In other words, Georgia's anti-mask law only survived a First Amendment constitutional challenge because the Georgia Supreme Court made it narrowly tailored enough that it would be absurd to interpret the statute to prevent non-threatening political mask wearing. In Florida, a similar anti-mask act was struck down as unconstitutional before it even went into effect. In the State v. Miller decision, both the Georgia Supreme Court majority and the dissent found it uncontroversial that wearing a mask included symbolic speech. The majority simply held that the speech communicated by wearing a mask did not fall under First Amendment protection because, as the dissenting justice complained, it was irrebuttably presumed to be symbolic speech that gives rise to the apprehension of intimidation, threats, or impending violence. The dissenting justice also highlighted the problems of consistency in upholding a ban on symbolic speech using Klan masks when symbolic speech through wearing Nazi uniforms had already been upheld by the United States Supreme Court in a 1978 ruling. By 2018, at least in Georgia, the only real question remaining was whether police officers could escape civil liability for wrongfully arresting mask wearers who refused to remove their masks but did not intend to threaten or intimidate. This was decided in the 2018 case Gates v. Kokar, when a man sued under the First Amendment after being improperly arrested for wearing a V for Vendetta mask during a protest. To reach its verdict, the Georgia Supreme Court referred back to its previous cases from the 1990s. While the majority held that the arresting police officers had enough arguable probable cause to escape civil liability, both the majority and the dissent took it as a settled fact that wearing a mask was a form of speech. The dissenting justice put this most clearly. There can be no doubt that the order to remove the masks was directed at what would be constitutionally protected expression. The dissent reminded the majority that the Miller Court acknowledged this right in finding that engaging in non-threatening political mask wearing was clearly protected conduct. Whether the reader is more inclined to side with the majority ruling or the dissent in these Georgia cases, the most important takeaway is that while the specific nature and content of the speech inherent in masking was disputed, nobody disputed that wearing a mask was speech, which implicated the First Amendment. In all these cases, even the acknowledged compelling state interest in preventing crime and preserving the public peace did not allow rational basis dismissal of free speech challenges where masks were concerned. This case law history completely forecloses the legitimacy of trite assertions by COVID crisis courts that compulsory masking does not implicate the First Amendment. Fights over COVID masks did not break out because people were confused about whether or not masking or non-masking sent a message. Fights over COVID masks did not break out because people were confused about whether or not masking or non-masking sent a message. Fights over masks broke out because people got the messages and treated them like fighting words. The presence or absence of a mask cannot both be provocative enough to repeatedly serve as potential fighting words and fail to qualify as expressive conduct protected under the First Amendment. Mask proponents cannot have this argument both ways. Court rulings during the COVID crisis, which found that masking does not constitute compelled speech, flew in the face of copious scientific literature, case law, strong pronouncements from both sides of the political aisle, and universal experience. Mask wearing is symbolic speech, specifically intimidation, violence, and implied threats. Whether the actual or implied threat is of violence communicated by a Klan mask, of protest communicated by a V for Vendetta mask, or of disease communicated by a medical mask, it is indisputable that mask wearing can and does communicate actual or implied threats. The only question is how believable viewers find those threats to be, and how legally actionable they are. The United States Supreme Court has already held that First Amendment protections for speech extend even to the extreme of displaying and parading in actual Nazi uniforms and armbands. Yet Klan masks and protest masks communicate such plain, palpable threats of violence and intimidation that even the First Amendment recoils or permits arguable probable cause for arrests. This being the case, then regardless of whatever non-communicative function masks might ostensibly serve, forcing anyone to use their body as a billboard for the plain, palpable threats of infection and illness communicated by medical masks must, at the very least, warrant not just strict scrutiny, but the strictest scrutiny. Moreover, as in the 2021 case of Forbes v. County of San Diego, when compulsory masking was being challenged under grounds other than free speech, court filings defending mask use outright admitted the communicative effect of masking and cited this as a reason to mandate masks. In issuing the mask rules, the state explained that the use of face coverings by everyone can also reinforce physical distancing by signaling the need to remain apart. Getting around the precedents. How did COVID crisis courts purport to dispatch all of these precedents? Mostly, they tried to do so by brute force denial. They also subtly equivocated and misapplied two descriptors from precedent cases, inherently expressive and overwhelmingly apparent. These two descriptors appear over and over again in COVID crisis court rulings upholding mask mandates. According to judges upholding mask mandates, masking and non-masking must be inherently expressive with an overwhelmingly apparent meaning before the First Amendment can apply. The phrase inherently expressive comes from the 2006 Supreme Court case of Rumsfeld v. Forum for Academic and Institutional Rights, Incorporated. In this case, the Supreme Court ruled that denying military recruiters the same access provided to recruiters from other organizations was not expressive conduct protected under the First Amendment. Law schools discriminating against military recruiters argued that excluding military recruiters was a form of expressive conduct protected under the First Amendment, but the Supreme Court rejected this, responding that, "We have extended First Amendment protection only to conduct that is inherently expressive." Law schools expressed their disagreement with the military by treating military recruiters differently from other recruiters. But these actions were expressive only because the law schools accompanied their conduct with speech explaining it. The expressive component of a law school's actions is not created by the conduct itself, but by the speech that accompanies it. The fact that such explanatory speech is necessary is strong evidence that the conduct at issue here is not so inherently expressive that it warrants protection under O'Brien. The phrase overwhelmingly apparent comes from the famous 1989 flag-burning case of Texas v. Johnson, where the Supreme Court ruled that Gregory Lee Johnson's burning of an American flag qualified as protected speech under the First Amendment because the expressive, overtly political nature of the conduct was both intentional and overwhelmingly apparent. Some courts have gone so far as to say this 1989 case created a new Johnson test for symbolic speech and expressive conduct. To determine whether particular conduct possesses sufficient communicative elements to bring the First Amendment into play, the two-part Johnson test asks 1. Whether an intent to convey a particularized message was present, and 2. Whether the likelihood was great that the message would be understood by those who viewed it. When quoting these two cases to uphold mask mandates, judges would rattle off possible non-communicative interpretations of masking and non-masking which opposed those of the plaintiffs. The existence of these alternative interpretations, the judges would say, meant that any message being communicated by masking or non-masking was not overwhelmingly apparent enough to qualify as inherently communicative for First Amendment purposes. A good example of how this line of reasoning usually ran comes from Judge Jared M. Strauss in Zinman v. Nova Southeastern University. While plaintiff may interpret mask wearing as subservience or akin to worship of idols, that message would not be overwhelmingly apparent to one observing him or anyone else wearing a mask. Thus, wearing a mask is not inherently expressive such that the challenged mask mandates constitute compelled speech subject to First Amendment analysis. Similarly, the act of not wearing a mask is not inherently expressive under Johnson. Even positing plaintiff's intent to convey a message of protest against authority by not wearing a mask, he cannot satisfy the second prong of the Johnson test because there is no great likelihood that such a message would be understood by one observing his conduct. There are myriad reasons why someone may not be wearing a mask. The person may qualify for a medical exemption, may be apathetic towards or unconcerned about COVID, may have simply forgotten their mask, or, indeed, may be attempting to send a political or religious message as plaintiff contends. However, there is no way for an observer to know the reason why without additional explanation. This cookbook argument may appear solid at first glance, but falls apart on cross-examination. Simply looking closer at both the 1989 Johnson case and the 2006 Rumsfeld case is enough to do this, but more extensive reading of the Supreme Court's rulings in the area of symbolic speech and expressive conduct makes it overwhelmingly apparent that COVID-panicked courts got it badly wrong on masks, misapplying the law and moving the goalposts for what counts as symbolic speech and expressive conduct protected under the First Amendment. First, the Supreme Court never said in either the 1989 Johnson or 2006 Rumsfeld case that the message communicated by expressive conduct or symbolic speech must be overwhelmingly apparent to qualify as inherently expressive under the First Amendment. To turn this phrase into a requirement confuses and conflates necessity with sufficiency. Sufficiency and necessity are two very different things, and any judge or lawyer worth their salt is well aware of the distinction. For example, being 50 years old is sufficient to serve as a United States Senator, but it is only necessary to be 30 years old in order to do so. Communicating a message that is overwhelmingly apparent to the vast majority of one's audience is, as the Supreme Court ruled in 1989, obviously sufficient to invoke First Amendment protections of expressive conduct, but all that is necessary, according to the Supreme Court precedents used to decide the 1989 Johnson flag-burning case, is that the activity be sufficiently imbued with elements of communication to fall within the scope of the First and 14th Amendments. The demand that the specific message inherent in masking or non-masking be overwhelmingly apparent has more in common with the minority dissent in Texas v. Johnson than with the majority ruling. Far from being a case of one picture being worth 1,000 words, complained the dissenting justices, flag burning is the equivalent of an inarticulate grunt or roar that, it seems fair to say, is most likely to be indulged in not to express any particular idea, but to antagonize others. What the dissenting minority in Texas v. Johnson missed with regard to flags, and what judges upholding mask mandates missed or refused to recognize during the COVID crisis, is that speech in any form does not need to be eloquent, articulate, or immune to misunderstanding in order to be comprehensible, effective, and entitled to protection under the First Amendment. Speech which is the most genuine often tends to be more rudimentary. Judges who upheld mask mandates claimed that possible alternative interpretations of the motivation behind masking and non-masking meant that neither act could qualify as inherently expressive symbolic speech because the message was not overwhelmingly apparent. But the Supreme Court has already issued multiple rulings on symbolic speech and expressive conduct that go against this argument, starting with the landmark 1943 case West Virginia v. Barnett et al. During World War II, members of the Jehovah's Witnesses refused to salute the American flag on religious and free speech grounds, and were punished for doing so until finally vindicated by the Supreme Court. At the height of worldwide war, a far greater national emergency than COVID ever was, the Supreme Court held that compelling even a momentary flag salute was unconstitutional coercion of symbolic speech. Justice Robert H. Jackson, who later served as prosecutor during the Nuremberg trials, delivered the Supreme Court's ruling. It was a ringing affirmation that echoes just as strongly today. If there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein. West Virginia Board of Education v. Barnett is especially relevant to masking for at least 3 reasons. First, it took place in the middle of a national emergency, World War II. Second, it was another case of symbolic speech through non-action. Third, it was another case where only a minority of those who observed the non-action would have understood the message being sent. Every objection raised against masking or non-masking being a form of speech during COVID was also applicable to the Jehovah's Witnesses who objected to saluting the United States flag during World War II. The exact reason why a Jehovah's Witness was refusing to salute the American flag might be overwhelmingly apparent to members of the same minority sect, but not to most other observers or viewers without additional explanation. Nevertheless, saluting a flag, like wearing a mask, is a form of speech, and the First Amendment protects the right to refrain from speaking as powerfully as it protects the right to speak. During the COVID crisis, wearing a mask was a perpetual salute, every bit as expressive as holding a sign with written words. Compulsory masking forced wearers to act as instruments for fostering public adherence to a specific ideological point of view, symbolically shouting "unclean, unclean" in a crowded community, creating or exacerbating panic. It was an overt attempt to prescribe what shall be orthodox in medicine and politics. Just because some potential subset, or even the majority of recipients or observers fail to recognize or acknowledge a message does not mean that no message has been sent. Speech protected under the First Amendment does not have to be articulate, eloquent, or comprehensible to every viewer. Whether or not speech of some type takes place is independent of the size of the receptive audience. Ancient Christians communicated their believing status to one another using the simple pictogram of a fish. That this would have been lost on most contemporary pagan viewers was by design, and does nothing to defeat the fact that symbolic speech occurred when such iconography was employed. In West Virginia Board of Education v. Barnett, even though the vast majority of Americans did not share the Jehovah's Witnesses' perception of saluting the flag as an act of worship sufficient to violate the commandments found in the book of Exodus, the fact that members of the minority sect did so was sufficient to implicate First Amendment protections of both speech and religious practice. In the context of COVID-19, wearing or not wearing a mask clearly created a signal and sent a message, the very definition of symbolic speech. The failure of a portion of onlookers to accurately receive an intended message from masking or non-masking does not prove that no speech has taken place. If you say something and a deaf person does not hear you, or if a deaf person signs to you and you do not look at their hands or recognize the meaning of their gestures, speech has still taken place. The same applies to the speech inherent in masking and non-masking. To most people refusing to wear a mask, not wearing a mask communicated, "I am being open with you, I am not a threat to you." The fact that many people read such an act as, "I do not respect you," or "I do not care if you get sick," was a mistaken interpretation arising from their own internal filter. Misunderstandings or disagreements about what has been said can only happen if speech has, in fact, taken place. The fact that many people disliked the message communicated by masking or non-masking, or that people disagreed about the details or virtues of the message, just provides further proof that a message was being sent in the first place. Heated disagreement over precisely what meaning attaches to wearing or not wearing a mask merely serves to underscore that mask wearing or non-wearing in the context of COVID was, in fact, an act of symbolic speech, and as such implicated the First Amendment. Published scientific literature since 2020 recognized the speech in masking and non-masking. A Viewpoint article in the Journal of General Internal Medicine remarked, "Others refuse to wear a mask for political reasons, seeing it as a symbolic statement. Republicans are less likely to wear masks than Democrats, with less than 50% of Republicans wearing masks compared with over 75% of Democrats. For some, mask wearing can be viewed as a sign of weakness and shame, particularly for men. 67% of women reported that they wore masks outside, compared to just 56% of men." Another commentary, published in the International Journal for Environmental Research and Public Health, observed, "Mask adherence may, in part, be a function of whether or not mask wearing is perceived to be normative among one's political party." Mask wearing indisputably implicates the free speech clause of the First Amendment. In the words of West Virginia v. Barnett, it "invades the sphere of intellect and spirit which it is the purpose of the First Amendment to our Constitution to reserve from all official control." Court rulings that argued non-masking was somehow not protected expression because a reasonable observer would simply think the mask wearer was complying with public health law, or that the mask wearer could distance themselves from the message communicated by masks through some sort of disclaimer, were directly addressed and demolished 2 years before COVID by Supreme Court Justice Clarence Thomas in his 2018 Masterpiece Cakeshop v. Colorado Civil Rights Commission concurrence, joined by Justice Neil Gorsuch. In Masterpiece Cakeshop, the Supreme Court reversed the Colorado Court of Appeals, which had ruled against baker Jack Phillips' refusal to bake a cake for a same-sex wedding. Phillips asserted his free speech and free exercise rights under the First Amendment, which the Colorado Court of Appeals denied using the same reasoning employed during COVID to disparage and deny the symbolic speech in masking and non-masking. In his concurrence, Justice Thomas quickly exposed and refuted the flawed general arguments used by the lower court. The Colorado Court of Appeals was wrong to conclude that Phillips' conduct was not expressive because a reasonable observer would think he is merely complying with Colorado's public accommodations law. This argument would justify any law that compelled protected speech, and this court has never accepted it. From the beginning, this court's compelled speech precedents have rejected arguments that would resolve every issue of power in favor of those in authority. The Colorado Court of Appeals also erred by suggesting that Phillips could simply post a disclaimer dissociating Masterpiece from any support for same-sex marriage. Again, this argument would justify any law compelling speech, and again this court has rejected it. We have described similar arguments as begging the core question. Both of these flawed general arguments refuted by Justice Thomas were repeatedly and routinely employed by courts to justify compulsory masking, and both were indefensibly wrong, especially coming just 2 or 3 years after the Supreme Court's Masterpiece Cake Shop decision. Moreover, the U.S. Supreme Court has already said that changes to apparel far more subtle than the sudden appearance of masks are entitled to First Amendment protection. In the landmark 1969 free speech case, Tinker v. Des Moines Independent Community School District, the same 9 United States Supreme Court justices who issued the O'Brien decision just 1 year earlier held that the wearing of armbands was closely akin to pure speech, which, we have repeatedly held, is entitled to comprehensive protection under the First Amendment. This decision applies directly to masks in the context of COVID in at least 2 ways. First, like the Supreme Court's decision in Barnett, Tinker was also decided in the context of the most archetypal national emergency, a war. Second, armbands are far more subtle articles of clothing and elements of a person's appearance than are masks. If armbands qualify as nearly pure speech under the First Amendment, then masks, being far more expressive, are even closer to pure speech. If mere armbands can, as the Supreme Court has said, implicate direct primary First Amendment rights akin to pure speech, then masking and non-masking cannot avoid doing so too. Judicial decisions which denied this obvious truth were only able to do so using procedural technicalities or mental gymnastics that robbed their conclusions of legitimacy. Despite this, courts during the COVID crisis resolutely disregarded the relevance of Tinker and its sibling pre-COVID precedents in order to uphold mask mandates. Tinker provides no support for the plaintiff's position, insisted Judge Reggie B. Walton as he dismissed the suit against compulsory masking led by Congressman Thomas Massie. Releasing respiratory fluids during exhalation that carry virus and transmit infection without any sort of preventative mechanism in the middle of a deadly pandemic is not comparable to wearing an armband on top of one's clothing. But all Judge Walton did here was to couple brute force denial with an appeal to the non-speech component of masking. His prejudicial reframing made no actual attempt to rebut the point that masks and armbands are both symbolic speech. The objection Judge Walton put forward was simply an indirect attempt to imply that the assumed infection control benefits of masks automatically overruled any First Amendment protections without having to formally make or defend such an argument. Ultimately, every legal argument which tries to suggest that masking and non-masking are not speech protected under the First Amendment fails miserably. The Supreme Court has repeatedly and consistently recognized that the Constitution looks beyond written or spoken words as mediums of expression. According to the U.S. Supreme Court, conduct can be a form of speech that falls within the scope of the First Amendment if an intent to convey a particularized message was present, and, in the surrounding circumstances, the likelihood was great that the message would be understood by those who viewed it. In 1974, the Supreme Court specifically said that a symbolic act does not even need to convey a particularized message to fall under the protection of the First Amendment. A narrow, succinctly articulable message is not a condition of constitutional protection, which, if confined to expressions conveying a particularized message, would never reach the unquestionably shielded painting of Jackson Pollock, music of Arnold Schoenberg, or Jabberwocky verse of Lewis Carroll. In other words, conveying a particularized message is sufficient to invoke the First Amendment, but it is not a necessary condition for doing so. The Supreme Court has ruled multiple times that the First Amendment can be, and very often is, invoked by expressive conduct of a far less expressive or specific nature than masking or non-masking. In its 1995 ruling in Hurley v. Irish American Gay, Lesbian, and Bisexual Group of Boston, the Supreme Court further undermined the reasoning used to dismiss First Amendment challenges to compulsory masking when it explained why the First Amendment applied to the diffuse and imprecise expressive conduct and symbolic speech present in parades. A private speaker does not forfeit constitutional protection simply by combining multifarious voices, or by failing to edit their themes to isolate an exact message as the exclusive subject matter of the speech. Nor, under our precedent, does First Amendment protection require a speaker to generate as an original matter each item featured in the communication. Nevertheless, Judge Jared Strauss in Florida argued that the Supreme Court's ruling in Hurley could not apply to masking because the inherent purpose of holding a parade is to convey a particular message. The same can hardly be said about wearing or not wearing a mask. But this refutation is just a variant way of saying neither wearing or not wearing a mask is inherently expressive. Apart from being obviously false in the case of people who are wearing or not wearing masks with the intent to convey a particular message, it is nothing more than a statement of disbelief which does nothing to address the Supreme Court's actual reasoning that still applies every bit as much to masks as to parades. The power of context. Even if masking and non-masking were not inherently expressive, both would still qualify as symbolic speech and expressive conduct protected under the First Amendment because context, the surrounding circumstances, is the crucial factor in determining what constitutes symbolic or expressive speech under the First Amendment. Judges who dismissed free speech challenges to compulsory masking either ignored, discounted, or prejudicially misread this all-important component of symbolic speech. Their decisions erroneously assume that because masks may not be symbolic speech in some contexts, such as hospital operating rooms, that they therefore cannot constitute symbolic speech in other contexts. Meaning is extremely context-dependent. Gestures which are completely innocuous in one context may have great import in others. Eating a piece of bread, taking a sip of wine, or immersing oneself in water are not inherently expressive either, but when done in the company of others in a place of worship, these acts become sacramental professions of religious faith, with the nuanced manner in which they are performed even communicating a celebrant's denominational branch. Small circular bands are not inherently expressive either, but when made of a precious metal and worn on the fourth digit of the hand, they communicate one's marital status to all observers. Context and detail make the difference between a keyring and a wedding band, between taking a bath and getting baptized, between having a snack or taking communion. It is the difference between walking or driving from point A to point B and participating in a march to protest against COVID lockdowns. Trying to disprove the symbolic speech of such acts by reducing them to their mechanical components is simply a cheap rhetorical trick of the sort one learns in high school. Treating a mask as just another medical device is like treating a wedding band as just another ring of metal, or treating a communion wafer as just another cracker. Deliberately eschewing public health or hygiene measures to send a message is as old as the Bible. Jesus himself engaged in an act of symbolic speech when he declined to participate in the common hygiene practice of hand-washing before eating at a dinner party, which most likely involved communal dishes. The point he made in doing this was considered highly offensive by many present. It should come as no surprise, therefore, that many professing to be Jesus' followers immediately and intuitively recognized the symbolic speech inherent in wearing or not wearing a mask in the context of COVID, and acted accordingly. Evangelicals, for example, were less likely than the general population to wear masks throughout the events surrounding COVID, and evangelicals as a group were harshly criticized for this trend. Prior to the COVID hysteria, courts like the 11th Circuit in Florida used the previous Supreme Court decisions in this area to determine that under the right conditions, even food sharing can be speech protected under the First Amendment. As the 11th Circuit observed in a 2018 ruling on symbolic speech and expressive conduct, history may have been quite different had the Boston Tea Party been viewed as mere dislike for a certain brew and not a political protest against the taxation of the American colonies without representation. In that 2018 ruling, the 11th Circuit held a particular instance of food sharing in a public park to be expressive conduct protected by the First Amendment based on 5 contextual factors. These 5 contextual cues built a winning case that the actions in question met the Supreme Court's criteria. In the surrounding circumstances, the likelihood was great that the message would be understood by those who viewed it. First, the event was readily distinguishable from normal conduct. The food-sharing event in question was clearly different from relatives and friends simply eating together at the park. Second, the symbolic acts or events were open to the public. The food-sharing event was open for participation to everyone. Third, the symbolic actions took place in a traditional public forum, a city park. Fourth, the issue involved was one of public concern. The record demonstrates without dispute that the treatment of the city's homeless population is an issue of concern in the community. Fifth, the significance of the act had a historical basis. In the case of food sharing, this dates back millennia. As the court noted, Jesus shared meals with tax collectors and sinners to demonstrate that they were not outcasts in his eyes. The 11th Circuit applied the same set of criteria again in 2021 to determine that the architecture of a particular home did not constitute expressive speech protected under the First Amendment. First, the architecture of the home was not so obviously symbolic that the building was readily distinguishable from other large custom-built homes in a communicative sense. Second, the home was not readily viewable by the public. In fact, much of it was carefully shielded from public view with a limestone wall, louvered gate, heavy landscaping, and substantial vegetation. Third, private residences are not traditional public forums historically associated with the exercise of First Amendment rights. Fourth, residential architecture, and the homeowner's design in particular, had not been a matter of widespread public concern or discussion. Fifth, the court found that there was no evidence that residential architecture, specifically, has a historical association with communicative elements that would put a reasonable observer on notice of a message from the homeowner's house. The 11th Circuit's 5 criteria are clues to assist analysis, so failing one or two of them does not preclude First Amendment involvement. But the more of them that are met, the stronger the First Amendment connection becomes. In the context of COVID, wearing or refusing to wear a mask easily meets every one of these 5 criteria plus one more. First, non-masking during a public health emergency is easily distinguishable from non-masking under normal circumstances, especially in areas where masks are mandated or strongly recommended. Similarly, because non-masking is and remains the norm for the majority of humans throughout human history, widespread masking broadcasts a visual signal that things are not normal, and so it is likewise readily distinguishable from normal conduct. Second, masking and non-masking are open to all in both a viewing and a participatory sense. Going about in either a masked or an unmasked state is readily seen as an implicit endorsement via social modeling for others to do likewise. This artificial consensus and social proof were a major motive behind mask mandates. Third, masking and the conspicuous abstention from wearing a mask are both by their very nature public actions that take place in traditional public forums and other locations open to the public. This was especially apparent in places like government buildings, school board meetings, and town council meetings where people, including myself, were repeatedly refused entry without a mask, thus inhibiting and often outright prohibiting their speech as a direct result of their scruples against wearing masks. Fourth, the activity or non-activity involved in masking undoubtedly implicates issues of public concern, public health, public policy regarding a particular source of risk, and the extent of individual liberties, to list just 3. In the case of masks, this concern grew to the level of public and political polarization. Fifth, deliberately hiding or showing one's face has incontrovertibly been understood to convey a message over the millennia from biblical times to the present. More on this in the appendix. Sixth, the inescapable communicative properties of mask wearing had already been acknowledged and affirmed by multiple scientific studies and court rulings prior to the COVID crisis. The moment someone puts on or takes off a mask with the intent of sending a message, doing so becomes a form of speech protected under the First Amendment. When upholding mask mandates, judges would claim that serving a significant governmental interest and leaving ample alternative channels for communication meant that compulsory masking qualified as a permissible time, place, or manner regulation subject only to intermediate scrutiny. However, as the Supreme Court has pointed out, for a time, place, or manner regulation to be valid, it must be neutral as to the content of the speech to be regulated. This is a condition which compulsory masking by its nature simply cannot meet. Mask wearing cannot be content neutral because it is itself content. Restrictions on speech do not automatically become constitutional just because speakers have a viable alternative. The Supreme Court said in 1939 and again in 1974, one is not to have the exercise of his liberty of expression in appropriate places abridged on the plea that it may be exercised in some other place. As Justice Alito put it in 2020, respecting some First Amendment rights is not a shield for violating others. Public places are an appropriate place to show one's face and exercise one's First Amendment right of free speech. Up until 2020, it was hiding one's face in public that was viewed as aberrant behavior. Also, in those few cases where courts have permitted abridgments of free speech, the vast majority were cases where the legislative branch of government, not the executive branch, imposed the restriction. Mask mandates were almost entirely creatures of executive action, passed in violation of multiple procedural safeguards. Straightforward, unbiased application of the First Amendment's free speech clause and Supreme Court precedents should have been enough to show at a glance that compulsory masking was completely unconstitutional. But there are three additional elements which made compulsory masking one of the worst First Amendment violations in American history, and an imposition which should not have survived any level of scrutiny. First, compulsory masking affected every opposing speaker's intended message. Second, compulsory masking violated every American's right to receive speech. And third, compulsory masking inhibited or prohibited wearers' use of one of their most primal and fundamental forms of pure speech, their facial expressions. Compulsory masking alters objecting wearers' speech. The Supreme Court's 2006 Rumsfeld opinion specifically referenced the first of these three additional violations, and a thorough reading of this decision and its cited precedents reveals that this case should have been referenced to enjoin mask mandates rather than uphold them. When, in 2006, the Supreme Court said, "We have extended First Amendment protection only to conduct that is inherently expressive," it was not laying out some new, stricter, and more subjective test for what counts as symbolic speech or expressive conduct. Rather, it was affirming its previous judgments in this area, including more subtle instances of symbolic speech and expressive conduct like those in Tinker, West Virginia, and Hurley, and there are more where those came from. In 1986, 3 years before its flag-burning decision in Texas v. Johnson, the Supreme Court applied strict scrutiny to a state regulation that burned a corporation's speech because of how the regulation altered the speaker's own message. In Pacific Gas and Electric Company v. Public Utilities Commission of California, the Supreme Court ruled that citizens cannot be forced to use their private property as a mobile billboard for the state's ideological message. The court ruled that the coerced insertion of a leaflet in the envelope of a private utility's bill and newsletter constituted an unconstitutional violation of free speech because the utility may be forced either to appear to agree with the intruding leaflet or to respond. The utility, the court said, might well conclude that, under these circumstances, the safe course is to avoid controversy, thereby reducing the free flow of information and ideas. It is unconstitutional, ruled the Supreme Court, to require speakers to affirm in one breath that which they deny in the next. Mask mandates forced opponents of compulsory masking to affirm by their expressive conduct that which they denied with their words, and we all know that it is actions which speak the loudest. Companies derive their free speech rights from the rights of the citizens that own them, and there is no First Amendment free speech right which a corporation possesses that an individual citizen does not also possess. There is a common thread throughout the Supreme Court's First Amendment rulings. All speech inherently involves choices of what to say and what to leave unsaid. It is axiomatic that a system which secures the right to proselytize religious, political, and ideological causes must also guarantee the concomitant right to decline to foster such concepts. In fact, the Supreme Court listed ordinary people engaged in unsophisticated expression alongside the press and professional publishers when describing the primary beneficiaries of this right to decide what not to say. The fact that a mask mandate does not on its face target speech or discriminate on the basis of its content is not enough to dismiss free speech claims against compulsory masking, because it is the effect of a law's application that determines whether the First Amendment is being violated. The Supreme Court ruled in Hurley that when private parade organizers were forced to include a particular group, the state court's application of the statute produced an order essentially requiring petitioners to alter the expressive content of their parade, which had the effect of declaring the sponsor's speech itself to be the public accommodation. As in Hurley and Pacific Gas and Electric, compulsory masking uses one of a person's most intimate pieces of private property, their face, as a place of public accommodation. Compulsory masking makes people's faces a mobile billboard for the ideological message that COVID is a deadly threat, that they are personally susceptible either to contracting it or to spreading it, that compulsory masking is warranted, and that the government may control their body to the extent someone else may derive benefit. Whenever a masked person speaks out against compulsory masking, they are forced to contend with the fact that they are simultaneously helping to disseminate hostile views, and, in the words of the Supreme Court, might well conclude that the safe course is to avoid controversy. Many people did reach this conclusion. Compelling someone to wear a mask while they argue against masking impermissibly requires them to associate with speech with which they disagree. At the very least, a person wearing a mask against their objections is forced either to appear to agree with mask wearing or to respond. In the words of the Supreme Court, that kind of forced response is antithetical to the free discussion that the First Amendment seeks to foster. On its own, forcing someone to include an unwarranted message within or alongside their own, as in Hurley or Pacific Gas and Electric Company, would be enough to make mask mandates presumptively unconstitutional and require strict scrutiny. But compulsory masking goes beyond even these unconstitutional extremities. In their application, mask mandates have the effect of forcing wearers to physically superimpose a message with which many vehemently disagree over their own message in a way that obstructs and undermines it. Compulsory masking does not merely alter opponents' speech, it suppresses opposing speakers' messages and substitutes the masker's message. This is worse than the violations of free speech the Supreme Court struck down in Hurley and Pacific Gas and Electric Company. Mask mandates had the effect of appropriating all citizens' speech during the COVID crisis to create and proclaim an artificial orthodoxy, actions explicitly repudiated by the Supreme Court on multiple occasions. Compulsory masking was thus presumptively unconstitutional from inception. Regardless of the aim behind it, universal compulsory masking inevitably entails compelled speech. When the choice of whether to wear or not wear a mask is made based on the message masking or non-masking conveys, it boils down to the choice of a speaker not to propound a particular point of view, and that choice is presumed to lie beyond the government's power to control. The Supreme Court's 1995 Hurley decision was cited in its 2006 Rumsfeld opinion. Referring to its 1995 Hurley decision, the court said in Rumsfeld that this court has found compelled speech violations where the complaining speaker's own message was affected by the speech it was forced to accommodate. Judges who wanted to uphold compulsory masking would ignore this crucial reference while quoting the 2006 Rumsfeld decision. It is disingenuous to cite the 2006 Rumsfeld decision to uphold masks, saying, "The fact that such explanatory speech is necessary is strong evidence that the conduct at issue here is not so inherently expressive that it warrants protection," while ignoring the Supreme Court's crucial reference to its 1995 precedent. Having the complaining speaker's own message affected by the speech it was forced to accommodate is exactly the situation produced by compulsory masking. Rulings and arguments which upheld compulsory masking thus used sophistry to ignore half of the chief complaint. The complaints challenging compulsory masking were not simply that mandated mask wearing inhibits or prevents expressive activity, though it indisputably does this by hiding facial expressions and increasing the effort required to speak or be understood. The First Amendment complaints challenging compulsory masking invariably charged that forced masking invasively affects speakers' own messages by compelling expression of a message that many found to be false, objectionable, or repugnant for multiple valid reasons. In addition to being a form of compelled speech in and of itself, compulsory masking visually overwrote every opposed speaker's intended contrary message in direct violation of the First Amendment. The objection that mask mandates are simply a use of the state's power to impose reasonable restrictions on the time, place, and manner in which views are expressed does not hold water. In no way, shape, or form is it a reasonable time, place, and manner restriction to categorically forbid the presentation of a particular view in all public places in a way that forces people to alter and undermine their own speech by overriding it with a message they find repugnant. Another common justification and objection raised to defend overriding people's speech is that mask wearers can expressly disavow any connection with the message sent by masks. This is what Judge Reggie B. Walton was getting at when he said objecting congressmen had myriad means of getting their message opposing masks across, including wearing masks or other clothing containing the messages they wanted to convey, or making speeches from the House chamber or elsewhere on the subject. We have already seen how Justice Clarence Thomas officially refuted this, but even if Justice Thomas had not done so, all justifications like Judge Walton's fail in the case of masks, because actions speak louder than words, making the disavowals Judge Walton proposed either worthless or hypocritical. Even if a mask wearer is able to convince viewers that they do not believe in the message sent by wearing a mask, their message is still forcibly attenuated by the presence of the mask on their face. After all, the very fact that they are still wearing a mask is visible evidence telling observers that their convictions about masks are not strong enough to make them risk the penalties for not wearing one. Mask mandates were an especially pernicious form of suppressed and compelled speech because they produced their restrictive results at the precise time when public interest in the matters discussed would naturally be at its height. The right to communicate through facial expressions, gestures, and dress has, in the words of the U.S. Supreme Court, from ancient times been a part of the privileges, immunities, rights, and liberties of citizens. The fundamental individual rights of free speech, autonomy, and privacy are not privileges conferred by society or the government. They are deeply rooted in American heritage and founded upon historical notions and federal constitutional expressions of ordered liberty. Declaring a public health emergency does not magically exempt a person's body from the protections of the First Amendment. Your face is not a place of public accommodation, neither is your speech, and no authority ever has a right to use either one to propound their preferred message against your will. Violation of the First Amendment rights not to speak and not to associate with particular repugnant speech, as compulsory masking indisputably does, triggers strict scrutiny. Compulsory masking violates observers' First Amendment right to receive speech. It is foundational Supreme Court jurisprudence that the protection of the Bill of Rights goes beyond the specific guarantees to protect from congressional abridgment those equally fundamental personal rights necessary to make the express guarantees fully meaningful. This means that, among other things, the Free Speech Clause of the First Amendment does not merely protect the rights to speak and refrain from speaking, but also the right to receive speech, even in cases when that speech is lacking in social worth. In 1965, in Lamont v. Postmaster General, the Supreme Court declared a postal regulation unconstitutional because it inhibited and limited the unfettered exercise of the addressee's First Amendment rights to receive written speech. The postal regulation struck down had inhibited addressees' First Amendment rights to receive speech by detaining foreign mail tagged as communist political propaganda until the addressees affirmatively opted in to receiving this mail, even though it had already been addressed to them by the sender. The addressee, in order to receive his mail, must request in writing that it be delivered. In striking down this Postal Service regulation, the court also quoted a 1921 opinion by Justice Oliver Wendell Holmes, Jr. The use of the mails is almost as much a part of free speech as the right to use our tongues. This is true, and even more a part of free speech than the use of the mails is the use of our faces and facial expressions. As it did during the COVID crisis with regard to masks, the government argued in 1965 that it was not, in fact, violating any rights. Only inconvenience and not an abridgment is involved. Supreme Court Justice Brennan responded that inhibition as well as prohibition against the exercise of precious First Amendment rights is a power denied to the government. We cannot sustain an intrusion on First Amendment rights on the ground that the intrusion is only a minor one. Justice Brennan then quoted a decision issued by the Supreme Court 80 years before, in 1886. It is a reminder that should never have been forgotten during the COVID crisis. It may be that it is the obnoxious thing in its mildest and least repulsive form, but illegitimate and unconstitutional practices get their first footing in that way, namely by silent approaches and slight deviations from legal modes of procedure. This can only be obviated by adhering to the rule that constitutional provisions for the security of person and property should be liberally construed. A close and literal construction deprives them of half their efficacy, and leads to gradual depreciation of the right, as if it consisted more in sound than in substance. It is the duty of courts to be watchful for the constitutional rights of the citizen and against any stealthy encroachments thereon. The Supreme Court's 1965 Lamont decision fed into another 1976 case greatly affecting public health, Virginia State Board of Pharmacy v. Virginia Citizens Consumer Council, which challenged bans on the advertising of prescription drug prices. When recipients' First Amendment rights to receive speech were invoked, the ample alternative channels reasoning so frequently used by courts to dismiss challenges to masking during the COVID crisis was not good enough. In Virginia State Board of Pharmacy, the Supreme Court said, "We are aware of no general principle that freedom of speech may be abridged when the speaker's listeners could come by his message by some other means, such as seeking him out and asking him what it is. Nor have we recognized any such limitation on the independent right of the listener to receive the information sought to be communicated." Here, again, the Supreme Court has repeatedly stated, where a speaker exists, the protection afforded is to the communication, to its source, and to its recipients both. This court has referred to a First Amendment right to receive information and ideas, and that freedom of speech necessarily protects the right to receive. These cases apply to masks because the right to engage in speech through expressive conduct also includes the right to receive speech through expressive conduct, and mask mandates outrageously violated this right. When describing the return to true normalcy after the Philadelphia yellow fever epidemic of 1793, John Adams' son Thomas wrote, "The idea of danger is dissipated in a moment when we perceive thousands walking in perfect security about their customary business, and no ill consequences ensuing from it." As we saw in Part 3 on mask psychology, a 2021 article in the International Journal of Environmental Research and Public Health aptly described the importance of the messaging involved in this type of expressive conduct. A minority can just ignore the collective panic and continue to live their normal lives, because they are free to do so. Such a minority can be an example and a wake-up call to those that do succumb to the collective hysteria or are close to doing so. Having this example, the anxiety of observers may fall. Observers may follow the example, and the group of hysterics shrinks. It is one of the core characteristics of decentralized systems that they allow for competition, error detection, and correction. If the people that ultimately become role models for others through their interaction become ill and die, the panic would be confirmed. Mask mandates were a virulent attack on just this sort of expressive conduct. They violated not just everyone's right to make these expressive communications, but also everyone's right to receive them. In so doing, they extended and exacerbated the duration of the COVID crisis. This violation was especially egregious and unjustifiable in the case of dissenting healthcare workers and others perceived to have special knowledge about masks, SARS-CoV-2, and infection control in general. When doctors, dentists, and other healthcare providers widely perceived as having special expertise in the field wore masks, it constituted an even more powerful endorsement of the practice. Silence, by conformity and compliance from healthcare workers or anyone else who either knew better or had reservations, was at the very least a form of enforced tacit consent, recognized in the old Latin legal maxim, "He who is silent is taken to agree in cases where he should and could speak." In controversial matters of public concern, and especially during a public health emergency, citizens are entitled to receive all available information that their fellows wish to communicate, including the information communicated by both masking and non-masking. After reviewing the arguments put forward to justify banning the advertisement of prescription drug prices, the Supreme Court concluded, "On close inspection, it is seen that the state's protectiveness of its citizens rests in large measure on the advantages of their being kept in ignorance." Does that sound at all familiar? The court went on to say, "There is, of course, an alternative to this highly paternalistic approach. That alternative is to assume that this information is not in itself harmful, that people will perceive their own best interests if only they are well enough informed, and that the best means to that end is to open the channels of communication rather than to close them." This was, and is, just as true during a declared public health emergency. The solution was not, and will never be, imposing a coerced artificial orthodoxy in politics and science. Rather, the solution protected by the First Amendment is more information, more debate, more speech, vocal, written, symbolic, and expressive. As the Supreme Court ruled decades ago, it is precisely this kind of choice between the dangers of suppressing information and the dangers of its misuse if it is freely available that the First Amendment makes for us. Facial expressions are pure speech. "Your face, my Thane, is as a book where men may read strange matters." William Shakespeare, Macbeth. "And in thy face strange motions have appeared, such as we see when men restrain their breath. On some great sudden hest, oh, what portents are these? Some heavy business hath my lord in hand, and I must know it, else he loves me not." William Shakespeare, Henry IV. "You do not ask me or tell me much that concerns yourself, Frodo," said Gildor, "but I already know a little, and I can read more in your face and in the thought behind your questions. You are leaving the Shire, and yet you doubt that you will find what you seek or accomplish what you intend, or that you will ever return. Is not that so?" "It is," said Frodo. J.R.R. Tolkien, The Lord of the Rings, The Fellowship of the Ring, Chapter 3, Three is Company. But Diggory was more interested in the faces, and indeed these were well worth looking at. The people sat in their stone chairs on each side of the room, and the floor was left free down the middle. You could walk down and look at the faces in turn. "They were nice people, I think," said Diggory. Polly nodded. All the faces they could see were certainly nice. Both the men and women looked kind and wise, and they seemed to come of a handsome race. But after the children had gone a few steps down the room, they came to faces that looked a little different. These were very solemn faces. You felt you would have to mind your P's and Q's if you ever met living people who looked like that. When they had gone a little further, they found themselves among faces they didn't like. This was about the middle of the room. The faces here looked very strong and proud and happy, but they looked cruel. A little further on they looked crueler. Further on again, they were still cruel, but they no longer looked happy. They were even despairing faces, as if the people they belonged to had done dreadful things and also suffered dreadful things. C.S. Lewis, The Chronicles of Narnia, The Magician's Nephew, Chapter 4. Masks are far closer to pure speech than any other article of clothing, but the faces and the facial expressions that masks overwrite are pure speech. Facial expressions are the most precise, articulate, and unfiltered manifestation of body language. They have as much claim to being pure speech as the written word. If anything, facial expressions may possess an even stronger claim to that title. What they lack in precision, they more than make up in speed, intensity, nuance, and candor. Facial expressions, like vocalizations, are among humanity's most primordial means of communication, in constant use thousands of years before the first alphabets or hieroglyphics were developed. Human infants use facial expressions to communicate with their parents long before they can use even the most basic words. If primate communication is anything to go by, facial expressions predate formal language itself. Recognition of this fact is baked into our use of language at such a basic level that we rarely even notice it. It is right there in the term, facial expressions. To deface something is to disfigure it, especially its most visually important parts. When something is effaced, it is erased. If you are self-effacing, you make yourself less noticeable. We dare someone to say that to my face. We invite people to collaborate, to get together and hash this out face to face, because that provides for the best communication. We try to save face and avoid losing face. We may say one thing, but if our face tells a different story, our words will not be believed. If someone says, "It's fine," with a smile, we know things are all good. If they say, "It's fine," with a scowl or compressed lips, we know things are very much not fine. A thing's face denotes not just its most important outward appearance and presence, but what that appearance communicates. We prefer to be able to take things and people at face value. A document's face expresses its most manifest, direct, or obvious sense. Statutes, editorials, and court records express things on their face. We have the right to face our accusers in court. To do something in facie means to do it in the open, where people see it. Plaintiffs bring prima facie evidence to support their complaints. If a question of federal law affirmatively appears on the face of the record, a federal court may have jurisdiction to review it. A statute expresses something or speaks on its face. It can be judged upon its face. After testing the section on its face, it may be invalid on its face, because the inevitable effect of a statute on its face may render it unconstitutional. In determining this, judges may sometimes need to go behind the face of the statute or of the complaint to get at its full meaning and implications. Facial expressions are pure speech. They are pure speech more surely than are those symbols on a page that we train our brains to interpret as letters. Through dedicated effort and lifelong practice, we train our brains to recognize and translate specific designs on paper as letters of the alphabet. But infants and toddlers learn to recognize, differentiate, and read faces and facial expressions far earlier than they develop the capacity to sound out letters or even speak full sentences. Alphabetic illiteracy is no barrier to reading facial expressions. The trope of individuals skilled with letters and numbers but painfully deficient at reading obvious facial and social cues is pervasive in film and literature for a reason, as is the trope of artists who capture in portraits what cannot be put into words. Our faces and how we use them communicate what words do not, will not, or cannot. Bowing down with one's face to the ground communicates special obeisance. Men were reading faces long before they could read books, scrolls, or cuneiform tablets. Once men developed writing, they wrote chapters and whole books on how to read and interpret people's facial expressions to get at more truth that can be had from each other's written or spoken words alone. Subtle cues from lip compression to how facial expressions form and disappear communicate a great deal. We see examples of this in every medium from literature to film, fiction and nonfiction. An observer might not know exactly why someone's face is happy, sad, or contorted in pain, but the lack of additional detailed information does not negate the fact that the face and facial expressions already communicated details about an internal frame of mind. Judges trying to shoehorn facial expressions into failing intermediate O'Brien scrutiny argued, "The fact that explanatory speech is necessary is strong evidence that the conduct at issue is not so inherently expressive that it warrants protection as symbolic speech. But facial expressions communicate more than mere words, and they modify every spoken word. One could just as accurately claim that the fact that explanatory facial expressions are necessary is strong evidence that the words at issue are not so inherently expressive they warrant protection as speech. In both cases, where words and facial expressions are used to communicate, the fact that additional explanation may be needed means nothing more than when you need to give a friend more detail after telling them, 'I am sad,' or 'I am angry.' Whether your voice or your face communicated the message, your friend still received it, and speech implicating the First Amendment still took place. Moreover, this pure speech also implicates the 14th Amendment right to privacy, as Supreme Court Justice Warren and Justice Brandeis recognized in their 1890 essay on the right to privacy. If, then, the decisions indicate a general right to privacy for thoughts, emotions, and sensations, these should receive the same protection, whether expressed in writing or in conduct, in conversation, in attitudes, or in facial expressions." Emphasis added. If anything, facial expressions are needed to refine the message of words on paper, as evinced by the notorious misunderstandings of tone that can happen when reading letters and email. Similarly, when talking with people on the phone, we often deliberately use our facial expressions to enhance vocal communication, even when we know the other person cannot see us. The rise of stylized facial expressions in emojis and emoticons as part of written messages is tacit recognition of this fact and a shorthand attempt to compensate for it. Moreover, facial expressions are often more honest because they are less voluntary and harder to fake. They are as natural and appropriate in any public space as any written text and spoken words. Any restriction on the pure speech of facial expressions demands strict scrutiny in every sense of the term. Facial expressions are pure speech. Freedom of speech, recognized in the First Amendment, is every human's unalienable birthright. The unalienable First Amendment right to refrain from speaking secures the right to wear or not wear a mask, and the unalienable First Amendment right to speak categorically prohibits compulsory masking, regardless of the emergency. Even assuming masks to be 100% effective with no other side effects, and even assuming some worst-case respiratory variant of smallpox or the Black Death, compulsory masking would still not have been justified or constitutional. The fact that more narrowly tailored measures which have stood the test of millennia were available, like temporary quarantine limited to known infections, only made compulsory masking that much more inexcusable. Dealing with objections and counterarguments. But freedom of speech is not absolute. On the morning of March 2, 1961, 187 black high school and college students met at Zion Baptist Church in Columbia, South Carolina. From there, around noon, they walked in smaller separate groups to the South Carolina State House grounds while the legislature was in session. There, they found 30 law enforcement officers already waiting, and peacefully protested segregation while walking in an orderly way, single file or two abreast, carrying signs for about 45 minutes. They did not even disrupt or impede traffic within the State House grounds. The United States Supreme Court summarized what happened next. When told by police officials that they must disperse within 15 minutes on pain of arrest, They failed to do so, and sang patriotic and religious songs after one of their leaders had delivered a religious harangue. There was no violence or threat of violence on their part, or on the part of any member of the crowd watching them, but petitioners were arrested and convicted of the common law crime of breach of the peace, which the state Supreme Court said is not susceptible of exact definition. The best the arresting and convicting authorities could do was to characterize the students' conduct as boisterous, loud, flamboyant, while stamping their feet and clapping their hands. But they nevertheless imposed penalties ranging from a $10 fine or 5 days in jail to a $100 fine or 30 days in jail. In 2023 dollars, these fines would be $100 or $1,000 respectively. Almost 2 years later, in February 1963, the Supreme Court reversed the conviction, decisively ruling that South Carolina infringed their rights of free speech, free assembly, and freedom to petition for a redress of grievances, rights guaranteed by the First Amendment and protected by the 14th Amendment from invasion by the states. The circumstances in this case reflect an exercise of these basic constitutional rights in their most pristine and classic form. I bet you'll never guess how Supreme Court Justice Clark began his dissent. The priceless character of First Amendment freedoms cannot be gainsaid, but it does not follow that they are absolutes immune from necessary state action reasonably designed for the protection of society. Some variation of this platitude has been raised as an objection at virtually every vindication of individual liberties in America's history. During the COVID crisis, it was parroted ceaselessly as some sort of irrefutable checkmate when citizens objected to the unprecedented invasions of their rights. Freedom of speech is not absolute. Your liberties are not absolute. And so on ad nauseum. Freedom of speech is not absolute has been the trite starting excuse for every violation of individuals' unalienable First Amendment rights in America's history, and a universal objection when those same rights are vindicated. When the Supreme Court ruled in 1941 that judges cannot punish journalists for out-of-court publications opining on pending cases, Justice Frankfurter and 3 others dissented. Freedom of public expression alone assures the unfolding of truth. It is indispensable to the democratic process. But even that freedom is not an absolute and is not predetermined. When the Supreme Court ruled in 1974 that hanging an American flag upside down with a peace symbol on it was protected symbolic speech which the owner could not be arrested for, how did Justice Rehnquist begin his dissenting opinion? The right of free speech is not absolute at all times and under all circumstances. When, in 1989, the court affirmed Americans' right to symbolic speech by flag burning in Texas v. Johnson, the dissenting opinion was the same. The court insists that the Texas statute prohibiting the public burning of the American flag infringes on Respondent Johnson's freedom of expression. Such freedom, of course, is not absolute. At the best, the phrase freedom of speech is not absolute can be used as an introduction, but like saying that's just your opinion, backed up by nothing else, more often it was used as a vapid dodge or a subtle attempt to foist the burden of proof back onto the person who objected to having their rights stolen by fiat. Like saying, burden of proof is on you. It concealed lazy thinking and allowed those with the real burdens of proof to sit back and play the part of sniping skeptics. There is no good reason why the specifically enumerated right to the freedom of speech ever automatically takes a back seat to a limited, unenumerated right to public health. Rather, the presumption is in favor of individual liberty. Indirect, marginal public health benefits, even if proven, cannot justify direct and massive violations of essential individual liberties. This goes double for when the benefits are projections based on theory and computer models, as was the case with SARS-CoV-2. The burden is on the infringer to justify their actions, and hand-waving, use of magic words like safety, or COVID crisis sloganeering was not, and never will be, good enough. In the words of the Supreme Court, the First Amendment does not speak equivocally. It prohibits any law abridging the freedom of speech or of the press. It must be taken as a command of the broadest scope that explicit language read in the context of a liberty-loving society will allow. Few things are absolute. Some narrowly defined speech is not protected, including statements which by their very utterance inflict injury. This includes defamation and libel, threats and intimidation, certain types of obscenity, incitement, and other utterances inimical to the public welfare, tending to incite to crime, disturb the public peace, or endanger the foundations of organized government and threaten its overthrow by unlawful means. Masking and non-masking do not fit into any of these categories. They do not even come close. Yet mask mandates treated merely going about one's business with one's face uncovered as constitutionally unprotected communications which by their very utterance inflict injury. Justice Oliver Wendell Holmes Jr.'s famous example of falsely shouting fire in a theater and causing a panic was oversimplified and overused during the COVID crisis. In 1927, just 2 weeks after he handed down the worst verdict of his career in Buck v. Bell, Justice Holmes joined with Justice Brandeis to write a concurring opinion for the First Amendment case of Whitney v. California that was in many ways antithetical to the principles underlying Buck v. Bell. Justices Holmes and Brandeis reiterated that even dangerous speech is not outside the protection of the First Amendment. Even advocacy of violation, however reprehensible morally, is not a justification for denying free speech where the advocacy falls short of incitement and there is nothing to indicate that the advocacy would be immediately acted on. The wide difference between advocacy and incitement, between preparation and attempt, between assembling and conspiracy must be borne in mind. While Justices Holmes and Brandeis said that only an emergency can justify repression, they heavily qualified this apparent concession, making clear that the starting presumption is in favor of individual liberty. A state is, ordinarily, denied the power to prohibit dissemination of social, economic, and political doctrine which a vast majority of its citizens believes to be false and fraught with evil consequence. They went on to say, those who won our independence believed that the final end of the state was to make men free to develop their faculties, and that in its government the deliberative forces should prevail over the arbitrary. They valued liberty both as an end and as a means. They believed liberty to be the secret of happiness, and courage to be the secret of liberty. They believed that freedom to think as you will and to speak as you think are means indispensable to the discovery and spread of political truth, that without free speech and assembly, discussion would be futile, that with them, discussion affords ordinarily adequate protection against the dissemination of noxious doctrine, that the greatest menace to freedom is an inert people, that public discussion is a political duty, and that this should be a fundamental principle of the American government. The main point, in their words, is that fear of serious injury cannot alone justify suppression of free speech and assembly. Consistent application of this principle would almost entirely rule out rational basis scrutiny for measures that infringe citizens' First Amendment rights. Justices Holmes and Brandeis emphasized that even when a First Amendment violation serves a compelling state interest and is effective at producing the desired results, it may still be unconstitutional. A police measure may be unconstitutional merely because the remedy, although effective as a means of protection, is unduly harsh or oppressive. Despite the state's compelling interest in preventing crime, the fact that speech is likely to result in some violence or in destruction of property is not enough to justify its suppression. The implications for mask mandates are obvious. Even if failing to wear a mask had been likely to spread COVID, that would still not have been enough to justify suppression of the speech inherent in masking and non-masking and facial expressions. Even dangerous speech that makes others uncomfortable is protected by the First Amendment. Masking and non-masking are, at their core, more ideological communication than anything else. First Amendment protections are at their most robust for this sort of speech, and over it the state correspondingly has far less latitude to impose regulations, even or especially during a public health crisis. Even mistaken and erroneous speech is protected. As the U.S. Supreme Court said in its 1976 Virginia State Board of Pharmacy ruling on the right to receive speech, ideological expression, be it oral, literary, pictorial, or theatrical, is integrally related to the exposition of thought that may shape our concepts of the whole universe of man. Although such expression may convey factual information relevant to social and individual decision-making, it is protected by the Constitution, whether or not it contains factual representations, and even if it includes inaccurate assertions of fact. While the court recognized that the Constitution does not provide absolute protection for false factual statements that cause private injury, this is why there is a First Amendment exception for slander and libel, it also recognized that factual errors are inevitable in free debate, and the imposition of liability for erroneous factual assertions can dampen the vigor and limit the variety of public debate by inducing self-censorship. In the court's own words, this is true of speech, be it oral, literary, pictorial, or theatrical. This is worth restating for emphasis because masking and non-masking are both pictorial and theatrical forms of speech. But COVID is a clear and present danger. In an effort to delineate and clarify when speech is and is not protected, the U.S. Supreme Court has gradually articulated and refined a number of descriptors. In its 1963 Edwards v. South Carolina ruling that upheld the right of minority citizens to peacefully protest against unjust majority laws, the court accepted that speech is often provocative and challenging. It may strike at prejudices and preconceptions and have profound unsettling effects as it presses for acceptance of an idea. That is why freedom of speech is protected against censorship or punishment unless shown likely to produce a clear and present danger of a serious substantive evil that rises far above public inconvenience, annoyance, or unrest. There is no room under our Constitution for a more restrictive view, for the alternative would lead to standardization of ideas either by legislatures, courts, or dominant political or community groups. Compulsory masking was an extreme standardization of public health ideas. The clear and present danger exception referenced by the court in 1963 originated in the same 1919 case as the famous fire in a theater analogy, Schenck v. United States, and is one of these clarifying tests for unprotected speech. In 1941, the Supreme Court explained, "We have also suggested that clear and present danger is an appropriate guide in determining the constitutionality of restrictions upon expression where the substantive evil sought to be prevented by the restriction is destruction of life or property or invasion of the right to privacy." This standard invokes two of the most basic, long-standing, and universal legal justifications and defenses for both individual and governmental actions that would otherwise be impermissible: self-defense and, more broadly, necessity as the lesser of two evils. Laws challenged on grounds of free speech are often defended on this basis, that limitations on free speech may be permissible when, as the Supreme Court put it, some speakers will be destroyed in the absence of the challenged law. In the context of free speech, what the debate on mask efficacy gets at is the implicit assumption that if masks work well enough, then limitations on free speech applied during COVID were permissible. The formulaic recitation of cases and deaths from COVID, mentions of aerosols, citations to the CDC, and appeals to scientific consensus and CDC guidelines in every dismissal of a challenge to compulsory masking were an indirect way of trying to evoke this exception without having to defend it on an even playing field. They were attempts to avoid admitting that mask mandates were impermissibly prescribing what shall be orthodox in science, medicine, and public health, and dealing with the constitutional fact that even dangerous speech is permitted. Claims that compulsory masking is an essential public health measure are, in effect, claims of necessity. In the words of the Ninth Circuit, a necessity defense must demonstrate that a direct causal relationship be reasonably anticipated to exist between the defender's action and the avoidance of harm. Compulsory masking assumes that the imposing authorities are faced with an unavoidable choice of evils, and that compulsory masking is the lesser evil, for which there are no viable alternatives. It assumes that the harm compulsory masking prevents is imminent, severe, and that there is a direct causal connection between compulsory masking of every individual and the severity of harm from COVID. This was why mask efficacy was a dogma which could never be disputed. It was an indispensable pillar supporting the implicit claims of self-defense and necessity that compulsory masking rested on. This is a major underlying reason why, in practice, the judicial deck was stacked in favor of the dogma that masks work, and why no scrutiny or rational basis scrutiny was preferred. Just because there is a debate among experts about something does not necessarily make something irrational, and so even when disputed, compulsory masking still passed rational basis scrutiny. This put plaintiffs challenging masks in an impossible catch-22. When plaintiffs conceded for the sake of argument that masks either work or might work, this was used as grounds to rule against them as well, because making this concession merely reinforced the supposed rational or reasonable relationship between mask use and viral spread. But challenging the efficacy of masks outright was a surefire way to start out on the wrong foot. In cases where plaintiffs disputed the efficacy of masks and provided scientific sources, their sources were dismissed on various pretextual grounds, such as that the plaintiffs' references predated the pandemic or did not involve SARS-CoV-2 transmission. Such brush-offs just demonstrated the motivated reasoning and outrageous double standards being applied. New science may help explain old findings, but good science does not become bad science with the passage of time, and authorities like the CDC that pushed masks did so primarily using studies that did not involve SARS-CoV-2 either. Typically, these dismissals followed a basic pattern. They would start with a recitation of the total number of purported deaths with COVID, ignoring the actual mortality rate of SARS-CoV-2, which was comparable to that of other coronaviruses or a bad flu. They would also usually say something along the lines that there is currently no cure and no vaccine, thus sidestepping the fact that for more than 99% of those infected, no cure was needed, as well as the fact that there were effective treatment protocols for COVID-19 available in March 2020. Mention of natural immunity in these court decisions ranges from rare to non-existent. Playing up the risk from COVID as much as possible, these court decisions would then assert that masks are effective and essential, that universal compulsory masking is a rational, proportionate response to respiratory infections, and conclude by declaring that the plaintiff was not entitled to relief, i.e., they should stop complaining and wear a mask. Clearly, according to these courts, the threat from any unmasked individual outweighed any alleged violations of those individuals' First Amendment rights. But pointing out the deadliness of a particular disease does not automatically make every ostensible prevention measure rational or justified. In order for necessity or clear and present danger justifications to be valid in the case of masks, proponents also needed to demonstrate by clear and convincing evidence, at a minimum, that masks work, that alternative means like temporary quarantine were not viable, i.e. that universal compulsory masking is narrowly tailored, and that any unmasked individuals, including those who already recovered from COVID, are not just a speculative theoretical risk, but an actual, imminent, and severe threat to life. A fatal defect in every implied or explicit necessity defense for public health masking is that even if masks had been proven to work, any benefits would, at best, still be as indirect as the benefits from denying wartime accommodation for conscientious objectors, and Congress and courts have long held that granting combat exemptions for conscientious objectors is not likely to seriously hamper the state's defense efforts. Moreover, claims of necessity require a balancing of public interests, but rulings which upheld mask mandates simply categorically and unjustifiably presumed that the state interest in public health outweighed everything else. In reality, the public interest favors non-compulsion. Upholding fundamental individual liberties is always in the public interest. In the words of the Sixth Circuit, it is always in the public interest to prevent the violation of a party's constitutional rights. This includes the First Amendment. In the words of the Seventh Circuit, injunctions protecting First Amendment freedoms are always in the public interest. Judge Kurt D. Engelhardt of the Fifth Circuit articulated this foundational principle especially well in the COVID-19 vaccine context. The public interest is also served by maintaining our constitutional structure and maintaining the liberty of individuals to make intensely personal decisions according to their own convictions, even or perhaps particularly when those decisions frustrate government officials. This applies no less to masks. Additionally, the public benefits from the security provided by a civil service and governmental administration which gives individual liberties the broadest construction possible. Powerful and highly effective federal, state, and local governments are worse than useless without an even more powerful and highly effective Bill of Rights. Even taking public health prophylaxis as a compelling state interest, that only makes it analogous to other compelling state interests like crime fighting and prevention, because the same basic justification applies, that some speakers will be destroyed in the absence of the challenged law. The compelling state interest in crime prevention does not outweigh everything else, especially when any benefits are abstract and indirect, and the measures in question involve concrete and immediate infringements on liberties explicitly recognized by the Bill of Rights. The court rulings affirming this are too numerous to even begin listing. In the same manner, any compelling state interest in public health must also yield to individual liberties. The real burden of proof was always on the authorities, but the cases that dismissed challenges to masks ignored this. In 1927, Justices Holmes and Brandeis recognized that the clear and present danger standard was still especially vague. This court has not yet fixed the standard by which to determine when a danger shall be deemed clear, how remote the danger may be and yet be deemed present, and what degree of evil shall be deemed sufficiently substantial to justify resort to abridgment of free speech and assembly as the means of protection. At first glance, Justice Holmes and Justice Brandeis' 1927 concurrence may seem to suggest that reasonable basis scrutiny is enough. To justify suppression of free speech, there must be reasonable ground to fear that serious evil will result if free speech is practiced. There must be reasonable ground to believe that the danger apprehended is imminent. There must be reasonable ground to believe that the evil to be prevented is a serious one. However, the Supreme Court made clear in a number of later cases any emergency exceptions for basic liberties are much narrower than Justice Holmes and Justice Brandeis' language in 1927 might seem to suggest. The Court clarified in 1941 that the clear and present danger cases decided by this Court indicate that the substantive evil likely to result must be extremely serious and the degree of imminence extremely high before utterances can be punished. The First Amendment's prohibition of any law abridging the freedom of speech or of the press must be given the broadest scope that can be countenanced in an orderly society. Unlike the reasonable basis test, the clear and present danger doctrine requires a weighing of the evidence. Even successfully showing that the speech in question may cause the feared harm is not enough. In accordance with what we have said on the clear and present danger cases, neither inherent tendency nor reasonable tendency is enough to justify a restriction of free expression. Mask mandates imposed a de facto reasonable tendency test, but even assuming that non-masking could be shown to have a reasonable tendency to increase COVID transmission, the Supreme Court has already said the reasonable tendency test is so vague and indefinite that it is repugnant to the guarantee of liberty contained in the 14th Amendment. The Supreme Court has also said what risks do not meet the clear and present danger standard, and its rulings make clear that reasonable basis scrutiny or intermediate scrutiny are far too deferential. In 1940, the Supreme Court ruled that no clear and present danger of destruction of life or property, or invasion of the right to privacy, or breach of the peace can be thought to be inherent in the activities of every person who approaches the premises of an employer and publicizes the facts of a labor dispute involving the latter. By the same token, no clear and present danger of communicable disease can reasonably be assumed to exist in every member of the population who approaches within 6 feet of another person when no signs and symptoms of disease are present, regardless of whatever communicable diseases may be extant in the community as a whole. In 1941, incidentally the day after the Japanese attack on Pearl Harbor, the Supreme Court clarified this even further in Bridges v. California. The court said, "The likelihood, however great, that a substantive evil will result cannot alone justify a restriction upon freedom of speech or the press." In the same case, the court noted, restatement of the phrase clear and present danger in other terms has been infrequent. Compare, however, the test to be applied is not the remote or possible effect. During COVID, the entire justification for compulsory masking was based on the remote or possible effect of masks on viral transmission. A possible increase in the chances of transmitting a disease which one might possibly have, with an average infection fatality rate of less than 0.15%, cannot possibly meet this standard. Any benefit from universal masking would be, at best, a remote or possible effect. If marginally altering one's risk of contracting a single communicable disease could justify such invasive abridgments of fundamental rights, then no infringement of basic rights would be off the table. Freedom of speech may not be absolute, but the government's constitutional license to infringe freedom of speech and other essential rights is less absolute still. Even assuming every benefit ascribed to masks during the COVID crisis had been accurate, compelling their use would still be blatantly unconstitutional. Mask mandates irrationally treated every set of lungs as a clear and present danger, even though no generalized clear and present danger of communicable disease can reasonably be assumed to exist where no signs and symptoms are present. Seatbelts and helmet laws are a bad legal analogy. The argument that masks are just a basic common-sense safety device akin to seatbelts and safety helmets also fails. In his initial appellant brief that would ultimately lead to the first major direct legal setback for compulsory masking, Attorney Jeff Childers identified at least 9 legally relevant distinctions between masks and helmets or seatbelts. Unlike masks, seatbelts and safety helmets have never been considered a form of symbolic speech, and do not occupy a unique role historically and fundamentally, particularly as related to speech. Unlike masks, seatbelts and most safety helmets do not interfere with nonverbal speech like facial expressions. Unlike masks, seatbelts and most safety helmets do not obscure or interfere with the long-recognized protectable interest a person has in their likeness. Unlike masks, seatbelts and safety helmets have historically been regarded positively by most people. Unlike masks, seatbelts and safety helmets lack a long, storied history of symbolizing threats, intimidation, and violence. Masks have a historical association with criminality and disease that helmets and seatbelts completely lack. Unlike masks, state legislatures have never attempted to outlaw seatbelts or safety helmets. Unlike masks, no states have legislated automatic increases in criminal penalties just because someone wears a seatbelt or safety helmet while committing a crime. Unlike masks, no one has ever made the use of seatbelts and helmets a requirement to obtain essential goods and services. Unlike with masks, there is no broad scientific controversy about whether seatbelts and helmets actually work. If one insists on making an automobile analogy, compulsory masking was most akin to mandating that all drivers keep their emergency lights perpetually flashing, combined with the invasive intimacy of forcibly installing an ignition breathalyzer in every car, including ignition breathalyzers for people that don't drink at all. There is at least one more legal disanalogy between masking laws and seatbelt and helmet laws. Seatbelt and helmet laws are a subcategory of motor vehicle safety statutes, and motor vehicle safety statutes are typically subject to strict liability. Prior to 2020, the Georgia anti-mask law cases we reviewed earlier explicitly rejected this sort of interpretation in the case of legislation applying to masks. The legal basis for banning masks is, if anything, far stronger than the legal basis for mandating masks. Georgia's Anti-Mask Act was far more narrowly tailored than any COVID crisis mask mandate, and it was passed by the legislature according to well-established conventional procedures rather than emergency executive fiat. Despite this, without substantial pruning by Georgia's Supreme Court, Georgia's Anti-Mask Act was still unable to survive less than strict scrutiny from a rudimentary constitutional challenge. The Supreme Court of Georgia found that the statute would be overbroad and unconstitutional if applied with no reference to intent, such as some motor vehicle safety statutes. Although no intent or fault requirement was included by the legislature in the Anti-Mask Act, the need for a narrowing construction prohibited a strict liability interpretation. In a 2018 ruling, the 11th Circuit Court of Appeals reaffirmed that the Georgia mask statute must be read in light of the limitations placed on it by the Georgia Supreme Court, and Judge Kathleen Williams specifically emphasized that it was the limiting construction that saved the statute from constitutional infirmity. At the very least, therefore, judges in the 11th Circuit who dismissed First Amendment challenges to compulsory masking by referencing seatbelt and helmet laws erred in doing so. Mask mandates fail intermediate O'Brien scrutiny. But what about those times when government can legitimately infringe on symbolic speech and expressive conduct? What about those times when the governmental interest is compelling, or when speech is not so inherently expressive that it qualifies for full First Amendment protection, and is instead subject to intermediate O'Brien scrutiny? After all, the Supreme Court has said, no one supposes, for example, that a city need permit a man with a communicable disease to distribute leaflets on the street or to homes, or that the First Amendment prohibits a state from preventing the distribution of leaflets in a church against the will of the church authorities. This quote comes from the 1943 case Martin v. City of Struthers. During World War II, the city of Struthers, Ohio passed a municipal ordinance forbidding any person to knock on doors, ring doorbells, or otherwise summon to the door the occupants of any residence for the purpose of distributing to them handbills or circulars. When challenged under the First Amendment, one of the defenses raised by the city was its compelling governmental interest in preventing crime. The Supreme Court responded that, while door-to-door distributors of literature may be either a nuisance or a blind for criminal activities, they may also be useful members of society engaged in the dissemination of ideas in accordance with the best tradition of free discussion. The non-zero chance that a door-to-door canvasser might be a criminal did not justify infringing all door-to-door canvassers' First Amendment rights, especially when individual property owners could simply exclude solicitors. Likewise, the non-zero chance that a door-to-door canvasser might have COVID or any other communicable disease does not justify infringements on First Amendment rights any more than does the non-zero chance that they might be a criminal. The Supreme Court could just as easily, and just as accurately, have said, while door-to-door distributors of literature may have a communicable disease, they may also be perfectly healthy members of society engaged in the dissemination of ideas in accordance with the best tradition of free discussion. Indeed, the Supreme Court reaffirmed its 1943 decision in the 2002 case of Watchtower Bible and Tract Society of New York v. Village of Stratton, despite the documented existence of crimes, including murder, using door-to-door sales or canvassing as a cover. Public safety and public health do not automatically trump the First Amendment. Intermediate O'Brien scrutiny deals less with what constitutes speech than it does with when the government is allowed to infringe on symbolic speech and expressive conduct. Even if compulsory masking somehow did not warrant strict scrutiny, compulsory masking still fails the O'Brien standard in multiple ways. Under the O'Brien standard, a governmental regulation burdening free speech must 1. Be within the constitutional power of the government, 2. Further an important or substantial governmental interest, 3. Be unrelated to the suppression of free expression, and 4. Be no greater than is essential. Public health emergency powers are typically defined and inherently limited by the statutes granting those powers, and the power of magistrates to reduce the spread of disease is not as broad and sweeping as the power of Congress to raise and support armies invoked in the O'Brien decision to penalize burning draft cards. Furthermore, the requirement that the restriction on alleged First Amendment freedoms is no greater than is essential means that any measure infringing the First Amendment rights of individuals must be narrowly tailored and not overbroad. If there is alternative means that would more precisely and narrowly reduce the spread of COVID than universal masking, such as, for example, quarantine of the symptomatic or any number of other non-pharmaceutical interventions, then compulsory masking is greater than essential and thus fails intermediate O'Brien scrutiny. But the restriction on First Amendment freedoms from mask mandates was, and remains, far greater than is essential to further any interest in stemming the spread of COVID. In other words, universal masking is not, in fact, narrowly tailored. The restriction on First Amendment freedoms from mask mandates is much greater than is essential, and mask mandates fail intermediate scrutiny because of this. When the Supreme Court ruled that Gregory Johnson's expressive flag burning was constitutionally protected in 1989, two state interests were proffered to justify the suppression of expression in laws prohibiting desecration of the United States flag. 1. Preventing breaches of the peace, eminent lawless action, and 2. Preserving the flag as a symbol of nationhood and national unity. The strongest of these two was the state's compelling interest in preventing crime and breaches of the peace. However, since no breach of the peace occurred as a result of the flag burning, this interest was not implicated. Also, it is established constitutional law that breaches of the peace caused by lack of self-control in offended hearers do not override speakers' rights to free speech. By extension, the state's interest in preventing the spread of COVID should not be implicated in the case of any particular individual refusing to wear a mask unless COVID is actually transmitted, and even then, there would need to be some good evidence that, but for failure to wear a mask, COVID transmission would not have occurred. Additionally, when reading court rulings upholding mask mandates, one finds two universal refrains: that masks are a reasonable measure which may help, and that their primary function is to protect others from the wearer. There is a huge gap between possibly helping versus being necessary or essential. The word necessary does not include anything and everything that might possibly, maybe, conceivably, theoretically help. It is completely false to say that SARS-CoV-2 would be or could be controlled but for individual failure to wear masks, yet this is precisely the implication from carelessly applying words like necessary and essential to masks and mask mandates. Showing that masks may help or possibly help mitigate disease spread would not come anywhere close to being the same as showing that masks are necessary or essential to mitigate disease spread. Universal compulsory masking self-evidently goes beyond what is necessary or essential because it includes many people who have no chance of transmitting COVID whatsoever, either because they do not have it or are immune, and for whom it would therefore be irrational to wear a mask even if masks could be shown to work. Coercing irrational behavior only compounds the inherent wrong. Mask mandates commit a basic fallacy of composition, assuming that what is true of the whole is true of every part. But what is true of the whole is not necessarily true of every part, and vice versa. For example, just because a book as a whole is interesting does not necessarily mean that every individual chapter is also interesting, and just because one sheet of paper in a book is lightweight does not mean that the book as a whole is lightweight. If a disease is present in the community as a whole because 1 or 2 out of every 100 people have it, that does not make it rational or proportionate to act like every individual in the community is infectious, and still less does it give anybody the right to force everybody else to act this way. Unlike other conditions, which may be yes or no propositions, such as anonymity, one's chance of being infected or infecting others is always a matter of degree that can be affected by multiple interchangeable prevention methods. The fact that masks cannot contribute to an individual's inherent immunity means that masking is exchangeable and interchangeable with other common non-pharmaceutical infection control methods, such as social distancing, hand washing, and quarantining. This interchangeability means that even if masks work, the state can always achieve the same effect on public health through means that would not violate First Amendment rights. Finally, as the U.S. Supreme Court has pointed out in other contexts, just because the state has a compelling interest in achieving some aggregate result does not mean that it has one in each marginal percentage point by which it achieves this abstract interest. In other words, just because the government may have a compelling interest in stemming the spread of COVID-19 in the nation as a whole, it does not therefore follow that the government also has a compelling interest in enforcing measures which create a marginal shift in any particular individual's chances of catching or transmitting a virus. Even if mask wearing were decisively shown to affect an individual's chances of catching or transmitting any given virus, it would still be just one out of many measures which produce, at best, a marginal effect on risk to an individual who is himself a marginal fraction of a marginal percentage point in the government's aggregate compelling public health interest. The compelling interest of public health does not carry all the way to broad compulsory masking, and compulsory masking should presumptively fail even rational basis scrutiny when challenged under any article of the Bill of Rights, because no incremental interest the state can possibly have in the theoretical benefits from forcing one individual to wear a mask can possibly outweigh the real, severe, and immediate harms caused by the violative measures necessary to accomplish this. The mask mandates were never narrowly tailored, and repeatedly saying so did not make it any less false. Universal compulsory masking, by its very nature, cannot be narrowly tailored enough to qualify as no greater than is essential. Alternative channels are worthless when the primary message is already being overwritten. A final argument purporting to justify mask mandates under intermediate scrutiny, and which was regularly trotted out during the COVID crisis, is that mask mandates are constitutional because people who wish to criticize compulsory masking have ample alternative channels to get their message across. People wearing masks can still speak, said Federal Judge Susan Mulway. The mask mandates do not impose more than an incidental burden on speech. To the contrary, individuals can still engage in expressive activity. They just have to wear masks while they do. Judge Reggie B. Walton said that congressmen opposing mask mandates had myriad means of getting their message across while still wearing masks, including wearing masks or other clothing containing the messages they wanted to convey, or making speeches from the House chamber or elsewhere on the subject. As the governor rightly states, the mask order does not prevent plaintiffs from expressing their disagreement with the face covering requirement in other ways, said Judge Robert Chambers. This particular argument was put forward to satisfy a criterion of intermediate scrutiny nascent in Justice Harlan's 1968 O'Brien concurrence. After quoting the 4 main intermediate scrutiny criteria listed by the majority, Justice Harlan went on to say, I wish to make explicit my understanding that this passage does not foreclose consideration of First Amendment claims in those rare instances when an incidental restriction upon expression, imposed by a regulation which furthers an important or substantial governmental interest and satisfies the court's other criteria, in practice has the effect of entirely preventing a speaker from reaching a significant audience with whom he could not otherwise lawfully communicate. In other words, Justice Harlan was saying that it was possible for a restriction on speech to still violate the First Amendment even if it met the other 4 O'Brien criteria. He was alluding to earlier cases like Martin v. City of Struthers in 1943, where the Supreme Court gave greater weight to First Amendment claims against restrictions on speech when other equally effective alternative means of conveying their message were not available to the speakers. This concern of Justice Harlan gradually developed into an additional intermediate scrutiny criterion on top of the original 4. The final requirement of intermediate scrutiny is that a regulation leave open ample alternatives for expression, said Chief Justice Rehnquist in 2002. Mask bans and mask mandates inherently fail this final O'Brien criterion. By their nature, mask bans and mandates cannot avoid also banning or mandating more than just the non-communicative aspect of masking and non-masking, and alternatives left open need to be legitimately comparable to whatever speech has been closed off in terms of effectiveness and audience reach, as well as uncontaminated by accompanying compelled and coerced speech. Wearing a mask with an anti-mask slogan or delivering a speech against compulsory masking while wearing a mask does not meet this requirement. Furthermore, the ample alternative channels argument goes both ways. If the state has ample alternative channels to achieve a public health objective through means that would not violate First Amendment rights, then universal masking is not narrowly tailored enough to survive intermediate scrutiny. A restriction on speech does not become constitutional just because speakers have a viable alternative means of communicating their message. As the Supreme Court said, one is not to have the exercise of his liberty of expression in appropriate places abridged on the plea that it may be exercised in some other place. Yet that is exactly what compulsory masking did. Public places and the company of others are a natural and proper place to show one's face for purposes of communication, but this was prohibited in traditional public forums, other public places, private businesses, and even houses of worship, all on the fear-enhanced speculation that a pathogen carried by someone somewhere in the community had a non-zero chance of lethal transmission by persons with no signs or symptoms, and that masks might marginally decrease that chance. Mask mandates and the COVID crisis court rulings that upheld them rest on the presumption that the governmental interest in public health extends in an open-ended, effectively limitless manner to every conceivable risk factor and mitigation measure. Many immediate, direct, concrete harms traceable to the exercise of individual liberties are not enough to justify infringement of First Amendment rights. Appeals to theoretical, future indirect harms, as in compulsory masking, are even less able to justify concrete, immediate, direct violations of essential liberties. Pointing to any potential aggregate benefit is not sufficient. The Bill of Rights does not turn on a numbers game. Free speech conclusion. The unique and important nature of a person's face. In his book, 6-Minute X-Ray, Rapid Behavior Profiling, body language expert Chase Hughes devotes a full chapter to the face and makes it clear that his brief overview is just the tip of this iceberg. A person typically glances at the face 11 times per minute in conversations. The most impactful researcher in facial movement science was Dr. Paul Ekman. Ekman traveled to the depths of jungles to seek out tribes who had never been exposed to outside human contact to verify that facial movements and facial expressions are universal. We truly are born with the same facial expressions and nonverbal communication strategies, and Dr. Ekman proved it. His groundbreaking book, Unmasking the Face, paved the way for modern researchers in behavior science. It should have come as no surprise to anyone that mandates directly regulating a body part as unique and important as the face would constitute an imposition of the most invasive sort. As attorney Jeff Childers articulated the issue, any ordinance requiring someone to cover his face also impairs his face's unique role in communication, his personal identity, and his ability to express his thought and emotion. That, after all, is just what the term facial expressions means. A masked face is not at all normal, but a degree of normalcy is expected for effective verbal and nonverbal communication. In its amicus brief supporting Health Freedom Defense Fund's challenge to the CDC's travel mask mandate, the Association of American Physicians and Surgeons stressed, the ability to see another's demeanor while he is speaking is often as important as the context of what he says. According to the American Medical Association's Guides to the Evaluation of Permanent Impairment, the face plays a unique role in communication. No other part of the body serves as specific a function for personal identity and for the expression of thought and emotion. Facial expressions are an integral part of normal living postures. A degree of normalcy is needed for effective verbal and nonverbal communication. Facial anatomy contributes to identity, expression, normal functioning, and appearance of the forehead, cheeks, eyes, eyelids, eyebrows, lips, mouth, nose, chin, and neck. The face is such a prominent feature that it plays a critical role in the individual's physical, psychological, and emotional makeup. Facial disfigurement can affect all of these components and can result in social, vocational, and even psychiatric harm. This characterization of the face has been in official use for more than 30 years and has been employed to reach decisions in court cases. From ancient times, every person has possessed a fundamental property right in every part of their body. Legal recognition of the special status and value held by structures integral to the face, the eyes and teeth, goes back to the Code of Hammurabi and the Law of Moses. The Law of Moses arguably recognized that even slaves retained ownership rights over the most important structures of their faces, by providing that slaves who had an eye ruined or a tooth broken by their owners were to be set free in compensation. Legal recognition of the special nature of the face as a whole goes back at least as far as the Code of Justinian in the 6th century AD. If someone has been sentenced to the mines because of the gravity of the crimes of which he or she has been convicted, he or she shall not at all be tattooed on the face, since the penalty imposed by conviction can be set forth in a single inscription either on the hands or the legs, in order that the face, which has been designed to resemble the beauty of heaven, shall not at all be disfigured. In her survey of historical attitudes towards facial disfigurements, published in the Transactions of the Royal Historical Society, scholar Patricia Skinner noted, "In the early Irish law code Brethadain Cecht, the shame of the public scar on the face exposed its victim to public ridicule. Hence, the law states, a fine has to be paid for every public assembly the victim has to endure with facial disfigurement." Additionally, a person's likeness, which is primarily if not wholly determined by their face, is a protectable property interest in most modern legal systems. Depressingly, deliberate facial disfigurement, as a particularly barbaric form of punishment for theft, adultery, administrative corruption, and political offenses, is even more widely attested in the historical record than protection. An article published in the journal Antiquity in 2020 noted, "Mutilation has commonly been applied to the limb extremities and the head, but the face especially serves as a brutally obvious medium for marking out certain individuals from others. This is because the human face is not only defined by the morphology of underlying bone, muscle, and fat, but soft tissues, such as those forming the ears, nose, and lips, all serve to make each face distinct, facilitating social communication and allowing the expression of emotions. A person's face is the most visible locus of their personality, and this deliberate targeting is itself an indicator of the special importance historically attached to what at least one highly published surgeon has called the most noble and expressive part of the human body. Compulsory masking may not permanently disfigure the face, but it indisputably infringes on that part of our bodies which most houses and expresses our identity, and which possesses a unique historical and legal status because of this role. The private forum of your face and facial expressions is not exempt from the protections of the First Amendment. Saying that the First Amendment protects a man's speech but does not protect his mouth from being forcibly closed would be the worst kind of absurdity. Areas of the face forcibly covered by masks include the lips and teeth needed to properly form words, as is the nose that helps give the voice its resonant quality. It is worse than absurd to argue that the First Amendment protects speech but somehow permits a man's facial expressions to be forcibly overwritten by a mask that inherently communicates a message he opposes. The facial expressions forcibly occluded by masks are pure speech, and there are multiple factors that decisively tip mask mandates into the realm of unconstitutional infringement on free speech, even under lesser forms of scrutiny than the strict scrutiny which compulsory masking unquestionably requires. The overwhelming majority of people compelled to wear masks were unable to transmit COVID either by reason of not being infected or because they had already recovered. This is self-evidently greater than is essential. People desiring to engage in expressive conduct and symbolic speech by not masking had their message affected by the speech it was forced to accommodate, and alternative channels available to communicate opposition to masking were comparatively worthless in light of the potent communicative effect of mask wearing. Verbal messages against masks were effectively overridden or at least rendered hypocritical and suspect by the symbolic message people were forced to convey by wearing one, and this effect was especially pernicious in the case of doctors and other health care providers who opposed compulsory masking. Additionally, compulsory masking violated every potential viewer's right to receive speech through facial expressions, symbolic speech, and expressive conduct. Anything that artificially increases the effort required for speech is an inhibition. Speech cannot occur without airflow past the vocal cords, so anything that increases resistance to such airflow, e.g. a mask, is by definition a mechanical inhibition of vocal speech. Additionally, as we have already seen in the science section, published studies from 2020 and 2021 described voice disorders as a known side effect of mask wearing. Exceptions and exemptions from mask wearing for public speaking and artistic vocal performances at the height of the pandemic implicitly conceded this fact. Imposing a masking requirement as a prerequisite for public comment before legislatures, city councils, and school boards grossly inhibited citizens' exercise of their First Amendment rights to petition the government. The minor vocal effects of masks on speech might be justifiable under a rational basis standard, but the social modeling and social proof inherent in mask wearing forces everyone who wants to argue against masks to symbolically contradict themselves. The COVID crisis mask mandates were not at all narrowly tailored. Generations from now, the inherent madness of compulsory masking is going to become proverbial and a cultural byword for tyrannical overreaction. Mask mandates do not and cannot qualify as being necessary because the government always has less intrusive alternatives available to accomplish the same goal. Attempts to minimize the violation inherent in mask mandates by saying some version of the facial covering requirement is not permanent completely ignored the essential point which cannot be overstated. As the U.S. Supreme Court has said, the loss of First Amendment freedoms for even minimal periods of time unquestionably constitutes irreparable injury. How long mask mandates lasted was secondary compared to the fact that they were ever imposed in the first place. Other grounds used to dismiss challenges to compulsory masking were equally insulting legalisms. For example, here the plaintiff fails to allege a reasonable probability that a real injury will occur unless the temporary injunction is issued. The wearing of a face covering in public under the limited circumstances contained in the emergency order will not in any way alter the plaintiff's physical person or result in permanent disfigurement. This, of course, is a textbook example of equivocation about what a real injury consists of. Physical or other tangible injuries are important and valid types of injury, but intangible injuries like deprivation of fundamental liberties, including freedom of speech, are still legally concrete and require injunctive relief. To limit real injury to physical injury is among the worst sort of judicial reasoning. You don't really believe in freedom of speech unless you are willing to respect it for those opinions you know are wrong and dangerous. Masking is speech. Non-masking is speech. Mandating either one was and remains a plain, palpable invasion of rights secured by the fundamental law, and every court that ruled otherwise during the COVID crisis got it badly wrong to the extent they did so. In fairness to the courts which found that masking did not implicate the First Amendment, no plaintiff alleged symbolic speech and expressive conduct through masking or non-masking as thoroughly or as well researched as this book. But in fairness to the plaintiffs, based on their COVID crisis rulings, these courts would no doubt have insisted that throwing British tea into Boston Harbor was not inherently communicative either. The burden of proof should never have been placed on the plaintiffs to the extent it was. Initial complaints and responses to motions to dismiss are not generally permitted to be book length, and even on a charitable evaluation, multiple courts' refusal to acknowledge and uphold the First Amendment implications inherent in compulsory masking resonates with the worst episodes of jurisprudence in American history, from Dred Scott to Buck v. Bell to Korematsu. When a statute, even more an executive mandate, infringes on a fundamental right, the burden of proof is on the state, not the individual whose rights are being infringed. Judges who upheld mask mandates were not asleep at the wheel during the COVID crisis. Rather, they were wide awake and vigorously scrubbing their hands in the time-dishonored tradition of Pontius Pilate. I take the position that it is absolutely beyond any legitimate use of an authority's power to compel a citizen to communicate a message which that citizen knows or believes to be false. At the very least, the strictest scrutiny must be met first. It is worth repeating, the loss of First Amendment freedoms for even minimal periods of time unquestionably constitutes irreparable injury. An ongoing constitutional violation of the magnitude and duration of compulsory masking certainly does this. Compulsory masking is, beyond all question, a plain, palpable invasion of rights secured by the fundamental law. Masking and non-masking is an incredibly potent form of symbolic speech and expressive conduct far closer to pure speech than numerous things the U.S. Supreme Court has already ruled are protected by the First Amendment. Compulsory masking affects opposing wearers' speech by forcing them to associate with speech they find repugnant, and overwrites their own message with that of the maskers. Compulsory masking violates every viewer's right to receive speech contradicting the message communicated by masking. Finally, the facial expressions censored by masks are pure speech in and of themselves. Any one of these things would require that compulsory masking be subject to strict scrutiny, which it cannot survive. In combination, they raise compulsory masking to one of the worst, most invasive, most widespread violations of First Amendment rights in American history. Regardless of what court rulings drafted in an atmosphere of artificially enhanced terror may have asserted based on motivated reasoning and a cherry-picked selection of case law, compulsory masking indisputably warrants not just strict scrutiny, but the strictest scrutiny under the free speech clause of the First Amendment. And every court that denied this made a clear error of law. The conclusion that mask wearing or non-wearing did not implicate speech could only be reached through willful ignorance, motivated reasoning, and contemptible straw man argumentation. The First Amendment. Free exercise. It is the duty of every man to render to the Creator such homage, and such only as he believes to be acceptable to him. This duty is precedent, both in order of time and in degree of obligation to the claims of civil society. Before any man can be considered as a member of civil society, he must be considered as a subject of the governor of the universe, and if a member of civil society, who enters into any subordinate association, must always do it with a reservation of his duty to the general authority, much more must every man who becomes a member of any particular civil society do it with a saving of his allegiance to the universal sovereign. James Madison, 1785. COVID-19 is not a blank check for a state to discriminate against religious people, religious organizations, and religious services. There are certain constitutional red lines that a state may not cross even in a crisis. Those red lines include racial discrimination, religious discrimination, and content-based suppression of speech. U.S. Supreme Court Justice Brett Kavanaugh, Calvary Chapel, Dayton Valley v. Sisolak, 2020. The First Amendment provides legal protection not just for beliefs, but also for actions or non-actions stemming from those beliefs. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Freedom of religion, including the free exercise of religion, is the first fundamental freedom listed in the Bill of Rights. It comes even before freedom of speech, and with good reason. Historically, it is one of the unalienable rights most frequently violated, and also the one which men have been willing to suffer the most to uphold and defend. In his concurring opinion upholding First Amendment protection for religious exercise in the landmark 1963 free exercise case Sherbert v. Verner, U.S. Supreme Court Justice Potter Stewart wrote, "I am convinced that no liberty is more essential to the continued vitality of the free society which our Constitution guarantees than is the religious liberty protected by the Free Exercise Clause explicit in the First Amendment and embedded in the 14th. Justice Stewart's words were prescient. The right of religious freedom enshrined in the First Amendment was one of the very few strong enough to directly take on the overreach of COVID crisis mandates supercharged by panic. It may seem inconceivable that wearing a mask could violate anyone's sincerely held religious beliefs during a declared public health emergency. Yet for thousands of Americans, wearing a mask was and remains a major violation of sincerely held religious beliefs, depending on the specific context and type of mask, including medical masks in the name of stopping a respiratory virus. Just as sincerely held religious beliefs may dictate wearing a face covering in certain contexts, they are equally, perhaps more, likely to forbid doing so in other contexts. One specifically Christian set out of many possible religious beliefs that preclude mask wearing in the name of COVID is detailed in the appendix. During the COVID crisis, sincerely held religious beliefs drove thousands of Americans to refuse and actively oppose compulsory masking. Many people sensed that wearing a mask was edging into quasi-sacramental performative ritual territory, and at least one lawsuit alleged that in this sense, compulsory masking amounted to an establishment of scientism and safety as secular religions in violation of the First Amendment. The belief that wearing a mask was a repugnant ritual with religious significance could certainly feed into individuals' sincerely held religious beliefs regarding masks, but any claims that compulsory masking violated the Establishment Clause of the First Amendment fail as a standalone matter of law for at least two reasons. First, the legal threshold for something to count as an establishment of religion is high enough that even more overtly religious acts like opening congressional sessions with prayer do not qualify. And secondly, because secular ideologies like scientism are not recognized as religions for legal purposes. For First Amendment purposes, religious beliefs are not limited to tenets and practices specifically required or prohibited by an individual's faith. It is enough that the primary motivation be religious in origin. The Supreme Court has consistently ruled that, in order to be covered by the First Amendment, a religious belief need not be confined in either source or content to traditional or parochial concepts of religion. A religious belief does not have to fall under a historically established religious tradition, as long as it is a sincere and meaningful belief occupying in the life of its possessor a place parallel to that filled by the God of those admittedly qualified for the exemption. In one 1970 case, Welsh v. United States, the agnostic plaintiff went so far as to cross out religious training as a reason for opposing participation in war on his selective service statement, but the court ruled that his moral and ethical beliefs in opposition to all war still qualified for a religious exemption because they were beliefs about what is right and wrong, and these beliefs are held with the strength of traditional religious convictions. It is also not necessary for other individuals from the same faith to agree in order for religious beliefs to receive First Amendment protection. As the Supreme Court very properly said when confronted with an intra-faith disagreement, it is not within the judicial function and judicial competence to inquire whether the petitioner or his fellow worker more correctly perceived the commands of their common faith. Courts are not arbiters of scriptural interpretation. This means that people from the same religion can have disagreements about whether or not to wear masks, and both positions receive First Amendment protection as long as they are sincerely held. Religious exercise under the First Amendment includes any exercise of religion, whether or not compelled by or central to a system of religious belief. This definition, in the words of the Supreme Court, provides very broad protection for religious liberty, and applies to the performance of or abstention from physical acts that are engaged in for religious reasons. There is a legal distinction between the First Amendment's absolute protections for religious beliefs versus its strong protections for the exercise of those beliefs. Obviously, no amount of sincerity would confer First Amendment protections on free exercise which extended to Aztec or Canaanite-style human sacrifice. But still, in the words of the Supreme Court, only those interests of the highest order and those not otherwise served can overbalance legitimate claims to the free exercise of religion. Under the First Amendment, laws that burden religious exercise must be both neutral and generally applicable unless they are narrowly tailored. Otherwise, the law must satisfy strict scrutiny. COVID mask mandates were neither neutral nor generally applicable nor narrowly tailored. Mask mandates are neither neutral nor generally applicable nor narrowly tailored. Since mask mandates could not survive true strict scrutiny, when faced with First Amendment free exercise challenges, advocates and imposing authorities had to insist that the mandates were neutral and generally applicable, and thus not subject to strict scrutiny in the first place. Magistrate Judge Jared M. Strauss dismissed a free exercise challenge to compulsory masking in Florida by saying, "Rational basis review applies because the mask mandates are neutral and generally applicable. They are neutral because they do not have the object of infringing upon or restricting practices because of their religious motivation. They are generally applicable because the government has not, in a selective manner, imposed burdens only on conduct motivated by religious belief." In Massachusetts, District Judge William G. Young ruled that Governor Baker's mask mandate in public places is neutral and of general applicability. Judge Young's ruling on the neutrality and general applicability of mask mandates was then cited approvingly by Judge Susan Mulway in Hawaii. A Sixth Circuit panel of 3 judges acknowledged the multiple exceptions to the Michigan Department of Health and Human Services masking orders, but ruled that the orders were neutral and generally applicable anyway. The masking orders, said the Sixth Circuit panel, are not so riddled with secular exceptions as to fail to be neutral and generally applicable. The exceptions to the MDHHS orders were narrow and discreet. First, many of the exceptions, such as medical intolerance to mask use, eating and drinking, swimming, or receiving a medical treatment during which a mask cannot be worn, are inherently incompatible with wearing a mask. But no matter how dogmatically judges, pundits, and any other authorities insisted that mask mandates were neutral and generally applicable, no mask mandate truly met this standard as laid out by the U.S. Supreme Court. First, government regulations are not neutral and generally applicable and therefore trigger strict scrutiny under the Free Exercise Clause whenever they treat any comparable secular activity more favorably than religious exercise. Though directly targeting religious conduct certainly does make a law non-neutral, just because a law does not explicitly target religious conduct does not always mean that the law is actually neutral in practice. Supreme Court Justice Alito explained that a law cannot be regarded as protecting an interest of the highest order when it leaves appreciable damage to that supposedly vital interest unprohibited. In other words, if some particular conduct, such as not wearing a mask, undermines a claimed governmental interest, a law is not neutral if it permits that particular conduct on the basis of a secular reason, while at the same time forbidding that particular conduct on the basis of a religious reason. A mask mandate that makes an exception for singing unmasked in a chorus while recording in a Hollywood sound studio, but refuses to let churchgoers take off their masks to sing, is not neutral even though it does not directly target religiously motivated non-masking. Allowing casinos to operate at 50% capacity, but not churches, is another example of this sort of non-neutrality, as is granting medical accommodations for not wearing a mask, but refusing religious accommodations. Non-neutrality also raises separate but related issues of disparate enforcement which implicate the 14th Amendment. As another example, Justice Alito pointed to how mask mandates were eased to permit drinking in Las Vegas casinos, but not to permit worship in churches. Casinos are permitted to serve alcohol, which is well known to induce risk-taking, and drinking generally requires at least the temporary removal of masks. First Amendment free exercise analysis also does not require that the activities compared be identical. A mask mandate in all public schools does not mean that imposing a mask mandate on religious schools survives the First Amendment when gyms, piercing studios, and office buildings have lesser or no mask mandates. Regardless of whether one person is unmasked for a medical reason, another unmasked for a religious reason, and still others unmasked for performance, identification, or some other practical reason, one thing remains the same: they're all unmasked. As such, unmasked individuals pose an identical supposed hazard to the claimed governmental interest in public health and infection control, and favoring one of the secular categories over a religious rationale is a violation of the First Amendment, which requires strict scrutiny. As Justice Kavanaugh wrote in Calvary Chapel, Dayton Valley v. Sisolak, 2020, it is not enough for the government to point out that other secular organizations or individuals are also treated unfavorably. The point is not whether one or a few secular analogs are regulated. The question is whether a single secular analog is not regulated. If a law treats any comparable secular activity more favorably than religious exercise, it must satisfy strict scrutiny. In a parallel vein, according to the Supreme Court, a law is not generally applicable if it invites the government to consider the particular reasons for a person's conduct by providing a mechanism for individualized exemptions. In other words, a mandate which allows for exemptions is not truly generally applicable, and if secular exemptions are permitted, including medical and administrative exemptions, religious exemptions must also be permitted. In Employment Division, Department of Human Resources of Oregon v. Smith, for example, the court explained that where the state has in place a system of individual exemptions, it may not refuse to extend that system to cases of religious hardship without compelling reason. Granting medical and administrative exemptions to mask wearing while refusing to grant religious exemptions undermines any claimed neutrality and general applicability. Since every mask mandate explicitly or implicitly allowed multiple secular exemptions, including medical exemptions, any refusal to also grant religious exemptions to mask wearing violated the Free Exercise Clause of the First Amendment. The various branches of the military learned in lower courts that with regard to COVID vaccines, any comparable secular activity does indeed include medical and administrative exemptions. Judge Matthew McFarland in the Sixth Circuit explained, "The Air Force's COVID-19 vaccination mandate is not generally applicable because it allows for medical and administrative exemptions as well as religious exemptions." A Sixth Circuit panel opinion delivered by Judge Eric Murphy later in the same case likewise took the Air Force to task. The Air Force appears to freely grant medical and administrative exemptions from its vaccine mandate. These exemptions produce substantial harm to the health and readiness interests that the Air Force claims to be compelling. The Air Force says that it must reject religious exemptions because those working in close physical contact can spread COVID-19. But the Air Force has allowed medical or administrative exemptions even when those exemptions undercut that interest. Perhaps most striking, the Surgeon General denied a religious exemption for Major Corvey because her assignment required intermittent to frequent contact with others. In the same month, she received a medical exemption for her pregnancy. Judge Reed O'Connor in the Fifth Circuit addressed the same issues in the Navy. The Navy's mandate is not neutral and generally applicable. First, by accepting individual applications for exemptions, the law invites an individualized assessment of the reasons why a service member is not vaccinated. Second, the comparable secular activity includes refusing the vaccine for medical reasons or participation in a clinical trial. An influx of religious accommodation requests is not a valid reason to deny First Amendment rights. No matter how small the number of secular exemptions by comparison, any favorable treatment, in this case deployability without medical disqualification, defeats neutrality. For these reasons, the mandate triggers strict scrutiny under the First Amendment. Another Fifth Circuit case involving the Army highlighted one more way that secular medical and administrative exceptions can be given illegitimate, non-neutral preference over religious exceptions, by allowing lower-level authorities to approve one but not the other. The procedure employed by the Army for reviewing exemption requests itself undermines the claim that the Army considers religious exemptions on an individualized basis. Temporary medical exemptions to the COVID-19 vaccine mandate can be directly granted by the applicant's healthcare provider. An applicant's regional health commanding general can approve a permanent medical exemption, with any appeals to be considered by the Surgeon General. In contrast, a religious exemption must be approved by the Surgeon General, and the Assistant Secretary of the Army, Manpower and Reserve Affairs, reviews any appeals. Thus, as a matter of structure, the Army has opted to make the process for obtaining religious exemptions less personal and local than the process for medical exemptions. This reasoning applies just as much to mask mandates as it does to vaccine mandates. The mere existence of exceptions undermines a claim to be generally applicable, and that claim becomes progressively weaker as the exceptions pile up. The Supreme Court of Louisiana quoted an especially good summary by a panel of judges in the federal Sixth Circuit. As a rule of thumb, the more exceptions to a prohibition, the less likely it will count as a generally applicable non-discriminatory law. At some point, an exception-ridden policy takes on the appearance and reality of a system of individualized exemptions, the antithesis of a neutral and generally applicable policy, and just the kind of state action that must run the gauntlet of strict scrutiny. Both as written and in practice, mask mandates were riddled with unexplained secular exceptions to masking while disallowing religiously motivated non-masking, making them neither neutral nor generally applicable. Additionally, the cumulative effect of exceptions progressively dilutes the purported infection control rationale behind imposing a mandate in the first place. A prime example of a mask mandate so riddled with exceptions that it loses general applicability was the series of mask mandates put out by the United States Department of Defense. Despite supervising one of the healthiest and least vulnerable subpopulations in the United States, the DoD pushed masking harder and further than any other governmental body with the possible exception of the CDC. Review of social media postings from late March 2020 reveals that service members were already wearing face coverings, even outdoors, before Secretary of Defense Mark Esper issued orders on April 5th that, to the extent practical, all individuals on DoD property, installations, and facilities will wear cloth face coverings when they cannot maintain 6 feet of social distance in public areas or work centers. On February 4, 2021, Secretary of Defense Lloyd Austin went even further, turning CDC masking guidelines into automatic orders, along with everything that entails for military personnel. Effective immediately, all individuals on military installations as defined below and all individuals performing official duties on behalf of the department from any location other than the individual's home, including outdoor shared spaces, will wear masks in accordance with the most current CDC guidelines. Secretary of Defense Austin's memorandum incorporated exceptions for secular activities, for brief periods of time when eating and drinking, briefly for identification or security purposes, and to reasonably accommodate an individual with a disability. The consolidated DoD COVID-19 Force Health Protection Guidance documents put out by the Office of Undersecretary of Defense Gilbert Cisneros listed even more exceptions to accommodate participation in a religious service, when clear or unrestricted visualization of verbal communication is required for safe and effective operations, when environmental conditions are such that mask wearing presents a health and safety hazard, and case-by-case exceptions, emphasis added. If the previous host of exemptions were not enough, this last provision for case-by-case exceptions based on executive discretion on its own renders the mask mandate not generally applicable and therefore subject to strict scrutiny, because it creates a mechanism for granting individualized exceptions. As the U.S. Supreme Court said, the creation of a formal mechanism for granting exceptions renders a policy not generally applicable, regardless whether any exceptions have been given, because it invites the government to decide which reasons for not complying with the policy are worthy of solicitude. It is also worth noting that, while the DoD guidance explicitly permits religious and case-by-case exceptions to masking, all formal religious accommodation requests for masking exemptions were treated the same way as religious-based requests for vaccine exemptions: predetermined blanket disapproval. This, despite the broad granting of situational and administrative exemptions and the exception-riddled rules which belied any assertions that masking was so mission-critical that no exemptions could be granted. Mask mandates failed the test of general applicability because each one had multiple exceptions and allowed executive discretion to grant modifications and exemptions. Mask mandates failed the test of neutrality because they included secular exceptions while denying religious ones. Finally, mask mandates were not narrowly tailored because, in addition to being under-inclusive by exempting categories of activity seen to have comparable risk, mask mandates were also over-inclusive because they swept up the overwhelming majority of people who would not have needed to wear a mask even if masks worked. Treating everyone the same, regardless of their individual medical health, risk factors, and immune status, can be neutral and generally applicable, but by definition it is not narrowly tailored. True narrowly tailored, time-tested alternatives, e.g. quarantine of the symptomatic, were always readily available. Universal compulsory masking only really ever addressed one additional theoretical risk: lethal spread of COVID from asymptomatic or pre-symptomatic individuals. The majority of people covered by mask mandates did not have COVID and were at no meaningful risk from COVID. This too prevented mask mandates from qualifying as narrowly tailored. COVID mask mandates were neither neutral, nor generally applicable, nor narrowly tailored, and thus required strict scrutiny under the Free Exercise Clause of the First Amendment. The Religious Freedom Restoration Act, RFRA. A critical offshoot of the First Amendment's Free Exercise Clause is the Religious Freedom Restoration Act of 1993, usually referred to simply as RFRA. Current First Amendment jurisprudence allows laws that infringe on freedom of religious exercise to pass under rational basis scrutiny if they are neutral and generally applicable. This is why too many courts during the COVID crisis twisted the definition of neutral and generally applicable to apply it to mask mandates. RFRA, on the other hand, subjects even neutral and generally applicable laws to strict scrutiny if they substantially burden the exercise of religion. Congress passed RFRA in response to a series of late 20th century decisions by the Supreme Court which undermined, or arguably neutered, the First Amendment's Free Exercise Clause in certain areas, especially correctional and military contexts. The explicit purpose of RFRA was to restore and guarantee protections for the exercise of religion that were applied via the First Amendment in landmark Supreme Court cases like Sherbert v. Verner in 1963 and Wisconsin v. Yoder in 1972, but which were not applied in later rulings like the court's 1986 5-4 decision in Goldman v. Weinberger, which allowed minutiae of military uniform regulations to take precedence over the First Amendment's Free Exercise Clause. RFRA applies to all components of the federal government, including military and correctional institutions, but does not apply to state or local actors. That being said, at the time of this writing, about half of states have passed laws substantially similar to RFRA, and even for those states that do not have RFRA-like statutes, the First Amendment still applies. In the statute's own words, a person whose religious practices are burdened in violation of the Religious Freedom Restoration Act may assert that violation as a claim or defense in a judicial proceeding and obtain appropriate relief. RFRA specifically says that the federal government may not substantially burden a person's exercise of religion, even if the burden results from a rule of general applicability. The statute makes just one exception under two conditions. Government may substantially burden a person's exercise of religion only if it demonstrates that application of the burden to the person, 1, is in furtherance of a compelling governmental interest, and 2, is the least restrictive means of furthering that compelling governmental interest. Under RFRA, a claimant has to show two things: a sincerely held religious belief and a substantial burden on that belief. Once that is done, the burden of proof is on the government to satisfy strict scrutiny and show that its infringement, 1, furthers a compelling governmental interest by 2, the least restrictive means. A substantial burden that would activate RFRA's protections includes when a person is forced to choose between following the tenets of their religion and receiving a governmental benefit, as in the 1963 landmark case Sherbert v. Werner, or when they are coerced to act contrary to their religious beliefs by threat of civil or criminal sanctions, as in the 1972 landmark case Wisconsin v. Yoder. Thus, if someone has a sincerely held religious belief against wearing a mask, including or especially for COVID, any requirement to wear a mask is a substantial burden if that requirement is backed by threats of fines, job loss, denial of services like education or public transportation, denial of access to places of public accommodation, or other penalties. In the words of the Sixth Circuit, this intangible injury, the coerced violation of religious beliefs, is irreparable even when the coercion comes from such lesser forms of pressure as the threatened loss of a civilian job or the loss of the ability to play a college sport. Additionally, as Illinois Judge Raylene Grishow ruled in 2022, to demonstrate irreparable injury, the moving party need not show an injury that is beyond repair or compensation in damages, but rather need show only transgressions of a continuing nature. There is no adequate remedy at law because the loss of the continuous sacrifice of legal rights cannot be cured retroactively once the issues are decided on the merits. More than this, the compelling interest that the government has to show in order to satisfy RFRA is not merely a generalized one as in lesser forms of scrutiny. In 2006, the U.S. Supreme Court made clear that RFRA requires the government to demonstrate that the compelling interest test is satisfied through application of the challenged law to the person, the particular claimant whose sincere exercise of religion is being substantially burdened. To satisfy the requirements of RFRA, the government needs to show it has a compelling interest in applying its mandate to the specific individual. This is important because, as we covered before, even when the government has a generalized compelling interest, the default is that the government does not have a compelling interest in each marginal percentage point by which its goals are advanced. Even in prison or military contexts, RFRA squarely places the burden on the government to demonstrate a compelling interest achieved through the least restrictive means. RFRA's focus on the burden to the person demands more than dismissive, encompassing, and inflexible generalizations about the government's interest and about the absence of a less restrictive alternative. Broadly formulated interests and generalized statements will not suffice. Instead, the government must proffer specific and reliable evidence, not formulaic commands, policies, and conclusions. What might an individualized to-the-person analysis need to include in the case of an individual with religious objections to masking for COVID? To start, it would require far more than a reasonable basis showing that masks actually work. The U.S. Supreme Court has already ruled that in the context of individuals with active tuberculosis, an individualized inquiry requires looking at A. the nature of the risk, B. the duration of the risk, C. the severity of the risk, and D. the probabilities the disease will be transmitted and will cause varying degrees of harm. A to-the-person analysis under RFRA would be even more stringent. At the very least, a to-the-person analysis of masking for COVID would require showing by clear and convincing evidence that masks work, and this showing would just be the first step. The analysis would need to fit the benefits of masks into the objecting individual's specific circumstances, looking at the disease in question, its lethality stratified by age, how prevalent it is in the individual's community and workplace, the relevant transmission rates, the individual's age, overall health and fitness, occupation, and infection history. The analysis would then need to use all this information in some back-of-the-envelope show-your-work math to arrive at an individualized disease risk estimate with and without masks. In order to satisfy the least restrictive means requirement, the analysis would also need to evaluate and discard alternative methods, pharmaceutical and non-pharmaceutical, which could be used singly or combined to achieve the same effect without violating any sincerely held religious beliefs. Finally, due process would require that the individual in question be given a formal opportunity to interrogate, critique, and rebut any and every part of this analysis, or at least produce their own competing analysis. In sum, a to-the-person analysis that satisfies RFRA would need to show that the individual in question posed a quantified, imminent, substantial health risk to themselves and others without a mask, and that there were no viable alternatives available to achieve a comparable risk reduction. This threshold is hard enough to meet for anyone that is not sick, and basically impossible for anyone that already had the disease in question and recovered. No COVID crisis mask mandate came anywhere close to meeting the to-the-person standard required in RFRA. Objections to religious exceptions. Academic debates over freedom of religion and the First Amendment go into detail discussing the tension between religious accommodations and the principle of neutrality contained in the Establishment Clause of the First Amendment, which prohibits the government from enacting any law respecting an establishment of religion. Critics list the practical difficulties involved in adjudicating religious claims, and how the existence of a right to religious accommodation encourages false claims or perceptions of unfairness. Some have gone so far as to argue against the very existence of a generalized constitutional right of religious accommodation. At the everyday ground level, though, 3 objections to religious exemption claims predominate, and none of them are strong. A vague but common objection is that adding religious accommodations on top of secular exemptions would somehow exceed some arbitrary amount of what counts as, or feels like, too many total exceptions. However, even in the more constraining military context, courts have ruled that an influx of religious accommodation requests is not a valid reason to deny First Amendment rights. The related objection, based on fear of potential abuse by insincere applicants bringing false claims, is one of the reasons why sincerity of belief rather than orthodoxy or denominational size is the legal test in religious free exercise cases. The legal presumption of innocence allows some guilty criminals to evade courtroom justice, but that does not justify punishing the innocent by presuming guilt. In the same way, the fact that a number of insincere people may manage to take advantage of religious accommodations does not justify denying accommodations to the sincere. There are multiple ways of reasonably verifying sincerity for legal purposes, and the sincerity standard both protects minorities and makes exploitative gamesmanship more difficult. One of the strongest objections is that permitting religious exemptions begins to make the professed doctrines of religious belief superior to the law of the land, and in effect to permit every citizen to become a law unto himself. This objection was put forward by the state of Louisiana while prosecuting Pastor Mark Anthony Spell for violating Louisiana Governor John Bell Edwards' lockdown orders by holding in-person worship services in 2020. The Louisiana Supreme Court responded directly. The state nevertheless maintains the orders are neutral and generally applicable, and that any holding to the contrary would allow the defendant to become a law unto himself through professed doctrines of religious belief. The state's argument misses a crucial point. The defendant does not argue he is a law unto himself, or the executive orders violate his own standards. What defendant seeks, and what our Constitution ensures, is that his religious activities be treated no differently than comparable secular activities. Disparate treatment implicates the Free Exercise Clause. We interpret Pastor Spell's request not as one for special treatment, but for equal treatment. Compared to those COVID crisis rulings which sought to evade these foundational principles using any and every means available, the Louisiana Supreme Court's finale reads like an unequivocal blast of clean air. We reject any contention that early in a crisis the Constitution's protection of fundamental rights must always yield to the needs of the state to respond to the crisis. A public health emergency does not relegate the First Amendment to a proposition or allow violations thereof to be judged on a sliding scale of constitutionality. The infringement of the fundamental right of the free exercise of religion, whether in times of crisis or calm, must always be strictly scrutinized by our courts. The Fourth and Fifth Amendments. self-incrimination, due process, and takings. No person shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. United States Constitution, Amendment 5. When groping for the right legal terms to describe how their fundamental liberties were being violated by compulsory masking, many Americans intuitively gravitated towards the Fourth and Fifth Amendments because of their well-known protections for the right to privacy, the right to remain silent, the right to due process, and the presumption of innocence. This intuitive association with amendments designed to protect citizens accused of wrongdoing was only reinforced by the language used to characterize refusal to wear a mask. Failure or refusal to wear a mask was constantly described by authorities in ways that implied it was a form of criminal negligence. Loaded terms like reckless, dangerous, and negligent were routinely mixed with other epithets like selfish, antisocial, and free dumb, then venomously flung at people who resisted wearing masks. The overtly punitive nature of the mask mandates, threatening hefty fines and jail time, reinforced this perception. Realistic legal minds knew that actual criminal negligence requires a standard of proof which refusal to wear a mask was unlikely to satisfy, including reckless disregard for the consequences of one's conduct, a heedless indifference to the rights and safety of others, and reasonable foresight that injury would probably result. Such a standard would be especially hard to meet against someone refusing to wear a mask as a form of conscientious objection, especially if they had knowledge of their own health, prior recovery from COVID, or a recent negative test. Conscientious inaction and refusal to wear a mask, which is meant to be a statement or demonstration that one is non-threatening, is also tough to construe as a form of reckless endangerment, much less any kind of overt threat. Additionally, as courts like the Georgia Supreme Court have ruled multiple times, it is a long-standing rule that criminal statutes must be strictly construed against the state and liberally in favor of the accused. Nevertheless, legal standards took a backseat to politics when it came to masks, especially at the rhetorical and street levels. Many people forced to wear masks very reasonably saw mask wearing as a form of symbolic self-accusation of sickness and disease in violation of the right to remain silent and not self-incriminate. Compulsory masking felt like a public health bill of attainder, a law pronouncing someone guilty of some wrongdoing, nullifying their civil rights without a trial, and expressly forbidden by Article 1, Section 9 of the Constitution. Mask mandates assumed that everyone was infectious until proven healthy, the opposite in principle of innocent until proven guilty, and the fact that mask mandates were most often imposed by executive fiat rather than the legislative process only exacerbated this impression. In spite of this intuitive association, however, direct challenges to masking under the Fourth and Fifth Amendments couched in these terms got nowhere because of the highly specific nature of the protections involved. The Supreme Court has affirmed that the principal object of the Fourth Amendment is the protection of privacy rather than property, but the Fourth Amendment's privacy protections apply in specific criminal, search and seizure, and evidentiary contexts, and are not as broad as the privacy protections in the 14th Amendment. As for the Fifth Amendment, when one frustrated military veteran sued after having been denied medical care at the Veterans Administration clinic and threatened with police action for refusing to wear a mask, alleging that he was treated, handled, and regarded as a direct threat to himself or others and presumed to be guilty, the presiding judge responded brusquely, "Plaintiff does not explain by whom he is being presumed guilty or how, but a presumption of innocence has been recognized only in the context of a criminal trial." The judge also felt the need to add, for some reason, "The fact that plaintiff's refusal to wear a mask is a cause for suspicion is neither surprising nor actionable." Innocent until proven guilty, used in the more colloquial sense, can have legal weight in other non-criminal contexts, but these broader applications of the principle arise from legal sources other than the Fifth Amendment. In an employment context, for example, attorney Jeff Childers has pointed out, "There is a small but well-developed set of case law holding that employers can't just assume that a healthy employee is sick simply because they are in some at-risk category. Consider the case of an employer treating a healthy gay person as having AIDS and requiring them to work from home or something. That's not fair. It turns out that kind of differential treatment violates the Americans with Disabilities Act." Discrimination or denial of services based on the presence or absence of a mask is, at bottom, discrimination based on either presumed medical status or ideological status. The Fifth Amendment is not solely concerned with criminal justice, however. The Fifth Amendment's Takings Clause provides various degrees of protection against direct confiscations or regulations restricting the use or enjoyment of private property, depending on the nature of the property and the regulation in question. Takings can also be indirect, as when the government forces citizens to purchase something. At least one initial complaint challenging compulsory masking included an argument that forcing citizens to purchase masks using their own money under threat of criminal sanction was just this sort of indirect taking. This challenge ultimately succeeded, but not based on that particular argument. Even more importantly, in the context of masks, a fundamental component of property ownership protected by the Fifth Amendment is the right to exclude, which is violated by forcing something into or onto someone's property, i.e., taking access. Even invasions as indirect as overflying private property can be this kind of taking under the Fifth Amendment. For example, in 2021, the Supreme Court ruled that a California regulation forcing agricultural employers to allow union organizers onto their property for up to 3 hours per day, 120 days per year, was an unconstitutional per se taking under the Fifth and 14th Amendments. The court explained, "The fact that a right to take access is exercised only from time to time does not make it any less a physical taking." A person's mind and body are their most intimate and fundamental property. It stands to reason, therefore, that any regulation forcing persons to allow something such as a mask or a therapeutic of any sort onto or into their body in the name of a public benefit like public health would constitute a per se physical taking of the most invasive sort under the Fifth Amendment. COVID crisis mask mandates forced people all over the world to allow masks onto their intimate property, their faces, for hours at a time, 365 days each year for multiple years. To hold that public health authority extends to universal compulsory mask mandates effectively takes a legally continuous right of access to one of the most intimate parts of every American's most fundamental property, their face and airways, for purposes of public benefit. James Madison declared, "As a man is said to have a right to his property, he may be equally said to have a property in his rights." Rights are a form of property, and the COVID crisis global deprivation of multiple rights in the name of public health was certainly a taking in derogation of the spirit, if not the letter, of the Fifth Amendment. At the very least, mask mandates were indisputably a direct and immediate interference with people's enjoyment and use of their faces. Ultimately, though, any potential challenges to compulsory masking based on the Fourth and Fifth Amendments have yet to be fully developed or litigated, and did not play a major role in COVID crisis litigation. 13th Amendment challenges to masks. As an aside, when property is involuntarily taken or its use is restricted by authorities, the court has often described the property interest taken as a servitude or an easement. This concept of a taking as a servitude, combined with an understanding of one's body as one's most fundamental property, led at least two plaintiffs to challenge compulsory masking under the 13th Amendment. In Wisconsin, Mark Joseph argued that, at least constructively, by having to wear a mask he is being forced to provide a medical service to others in violation of the 13th Amendment's prohibition on involuntary servitude. In Oregon, a parent argued on behalf of her child that tying school receipt of federal funds to the enforcement of mask mandates was an indirect way of placing children in servitude for money. Unfortunately for these challenges, while the word servitude can be accurately used in a general sense to refer to being controlled by a person or thing, as well as to deprivation or lack of liberty, and both of these definitions certainly applied to compulsory masking, the legal definition of servitude for 13th Amendment purposes is much more specific. In legal terms, servitude can refer to enslavement, but it also includes legal obligations laid on properties and estates, as well as the right of requiring someone to do something which they are obligated to perform, as in the case of a contract. In dismissing 13th Amendment challenges to masking, judges acidly remarked that such claims were utterly without merit, and that plaintiffs' argument that masking is a sign of slavery both trivializes the horrors of slavery and fundamentally misconstrues the nature of the mask mandates. We saw in the psychology section of this book how physical props can be powerful psychological cues, getting people to internalize assigned situational rules and roles, and even inducing them to do things they later regret. While 13th Amendment claims against masks fail as a matter of law, their existence provides further evidence that many Americans strongly perceived masks as a contemporary form of slave collar, which reinforces First Amendment claims that press the symbolic speech inherent in masking and non-masking. Additionally, the dismissing judge's curt rejections of 13th Amendment challenges to masking failed to even acknowledge the long and well-documented history of distinctive articles of clothing signifying servile legal status, as well as the rhetoric of the decade prior to 2020 when politicians were trying to make non-masking compulsory, and which routinely characterized face coverings as signs of subservience. As noted earlier in this book, expressive mask wearing was associated with protests of human trafficking prior to 2020, and forced masking was inflicted on prisoners in Guantanamo Bay as part of procedures designed to make them more psychologically submissive. Implicitly limiting the characterization of slavery to its practice in the 19th century American antebellum South, as these judges did, also does a disservice to contemporary victims of human trafficking coerced using more subtle methods, and ignored plaintiffs' underlying point that slaves, by definition, cannot say no to mask wearing imposed on them in the name of public health or any other rationale. The historical record also contains indisputable examples where dehumanizing and punitive masking was indeed a sign of slavery. For example, in his 1856 book, Sketches of Life in Brazil, Thomas Ewbank remarked, "It is said slaves in masks are not so often encountered in the streets as formerly, because of a growing public feeling against them. I met but 3 or 4, and in each case the sufferer was a female. The mask is the reputed ordinary punishment and preventative of drunkenness. Minute holes are punched to admit air to the nostrils, and similar ones in front of the eyes." While the masks described by Thomas Ewbank were made of metal, a slave collar remains a symbol of servility regardless of whether it is made of cloth, leather, iron, gold, or melt-blown polypropylene. The connection between masks and slavery is similarly baked into the Spanish language and history. The Spanish word bozal refers to a muzzle, a covering for an animal's mouth, or to restrain from speech. It also refers to the state of being wild, untamed, green, and inexperienced. In Spanish New World colonies, bozales were recently enslaved Africans, as compared to Hispanicized Ladinos, whether free or slave. At the very least, given both the history and psychology involved, COVID crisis concerns about masks being a sign of servility ought not to have been dismissed so casually by courts who are confronted with this particular challenge. The 9th and 14th Amendments. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. United States Constitution, Amendment 9. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. United States Constitution, Amendment 14, Section 1. William Penn's hat, unenumerated rights, the right to be let alone, and the right to privacy.
The Constitution of the United States protects those fundamental rights that make up the minor day-to-day matters of liberty, the minutiae and the leviculae, just as much as it does the more obvious or momentous rights. An exchange during the original congressional debates that took place when drafting the Bill of Rights reveals how the more trivial rights, involving things like articles of apparel, can be intimately and inextricably connected to the more momentous and well-known ones, and how petty tyranny undermines the more prominent enumerated rights by chipping away at the unenumerated ones. During the debates over how the First Amendment was to be worded, Theodore Sedgwick, one of the delegates from Massachusetts, objected to the explicit inclusion of the right of assembly. "It is derogatory to the dignity of the House to descend to such minutiae." Sedgwick argued that going to such a level of detail was like declaring that a man should have a right to wear his hat if he pleased, and made a motion that the clause protecting the right of assembly be struck. Representative John Page of Virginia responded, "The gentleman from Massachusetts objects to the clause because the right is of so trivial a nature. He supposes it no more essential than whether a man has a right to wear his hat or not. But let me observe to him that such rights have been opposed, and a man has been obliged to pull off his hat when he appeared before the face of authority. People have also been prevented from assembling together on their lawful occasions." John Page was referring to a trial in England from a century earlier which involved Pennsylvania's Quaker founder William Penn. This trial was part of the founding generation's communal memory and involved violations of many rights which America's founders were anxious to preserve and protect. Having previously been banned from preaching inside any building, William Penn delivered an outdoor sermon on a street corner in London. He was immediately arrested and thrown into jail, then hauled before the London Court of Sessions on charges that he did unlawfully and tumultuously assemble, and did take upon himself to preach and speak to the great disturbance of the king's peace. Penn entered the courtroom bareheaded, at which the mayor, who was the head magistrate, took offense and ordered that Penn's hat be put back on again. Penn, now wearing his hat, was brought to the bar. But William Penn's religious beliefs dictated that he refused to remove his hat in the customary gesture of respect. At Penn's non-action, the mayor again took offense and fined him 40 marks for contempt, roughly the amount a skilled tradesman would earn in a year at the time. After hearing the case, the jury found Penn guilty of the non-crime of speaking in Gracechurch Street. The mayor was furious and threatened the jury with punishment if they did not convict. He even kept the jury imprisoned overnight without fire, food, drink, or even a chamber pot. To its everlasting credit, the jury, led by its foreman, Edward Bushell, refused to cave to either threats or duress, and the next day returned an even more direct not guilty. In a rage, the magistrate had the 12 jurors imprisoned for refusing to obey the court's order to convict, and also refused to release William Penn, citing the fine for not removing his hat which the magistrate had ordered put on in the first place. After America's first congressional delegates were reminded of William Penn's experiences, the freedom of assembly was explicitly included in the First Amendment, and the Ninth Amendment was passed to help protect those other more trivial fundamental rights not specifically enumerated in the first 8 amendments. Later, protection for personal liberty was further reinforced by the Due Process Clause of the 14th Amendment. The presumption starts in favor of individual liberty, not governmental power. If wearing or not wearing a hat implicates fundamental rights, even in the controlled setting of a courtroom, then wearing or not wearing a mask certainly does as well. In 1970, the First Circuit Court of Appeals applied the history of First Amendment debates and William Penn's trial to the seemingly trivial matter of school hairstyle mandates. The court recognized that what appears superficially as a dispute over which side has the burden of persuasion is, however, a very fundamental dispute over the extent to which the Constitution protects such uniquely personal aspects of one's life. When confronted with the same issue in 2001, the Alaskan Supreme Court held control of personal appearance to be a fundamental liberty right. Hairstyles have been a historical target of busybody tyranny the world over, and mask mandates are far more analogous to hairstyle regulations than they are to seatbelt and helmet laws. Requiring plaintiffs who were challenging compulsory masking to show why they should not have to wear a mask represented a fundamental cheat, reversing the proper burden of proof. In overturning a hair-length mandate, a Seventh Circuit panel took judicial notice of the U.S. Supreme Court's recognition for the special right of an individual to control his physical person. The Seventh Circuit referenced Chinese and Russian history to explain. The freedom guaranteed by the Bill of Rights could be significantly diluted through subtle forms of state repression and tyranny. History contains many examples of regimes which have attacked and silenced their opponents by requiring conformity of hairstyle or dress. Thus, following the Manchus' invasion of China in 1644, in order to consolidate its power over Chinese citizens, the founders of the Qing dynasty transformed the appearance of the country by compelling the male population to shave the front of the head and to wear the hair in a queue. Official dress was altered from the Chinese style to the skullcap and Tatar gown, with high collar and fastening at the side. In the first year or two after the conquest, the opposition to these measures was intense, and thousands of people from all walks of life chose to die rather than adapt the marks of servitude. Another example includes official prohibition of beards during the reign of Peter the Great. Defenders of mask mandates might argue, as Alachua County in Florida did, that controlling citizens' hairstyles is more invasive than merely covering their faces, but that is simply wrong. While removing a mask is certainly faster than regrowing hair, mask mandates are inherently more invasive than any rules on hair or beards. One's face is a more intimate area than the crown of one's head, and no hairstyle increases dead air space and resistance to airflow when breathing like masks do. Moreover, masks impose a far greater interference with citizens' abilities to express themselves by overriding the pure speech of facial expressions with a superimposed message. In any case, masking does directly implicate hairstyles, at least for men. According to the theory used to try to justify mask mandates, a good seal around the mask is essential to maximize a mask's effectiveness. Gaps greatly decrease the efficacy of masks. Beards create many such gaps. If bearded expert mask advocates like Dr. Peter Hotez and CDC Director Robert Redfield truly believed that COVID-19 was dangerous and that masks were so essential as to justify mandates, they would have shaved their beards off back in March of 2020 and pushed for bans on facial hair. Instead, they kept their own facial hair throughout the COVID crisis, and there was no serious talk of emergency facial hair bans on grounds of public health. Perhaps at least a few decision-makers or their legal advisors were aware that bans on facial hair had already been ruled either unconstitutional or automatically suspect. Cf. the Third Circuit. We held unconstitutional the Newark Police Department's policy that officers could not have facial hair. In a sense, the mandates of the COVID crisis were, at their roots, nothing new. Using the pretexts of safety, security, or other generally desirable ends, including the government's compelling interest in preventing crime, busybodies, busybullies, and anxiety-ridden authorities habitually attempt to take away or criminalize fundamental individual liberties not explicitly listed in the Bill of Rights, but which are every bit as basic and essential as the enumerated rights. 19th and 20th century bans on interracial marriage were a glaring and long-lasting violation of this type, but violations of the more trivial rights are just as indefensible and even more insidious. U.S. Supreme Court Justice Potter Stewart used a memorable turn of phrase to describe this sort of encroachment, in a manner made the more pernicious by its very subtlety. One such attempt by the Florida city of Jacksonville to ban multiple trivial rights had to be struck down by the Supreme Court in 1972. In Papa Christou v. City of Jacksonville, the city had passed an ordinance permitting arrest and conviction of people engaged in many usually innocent pastimes, including common night walkers, persons wandering or strolling around from place to place without any lawful purpose or object, and habitual loafers. Being a habitual night walker and night jogger myself, I find the thought of such an ordinance particularly grating. The Supreme Court very properly struck down the Jacksonville Ordinance for violating the 14th Amendment's due process guarantee by being so vague and generalized that it cast too wide a net when seeking to prevent crime. The Jacksonville Ordinance makes criminal activities which by modern standards are normally innocent. These activities are historically part of the amenities of life as we have known them. They are not mentioned in the Constitution or the Bill of Rights. These unwritten amenities have been in part responsible for giving our people the feeling of independence and self-confidence, the feeling of creativity. These amenities have dignified the right of dissent and have honored the right to be nonconformists and the right to defy submissiveness. They have encouraged lives of high spirits rather than hushed, suffocating silence. The Supreme Court reasoned that a direction by a legislature to the police to arrest all suspicious persons would not pass constitutional muster. Similarly, going about unmasked has historically been innocent, including throughout the worst plagues of history, and a direction by a legislature, never mind an executive order, to officials to mask all asymptomatic persons does not pass constitutional muster either. Compulsory masking in the name of the Spanish flu and COVID criminalized the right to be nonconformist and the right to defy submissiveness. Compulsory masking mandated lives of anxious spirits and suffocating silence. The point is that not being explicitly enumerated in the first 8 amendments to the Constitution does not magically render a fundamental liberty non-existent. The burden of proof is not on the individual whose rights are being violated, but on the authority to show why its interest is compelling enough and its infringement mild enough to survive scrutiny. Often during the COVID crisis, rights were successfully disparaged, ignored, and violated because they were not enumerated. Instead, this reasoning should have been applied to emergency powers. If specific rights are presumed to be questionable or suspect simply because they are unenumerated or fall under the broad headings of the 9th and 14th Amendments, courts ought to have been even more reticent to uphold unenumerated emergency powers. COVID crisis mandates all too often gained traction not because of any inherent intellectual substance or integrity, but because of widespread, deliberately cultivated, and totally unnecessary abject fear. Face-covering mandates used altruism, civic-mindedness, and infection control to mask what was more often, at bottom, political expediency, cowardice, and intellectual laziness. Why Ninth Amendment challenges to masking failed. It is a funny thing about constitutional interpretation. Generalized clauses which can be interpreted to give the government more power, such as the Commerce Clause or the Necessary and Proper Clause in Article 1, Section 8, are consistently interpreted as broadly as possible. Constitutional clauses which protect individual rights using similarly generalized wording, on the other hand, have a much more uphill struggle, and are often only recognized after being repeatedly and egregiously violated, as demonstrated by the history of efforts to uphold unenumerated individual liberties like the right not to be forcibly sterilized. Admittedly, there have been exceptions to this trend where the courts or other authorities have affirmed or implied rights that do not exist, usually at the expense of actual rights, but this general pattern holds true. Even so, as covered in our discussion of the First Amendment right to receive speech, to its credit, the United States Supreme Court has repeatedly recognized that specific guarantees in the Bill of Rights have zones of control that protect equally fundamental personal rights necessary to make the express guarantees fully meaningful, even when those rights are not explicitly stated in the text of the relevant amendment. The Ninth Amendment recognizes that not all fundamental, inalienable rights and liberties are explicitly listed in the previous 8 amendments. It was included in the Bill of Rights to provide formal recognition and reassurance that the explicit listing of a few specific individual rights in the first 8 amendments would not be interpreted to mean that the rest were unprotected, though this was exactly what happened on a massive scale with compulsory masking and other mandates during the COVID crisis. The text of the Ninth Amendment is simple and straightforward. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. The Ninth Amendment's history, purpose, and simplicity made it an intuitive tool for pro se litigants attempting to challenge mask mandates. Unfortunately, the Ninth Amendment has been functionally relegated to a position as one of the 14th Amendment's sidekicks. Claims brought against compulsory masking directly under the Ninth Amendment, if they were not removed in amended complaints, were dismissed for the simple reason that, under modern jurisprudence, the Ninth Amendment is treated as a rule of interpretation rather than a source of rights. According to the courts, it has never been recognized as independently securing any constitutional right for purposes of pursuing a civil rights claim. The most prominent 20th century Supreme Court decision to heavily feature the Ninth Amendment was Griswold v. Connecticut in 1965. In Griswold, the Supreme Court referred to the Ninth Amendment to strengthen its inference that the right to marital privacy falls under the general protected individual right to privacy and includes the use of contraception. The court's majority opinion held, using rather cumbersome wording, that specific guarantees in the Bill of Rights have penumbras, formed by emanations from those guarantees that help give them life and substance. In the words of the majority, without those peripheral rights, the specific rights would be less secure. Justice Arthur Goldberg put it more simply, with multiple references, in his concurrence. This court has never held that the Bill of Rights or the 14th Amendment protects only those rights that the Constitution specifically mentions by name. In his concurrence, Justice Goldberg spent several pages laying out how the language and history of the Ninth Amendment reveal that the framers of the Constitution believed that there are additional fundamental rights, protected from governmental infringement, which exist alongside those fundamental rights specifically mentioned in the first 8 constitutional amendments. Justice Goldberg clearly defined at least one example of a violation of the Ninth Amendment, though he did so mostly by restating the amendment's generalized wording in a way that applied to the specific example of marital privacy. To hold that a right so basic and fundamental and so deep-rooted in our society as the right of privacy in marriage may be infringed because that right is not guaranteed in so many words by the first 8 amendments to the Constitution is to ignore the Ninth Amendment and give it no effect whatsoever. Moreover, a judicial construction that this fundamental right is not protected by the Constitution because it is not mentioned in explicit terms by one of the first 8 amendments or elsewhere in the Constitution would violate the Ninth Amendment. However, Justice Goldberg carefully stopped short of saying that any rights could be grounded directly in the Ninth Amendment. I do not take the position that the entire Bill of Rights is incorporated in the 14th Amendment, nor do I mean to state that the Ninth Amendment constitutes an independent source of rights protected from infringement by either the states or the federal government.
This landmark case thus left the Ninth Amendment in a position where it does not act as a source of rights and only provides protection from a single highly specific line of attack, the argument that something is not a protected fundamental right because it is not explicitly mentioned in the Constitution. Personally, I hold to the very view which Justice Goldberg took pains to avoid affirming, that the Ninth Amendment constitutes an independent source of rights protected from infringement by either the states or the federal government. I believe the Ninth Amendment does exactly that, at least when combined with the Tenth Amendment's reservation of powers to the states and to the people. The context of the Bill of Rights and the discussions surrounding ratification of the United States Constitution took great care to emphasize the limited nature of government. As James Madison said in Federalist No. 45, the powers delegated by the proposed Constitution to the federal government are few and defined. Those which are to remain in the state governments are numerous and indefinite. The Tenth Amendment recognizes and protects these limitations with regard to both the states and the people. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. The careful wording clearly indicates that the states and the people are separate and distinct categories composed of individuals acting in their own personal spheres, individual states and individual people. The Ninth Amendment was drafted and proposed by James Madison, and he stated during the congressional debates surrounding the Bill of Rights that he did this with the express intent of guarding against any implication that those rights which were not singled out were intended to be assigned into the hands of the general government and were consequently insecure. Protection is implicit in any formal recognition, and it does not make sense to affirm that other amendments actively protect rights which extend beyond their precise wording, but deny this in the case of the one amendment which includes recognition of unlisted rights within its own wording. It seems highly implausible, bordering on irrational to me, that the amendment which explicitly recognizes the existence of unenumerated rights would not or should not also constitute a source of protection for those unenumerated rights in the same way that each of the first 8 amendments does for the group of rights it recognizes. Even though the practical questions of what criteria a court can or should use to determine whether an unenumerated right is fundamental and protected are legitimate and challenging, that same difficulty has not prevented courts from doing this with regard to unenumerated fundamental rights protected by the 14th Amendment. I personally cannot help seeing current judicial interpretation of the Ninth Amendment as unconstitutionally disparaging and denying rights that are not enumerated in the Constitution simply because they are not enumerated, violating the spirit if not the letter of the Ninth Amendment in the process. Regardless of my own personal views, though, as a matter of practicality, bringing any civil rights claim grounded solely in the Ninth Amendment will simply have the effect of making the plaintiff look bad and making the presiding judge take the suit as a whole less seriously, especially if the judge in question happens to be negatively predisposed to begin with, as was the case for lawsuits challenging mask mandates. Under its current judicial construction, the Ninth Amendment provides a positive interpretive lens that helps ensure the rest of the Bill of Rights reaches its full potential, and especially strengthens the 14th Amendment. On its own, however, the Ninth Amendment provides only the extremely narrow protection for fundamental rights of preventing them from being disparaged and infringed solely on the basis that they are not enumerated elsewhere in the Constitution. Perhaps that is good enough. I certainly hope so, and automatically invalidating the argument that something cannot be a fundamental right simply because it is not mentioned in the Constitution is no small thing. Like James Madison said, the most minute provisions become important when they tend to obviate the necessity or the pretext for gradual and unobserved usurpations of power. At this point, any broader role that may have originally been intended for the Ninth Amendment has been gradually folded into the 14th Amendment. This does not mean that the Ninth Amendment is worthless and cannot play a useful, even important part in a successful lawsuit, but it currently functions in a support role rather than on the front line, and on its own, the Ninth Amendment was not even a speed bump for mask mandates during the COVID crisis. The 14th Amendment. It is the 14th Amendment that secures those unenumerated rights referred to by the Ninth Amendment which are not protected elsewhere in the Constitution. For example, while the First Amendment protects freedom of expressive association, the 14th Amendment protects freedom of intimate association, which consists of choices to enter into and maintain certain intimate human relationships.
Already by 1923, over 100 years ago, when it was striking down an unconstitutional Nebraska law that banned the teaching of German before the 8th grade, the Supreme Court had a substantial list of both enumerated and unenumerated rights protected by the 14th Amendment. While this court has not attempted to define with exactness the liberty thus guaranteed, the term has received much consideration, and some of the included things have been definitely stated. Without doubt, it denotes not merely freedom from bodily restraint, but also the right of the individual to contract, to engage in any of the common occupations of life, to acquire useful knowledge, to marry, establish a home, and bring up children, to worship God according to the dictates of his own conscience, and generally to enjoy those privileges long recognized at common law as essential to the orderly pursuit of happiness by free men. Since 1923, the list of recognized fundamental rights has only grown. Miscegenation laws banning interracial marriage were struck down for violating the 14th Amendment, as was the Connecticut law banning marital use of contraceptives mentioned during our discussion of the 9th Amendment. 14th Amendment protections include the previously mentioned freedom from bodily restraint, as well as the liberty of the parents and guardians to direct the upbringing of the children, which entails the right to decide where to educate one's children and what that education consists of. Desegregation, interstate travel, the generalized constitutional right to personal liberty, the freedom to enter into contracts, aspects of voting rights, and more. If you can think of a protected fundamental liberty that does not easily fit into the original Bill of Rights, odds are that the 14th Amendment is involved in protecting it, and it is through the 14th Amendment that the majority of provisions contained in the Bill of Rights are applied, incorporated, to protect individual liberties against the states. Intuitively, one would think that something like masking, which so clearly affects the manner in which people associate, would implicate both expressive and intimate association. But at least one federal district court ruled that mask mandates do not infringe on any freedom of association by analogizing statutes against public nudity or requiring shirts and shoes in certain locations. Other COVID-related mandates certainly infringed on these two fundamental rights of association, but the mask component of the mandates was theoretically a minor restriction on the way they occur, which allowed anyone to freely assemble and associate so long as they were wearing a mask. To date, no one has brought a successful claim that mask mandates interfere with any freedom of association, although I have not yet seen a full exploration or articulation of this claim either. At least two portions of the 14th Amendment are directly relevant to compulsory masking, the Due Process Clause and the Equal Protection Clause. These are contained in Section 1 of the 14th Amendment, which reads in part, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws." Equal protection. The Equal Protection Clause of the 14th Amendment is essentially what the name implies, a clause enforcing equal protection and neutral enforcement of the law. As the U.S. Supreme Court put it in 1942, the guarantee of equal protection of the laws is a pledge of the protection of equal laws. The Equal Protection Clause does not on its own guarantee any specific rights, but instead protects against disparate, i.e. discriminatory, treatment in the exercise of rights guaranteed elsewhere in the Constitution. When the government treats one individual or group, a class of individuals, disparately compared to a similarly situated individual or group, then that disparate treatment is unconstitutional if it has no rational basis, targets a suspect class, or burdens a fundamental right. As you probably guessed based on that description, equal protection violations are only subject to rational basis scrutiny unless the disparate treatment targets a suspect class of persons or burdens a fundamental right. If the disparate treatment targets a suspect class or burdens a fundamental right, then heightened scrutiny is applied. Suspect classes requiring heightened scrutiny include race, gender, religion, national origin, immigration status, and wedlock status, but not things like age, wealth, height, weight, occupation, and criminal history. Some state-level laws include more categories of suspect classes. Selective enforcement of facially neutral mandates could also give rise to 14th Amendment claims under the Equal Protection Clause. A notorious mask-related example of this is the selective enforcement of mask mandates against parents protesting mask mandates for their children at school board meetings, but not against George Floyd protesters.
The Equal Protection Clause can be decisive in crucial cases involving fundamental rights. In 1942, for example, the Supreme Court applied strict scrutiny and unanimously held unconstitutional an Oklahoma law permitting punitive compulsory sterilization for certain repeat felonies, including the theft of more than $20 worth of property, which was defined in the Oklahoma law as grand larceny. The petitioner sentenced to sterilization in Oklahoma, Jack T. Skinner, had been convicted 3 times over a period of 9 years, once of stealing chickens and twice of committing robbery with the aid of a firearm. The Supreme Court held that Mr. Skinner's forced sterilization was an unconstitutional violation of the Equal Protection Clause of the 14th Amendment because similarly harmful criminal offenses like embezzlement of the same amount were excepted from this particular penalty. The court applied strict scrutiny because the penalty involved irreparable harm to the individual, and because not being forcibly sterilized, a right which is basic to the perpetuation of a race, the right to have offspring, was a fundamental right. Rather like a First Amendment neutrality test, forcing one group of people to wear masks but not another group of similarly situated people suggests the presence of a 14th Amendment equal protection violation. However, the First Amendment neutrality test has the fundamental nature of the right built in, whereas the 14th Amendment equal protection test does not. Whether an equal protection clause claim is effective depends on how intellectually even-handed the judge is, the reason being cited for the unequal treatment, how blatantly unequal the treatment in question is, and, crucially, how self-evident or explicitly well-established in legislation or previous case law the suspect class or fundamental right involved are. As it turned out, when lockdowns, compulsory masking, and other COVID crisis orders were challenged under the 14th Amendment's Equal Protection Clause, most judges had no difficulty denying that any fundamental right was implicated. Schools were among the last holdouts maintaining mask mandates, making an equal protection claim seem a natural route when students posing no real risk from COVID were not required to wear masks in any other place they congregated. As a summer 2021 lawsuit brought by parents in New Jersey trying to protect their children from being forcibly masked in school put it, adults and children may sit in close-packed rows at an indoor stadium, at a movie theater, in restaurants, in houses of worship, may dance in large groups at weddings or other gatherings, may mass at political meetings or protests, may sit close together at public lectures or at indoor theaters or playhouses, may mix freely in libraries and a host of other locations, but school children are still subject to the full discipline of masking and other restrictive measures. But this lawsuit, as with multiple others filed by parents under the Equal Protection Clause, was capped at rational basis scrutiny and then dismissed. This was for 2 reasons. First, as Judge Kevin McNulty informed the New Jersey parents, school children do not constitute a suspect class. Second, the U.S. Supreme Court has not accepted education as a fundamental right which triggers heightened 14th Amendment scrutiny. In the Supreme Court's own words, nor have we accepted the proposition that education is a fundamental right like equality of the franchise, which should trigger strict scrutiny when government interferes with an individual's access to it. Thus, because the mask mandate does not target a suspect class or burden a fundamental right, it receives not strict scrutiny but rational basis review, said Judge McNulty as he dismissed the parents' equal protection claim. For some reason, Judge McNulty also felt the need to remonstrate, when faced by a common catastrophe like a pandemic, we must all make some sacrifices to protect ourselves and our more vulnerable neighbors. Parents in Georgia fared no better. Rational basis is the proper standard of review for the mask mandate. The mandate neither discriminates against a protected class nor infringes a fundamental right, said Judge Thomas Thrash in the Atlanta Division. When 2 parents in Nevada brought an equal protection challenge against their school's mask mandates because Governor Sisolak's emergency executive directives exempted counties under 100,000 population, Judge Jennifer Dorsey dismissed the parents' claim on rational basis analysis because population density is not a suspect classification requiring heightened scrutiny unless it has a disparate impact on an actual suspect class. After sticking in the knife, Judge Dorsey then twisted it by penalizing the parents' lack of legal expertise and awarding the school district $57,021 in attorney fees against the parents, saying plaintiffs' claims were legally frivolous. This award was particularly unjust because the recommendations for school mask mandates which Judge Dorsey ostensibly subjected to rational basis scrutiny largely came from the CDC, and by then the CDC's airline mask mandate had already been ruled arbitrary and capricious. I want to highlight that Judge Dorsey also cited Jen et al. And Budzin et al.'s contrived piece of trash CDC observational studies that we covered in the science section, characterizing the studies as overwhelming recent evidence that mask wearing in public schools reduces the spread of COVID-19. Even when the schools involved were private religious schools, courts insisted on using only rational basis scrutiny to evaluate and dismiss equal protection claims against compulsory masking. Michigan Department of Health and Human Services Director Robert Gordon issued mask mandates in 2020 which favored multiple activities over religiously motivated conduct in education by allowing people to remove masks for identification, communicating with the deaf or hard of hearing, giving a speech, voting at a polling place, or receiving a service for which temporary removal of the face covering is necessary. Writing in an incisive and thorough dissent at the appellate level against mooting a legal challenge to this mandate, Judge John K. Bush highlighted that exempted activities under the mandate included dining at a restaurant, dining with friends at a private gathering, receiving a haircut, tattoo, or massage, sessions in a tanning booth, or the installation of a nose ring. Yet when a religious private school, Resurrection School, argued that Director Gordon's masking orders provide exceptions for other activity and conduct that is similar in its impact and effects, but not for plaintiffs' constitutionally protected activities, District Judge Paul Maloney coolly dismissed the comparison by saying in so many words that the requirements of equal protection could somehow be met by the universal application of unequal exceptions. Plaintiffs argue that Director Gordon's orders violate the Equal Protection Clause because individuals may remove their face covering in some circumstances. Plaintiffs' argument here is conclusory and unpersuasive. There is nothing in the face mask requirement that treats similarly situated groups of individuals differently. Every person over the age of 5 must wear a mask when outside the home, and the exceptions apply universally. While the Equal Protection Clause of the 14th Amendment blunted authoritarian overreach in multiple areas during the COVID crisis, compulsory masking was not one of them. Equal protection claims that should have been viable in practice met with failure against compulsory masking and other overreaching measures. For example, restaurants that served alcohol were often given preferential treatment in lockdown orders over bars that served food, as though there was any meaningful difference in viral transmission risk. I am not aware of any cases where a direct equal protection claim against compulsory masking was successful, though I will be delighted if I am later proved wrong about this. On the other hand, equal protection claims against compulsory masking often suffered from the same incomplete development and explication that other claims against masking did, and an especially well-pled equal protection claim, backed up by the right factual circumstances, could still find success against compulsory masking in the future if put before an even-handed judge. As mentioned before, when it came to masks, getting to any sort of scrutiny was an achievement, and equal protection claims at least did routinely get to rational basis scrutiny. As we shall see later, mask mandates failed even rational basis type scrutiny when finally brought before an open-minded judge. Due process. And as Dershowitz agreed, it can't just be public health. Oh, you might be able to give COVID to someone. Well, that's never been our standard for forcing anything on anybody, for doing any quarantine. It has to be clear and convincing evidence that unless you take the vaccine, you pose a substantial risk of severe harm. And again, Dershowitz, big pro-vaccine guy, ultimately conceded that's the appropriate legal standard in this context. Attorney Robert Barnes, describing his public vaccine and quarantine debate with attorney Alan Dershowitz. Absent the involvement of other fundamental individual rights like freedom of speech or exercise of religion, the general right to wear or not wear a mask is housed in the Due Process Clause of the 14th Amendment, which guarantees two distinct but intertwined types of due process: procedural due process and substantive due process. The concept of due process recognizes that final outcome is not the only thing that matters. The process by which outcomes are achieved matters every bit as much. Procedural due process concerns the steps and procedures that the government has to go through before it can lawfully deprive a citizen of life, liberty, or property. In a nutshell, according to the U.S. Supreme Court, procedural due process imposes constraints on governmental decisions which deprive individuals of liberty or property interests within the meaning of the Due Process Clause of the 5th or 14th Amendment. The classic example of procedural due process is the trial by jury that is protected by the 6th and 7th Amendments. But administrative processes and procedures have also been ruled to satisfy this requirement, depending on the situation and interest at stake. At a minimum, procedural due process includes notice, an opportunity to be heard, and impartial adjudication prior to any infringement or deprivation of liberty. Also, the hearing and adjudication must be meaningful. If the outcome is predetermined and the hearing is a mere rubber stamp formality, the requirements of due process are not satisfied. Some Supreme Court rulings have implied that procedural due process also includes a general right to be free from official stigmatization. Substantive due process protects both the enumerated rights incorporated against the states and those unenumerated fundamental rights which the Ninth Amendment refers to, including the general right to liberty. In 1954, the U.S. Supreme Court stated, "Although the court has not assumed to define liberty with any great precision, that term is not confined to mere freedom from bodily restraint. Liberty under law extends to the full range of conduct which the individual is free to pursue, and it cannot be restricted except for a proper governmental objective. This includes common law rights and privileges." Substantive due process rights default to rational basis scrutiny, but the more fundamental the right, and the greater the infringement on it, the more scrutiny substantive due process requires, as when infringements on the right to marital privacy and the right to not be sterilized required strict scrutiny. What legally counts as a fundamental right for purposes of due process, however, is much narrower than the popular concept of what counts as fundamental. For example, under the 14th Amendment, police with the motto "to protect and serve" have no duty to protect. As one court put it, to succeed on a due process claim, whether procedural or substantive, a plaintiff must demonstrate that he or she possessed a constitutionally cognizable life, liberty, or property interest. During the COVID crisis, courts gave the least effective interpretations possible to claims that were trying to articulate the negative right to not have external artificial burdens unilaterally placed on one's breathing. According to COVID crisis judges presented with challenges to compulsory masking, the right to breathe oxygen without restriction is not a fundamental right. One judge dismissed a pro se challenge to compulsory masking by saying, "Certainly, being denied air may be actionable, but being denied the cleanest air readily available does not implicate a fundamental right." One would think this kind of reasoning would also rule out forcing masks on people in the name of source control, but that sort of consistency was too much to expect. The key for a 14th Amendment substantive due process claim to receive anything more than rational basis scrutiny requires that the rights asserted be deeply rooted in this nation's history and tradition, and implicit in the concept of ordered liberty. Substantive due process says that even if you are demonstrably mentally or physically ill, the government cannot simply deprive you of liberty by involuntary institutionalization, also known as involuntary commitment, or forcibly treat you against your will. Procedural due process says that even in those cases where involuntary institutionalization or compulsory treatment can possibly be justified, the state still has a burden of proof that it must meet before it can exercise its police power in the name of public health. In general, there are 3 levels of proof that procedural due process may require, depending on the infringement, and all of them require far more evidence than the rational basis standard used to uphold mask mandates. Involuntary commitment for psychiatric treatment, for example, is such an extreme deprivation of multiple fundamental liberties, and so close to imprisonment, that the state must show by a clear and convincing standard of evidence in civil judicial proceedings that the mentally ill person is enough of a substantial, imminent danger to themselves or others to justify the intervention of state police power. Especially important in a public health context, in 1980 the Supreme Court said that even in the case of convicted felons, the medical nature of the inquiry does not justify dispensing with due process requirements. Clear and convincing evidence is one tier down from the beyond a reasonable doubt standard procedural due process requires for criminal conviction. It is a tier above the simple preponderance of the evidence, i.e. 51% or better, standard for most civil proceedings, and a preponderance of the evidence itself is far above a mere rational basis. Compulsory masking violated both substantive and procedural due process in different ways, and it was one of the most pernicious of many such infringements during the COVID crisis. The right to privacy. The right to be let alone. The 14th Amendment also covers those facets of the right to privacy not protected elsewhere in the Bill of Rights. There is a long-standing common law right to be free from arbitrary government action, to be let alone. This foundational right undergirds the right of privacy in the same way that the fundamental right of self-defense undergirds the Second Amendment. In his joint 1890 essay with U.S. Supreme Court Justice Samuel Warren, The Right to Privacy, Supreme Court Justice Louis Brandeis elaborated on the deeply fundamental nature of this right to be let alone. The protection afforded to thoughts, sentiments, and emotions, expressed through the medium of writing or of the arts, so far as it consists in preventing publication, is merely an instance of the enforcement of the more general right of the individual to be let alone. It is like the right not to be assaulted or beaten, the right not to be imprisoned, the right not to be maliciously prosecuted, the right not to be defamed. According to Justice Brandeis and Justice Warren, this right to privacy, to be let alone, falls under the more general right to the immunity of the person, the right to one's personality. Keep in mind that in this context, personality does not simply refer to a person's character traits, mannerisms, and other characteristics, but also includes a person's physical, mental, and social qualities. The right to one's personality is part of the right of property in its widest sense, including all possession, including all rights and privileges. One of the conclusions that Justice Warren and Justice Brandeis drew was that the protection of society must come mainly through a recognition of the rights of the individual. Each man is responsible for his own acts and omissions only. Many Supreme Court rulings do not make sense in the absence of a broad and robust common law right to be let alone, and some reference this right directly. Just a year after Justice Warren and Justice Brandeis wrote their essay, the Supreme Court best summarized this fundamental common law right in an 1891 ruling against a mandated medical examination, which the Supreme Court quoted to reach a decision in 1990. No right is held more sacred or is more carefully guarded by the common law than the right of every individual to the possession and control of his own person, free from all restraint or interference of others unless by clear and unquestionable authority of law. As well said by Judge Cooley, the right to one's person may be said to be a right of complete immunity, to be let alone. In a 1928 case, Justice Brandeis wrote a dissenting opinion which referred to, as against the government, the right to be let alone, the most comprehensive of rights and the right most valued by civilized men. In his opinion, Justice Brandeis intertwined the right to be let alone with the right to privacy, because privacy is an indispensable component of the right to be let alone. In an important 1969 decision concerning both privacy and the First Amendment right to receive speech, the Supreme Court majority quoted Justice Brandeis' 1928 opinion at length after declaring, also fundamental is the right to be free, except in very limited circumstances, from unwanted governmental intrusions into one's privacy. That same year, in Tinker v. Des Moines Independent Community School District, which we discussed previously in the First Amendment symbolic speech context, the Supreme Court explicitly pointed out that, whatever the emotional impact produced by their message, some students wearing conspicuous armbands for the purpose of symbolic speech about the controversial Vietnam War produced no interference, actual or nascent, with the school's work or of collision with the rights of other students to be secure and to be let alone. In this same decision, the Supreme Court said, "Our whole constitutional heritage rebels at the thought of giving government the power to control men's minds." The right to either wear or refuse to wear a mask is part of an individual's right to privacy, to be let alone. Forcing citizens to cover their faces with cloth or some other material is a major infringement of the common law right to be let alone, and we have seen in our review of the science and psychology of masking how mask mandates insidiously grasped at the power to shift wearers' beliefs in a particular direction. The COVID crisis mindset tended to disparage the right to be let alone and the right to privacy as being trivial or somehow weaker or less absolute than explicit rights like the right to free speech. But this perspective was false and completely ignored a major point that objectors to compulsory masking were making. Both the right to be let alone and the right to privacy have objective existence. Both are broad and robust. Both are deeply rooted in America's heritage and are founded upon historical notions and federal constitutional expressions of ordered liberty. Both are recognized under the 9th and 14th Amendments of the United States Constitution and protected under the 14th. Both of them entail the broad right to not wear a mask, and both were flagrantly and repeatedly violated by mask mandates. Despite multiple courts' refusal to acknowledge or remedy these widespread violations of fundamental individual liberties, the real burden of proof was always on the authorities trying to mandate masks, and those authorities never truly met this burden. Compulsory masking is unquestionably a form of bodily restraint, and it has been used in various forms as a dehumanizing punishment for hundreds, if not thousands, of years. no clear and present danger of destruction of life or property can be reasonably thought to be inherent in the activities of every person who goes about unmasked, even when the Black Death or Spanish flu happen to be passing through a community. Substantive due process forbade compulsory universal masking. Procedural due process required, at a minimum, notice and an opportunity to respond and receive a meaningful hearing with impartial adjudication, requiring clear and convincing evidence that every individual being forced to wear a mask was a legitimate, imminent, and substantial clear and present danger, a standard of proof which no one pushing universal compulsory masking ever has or ever will be able to truly meet. Some courts have ruled that, when the state must act quickly or pre-deprivation process is impractical, and meaningful post-deprivation process is available, then due process is still satisfied. But in the case of compulsory masking, no meaningful post-deprivation process was ever available. People across the globe were forced to wear masks with zero pre-deprivation due process, no hearing, no real discussion, and the only arbitration was by decision-makers infected with political motivation and mass panic. During the COVID crisis, citizens were forced to sue for their most basic fundamental rights in hostile courts that were using all their judicial ingenuity to dismiss or rule against the claims being brought. And as with violations of other individual liberties during the COVID crisis, multiple courts were just as unwilling to recognize violations of individual due process rights. Those who sought meaningful post-deprivation due process were far more likely to be reprimanded and penalized for selfishly making the attempt in the first place. Green v. Alachua County. The U.S. Supreme Court explicitly referenced the connected rights to privacy and to be let alone in 1967. The protection of a person's general right to privacy, his right to be let alone by other people, is, like the protection of his property and of his very life, left largely to the law of the individual states. This reference to the right to be let alone being largely left to the individual states is important. The first major court win against compulsory masking in the United States came in state rather than federal court. This critical breakthrough lawsuit against masks was brought in Florida by attorney Jeff Childers on behalf of his client Justin Green in Green v. Alachua County. In 1980, the citizens of the state of Florida made a move that ultimately benefited everyone else in the United States when they explicitly enshrined the common law right to privacy and right to be let alone into Article 1, Section 23 of their state constitution. Every natural person has the right to be let alone and free from governmental intrusion into the person's private life except as otherwise provided herein. Still, when he took Justin Green as a client to challenge compulsory masking, Floridian lawyer Selden Jeffrey, Jeff Childers, knew he was facing an uphill fight, especially in an area as self-brainwashed when it came to masking as Alachua County. An experienced litigator with a flair for witty, consistently optimistic commentary, Childers focused with laser-like precision on getting the Alachua County mask mandate to the strict scrutiny he knew it warranted and could not survive. He anticipated the usual adverse results at the district court level and focused his efforts on setting up the inevitable appeal. Childers would later say of his appellant brief for this case, "I worked harder on that brief than just about anything in my career." Though he also put forward solid claims based on the county's lack of administrative authority to issue mask mandates, the Takings Clause of the Fifth Amendment, equal protection under the 14th Amendment, and the Due Process Clause of the 14th Amendment, Childers based his primary challenge in the right to privacy protected by the 14th Amendment and Florida Constitution. As anticipated, despite the explicit wording of Florida's Constitution, Childers' lawsuit met with the usual predetermined denial from Circuit Judge Donna Kime, who not only completely denied that masks had anything to do with speech and personal medical decisions, but said, "There is no broad legal or constitutional right to be let alone by government." "Not so," responded Childers in his appellate brief. "The Florida Constitution does provide for a right to be let alone, and the constitutional right of privacy is broad. Our Supreme Court said that the right to be let alone from the government is not only broad but also strong as it can possibly be." Childers directly quoted the Florida Supreme Court. The drafters of the Privacy Amendment rejected the use of the words unreasonable or unwarranted before the phrase governmental intrusion in order to make the privacy right as strong as possible. He then quoted the Florida Supreme Court again when it specifically affirmed, "The concept of privacy or right to be let alone is deeply rooted in our heritage and is founded upon historical notions and federal constitutional expressions of ordered liberty." Jeff Childers additionally dealt with another frequent objection that was raised by the trial court, the argument that privacy rights do not apply in public locations where masks were being required. The trial court stated without qualification that there is no recognized right to a reasonable expectation to privacy in a public location. It is true that some limited aspects of privacy rights do not apply in public settings. For example, one generally cannot forbid having one's picture taken when out in public except in areas where there is a reasonable expectation of privacy, such as a changing room. However, as Childers pointed out, even under the U.S. Constitution's 14th Amendment right to privacy, which is narrower than Florida's, the U.S. Supreme Court has held that, as when someone has a private conversation in a public telephone booth, what he seeks to preserve as private, even in an area accessible to the public, may be constitutionally protected. Americans do not lose all their privacy rights under either the U.S. Constitution or their state constitutions in public locations, especially not in Florida. Childers highlighted the fact that the Florida Supreme Court had already found that a right to privacy exists in public locations, and overturned unconstitutional laws accordingly. The Florida Supreme Court had previously found that even juveniles had fundamental rights to privacy which were unconstitutionally violated by curfew laws. Jeff Childers also pointed out that the Florida Supreme Court had already ruled a statute against mask wearing was unconstitutionally overbroad, and thus a violation of due process. To their lasting credit, Judges Adam Tannenbaum and Robert Long of the Florida First District Court of Appeal upheld the fundamental individual rights involved. The right to be let alone by government does exist in Florida, as part of a right of privacy that our Supreme Court has declared to be fundamental. The Supreme Court has construed this fundamental right to be so broad as to include the complete freedom of a person to control his own body. Judges Tannenbaum and Long, the panel majority, explained, "The Supreme Court has explained repeatedly that within the right to be let alone is a fundamental right to the sole control of his or her person. This right ostensibly covers an individual's control over, or the autonomy of, the intimacies of personal identity and a physical and psychological zone within which an individual has the right to be free from intrusion or coercion, whether by government or by society at large. As defined by the Supreme Court, Article 1, Section 23's guarantee of bodily and personal inviolability, which we are asked to follow, must include the inviolability of something so intimate as one's own face. A person then reasonably can expect to be free from governmental coercion regarding what he puts on it. Under a free government, at least, the free citizen's first and greatest right, which underlies all others, is the right to the inviolability of his person, in other words, the right to himself." The third panel judge, Joseph Lewis, dissented, objecting that the majority does not explain how requiring a person to wear a mask when interacting with the public during a pandemic is the equivalent of controlling the person's body. Judge Lewis' objection makes some sense if controlling someone else's body was limited to direct physical control, but such a narrow definition would only cover the worst and most outrageous forms of controlling someone else's body. The majority may not have articulated this point in detail because of how basic it was. Controlling a person's body is not limited to using another person as a literal puppet or physically restraining them. When using another person's body is unilateral or involuntary, as in involuntary servitude, a military draft, compulsory flag saluting, compulsory sterilization, compulsory blood or organ donation, or forcing someone else to make use of a medical intervention, compulsion and coercion become a matter of controlling the person's body, regardless of how delicately or subtly the control is exercised. It is one thing to prevent someone from taking a particular action, but forcing them to perform an affirmative action goes far beyond that. In this sense, forcing someone to perform an affirmative act, especially when it is done involuntarily for another's indirect benefit, as in the rationale for mandating masks, is a form of controlling the person's body. Refusing to wear a mask is a non-action that does nothing to control anyone else's body, but forcing someone to put on a mask against their will indisputably constitutes a manner of controlling their body, and a gross invasion of the physical and psychological zone within which an individual has the right to be free from intrusion or coercion. In June 2021, more than a year after Jeff Childers filed the initial complaint, the Court of Appeal ruled, "The single question that the trial court must answer is the likelihood that the mask mandate would survive strict scrutiny." The Alachua County mask mandate had, of course, zero chance of surviving strict scrutiny and was immediately struck down. Green v. Alachua County was a critical turning point against compulsory masking, and more successes were on the horizon. Masks are medical interventions using medical devices involving medical choices. One thing that everyone agrees on is that masks are medical devices. The FDA's face mask emergency use authorization letter on mask use by the general public as source control also included cloth masks as a subset. The line between medical treatments and medical devices gets pretty blurry at times, especially in the case of medical devices like removable prostheses that are also a form of treatment. Think dentures and prosthetic limbs, eyes, ears, and noses, etc. Many, if not most, medical treatments use medical devices, and most medical devices are used during medical treatments. Common descriptions of different medical devices refer to them as treatments. For example, the Mayo Clinic describes a ventricular assist device as a device that helps pump blood from the lower chambers of the heart to the rest of the body. It's a treatment for a weakened heart or heart failure. The similarities between masks and prostheses or other removable treatment devices, such as ventricular assist devices, insulin pumps, or feeding tubes, naturally led some plaintiffs and their attorneys to make a case that masks also fit into this category, that forcing someone to wear a medical device like a mask is a form of compulsory medical treatment. We have also seen in the psychology section of this book how compulsory masking functioned as a form of behavior modification, and behavior modification is a form of therapy, i.e., medical treatment. Judges, however, rejected the argument of masks as medical treatment because the purpose of masking was to prevent transmission rather than to actually treat any disease or disability. When faced with any claims against compulsory masking, especially 14th Amendment claims grounded in due process or the general right to liberty, the standard pro-mask response was to totally ignore every non-physical aspect of mask wearing, and many of the physical aspects, in order to conclude that compulsory masking is a minor permissible infringement because masks are not compulsory medical treatment, as though that fact somehow made forcing them onto people's faces more defensible. This reasoning underlay rulings like that of California Judge Cynthia Bechant. The requirement that an individual wear a mask in public within 6 feet of persons from other households during a pandemic is a far cry from compulsory vaccination, mandatory behavior modification treatment in a mental hospital, and other comparable intrusions into personal autonomy. The quality of judicial reasoning went downhill still further after that. One appellate court asserted, requiring facial coverings in public settings is akin to the states prohibiting individuals from smoking in enclosed indoor workplaces. It is true that a preventative protective intent underlay both mask mandates and smoking bans, but the analogy was superficial at best, and this sort of reasoning was typical. Because someone somewhere in a community had a particular virus, everyone's normal breathing suddenly became comparable to smoking. A process that everyone must perform every few seconds to avoid dying could be regulated like an unhealthy recreation that many people go their entire lives without partaking in, and broadly mandating an activity somehow became equivalent to prohibiting one. The argument that compulsory masking is somehow justifiable because masks are not medical treatment, however, is a total red herring. Just because a violation of individual liberty is not as egregious or outrageous as it can possibly be does not make it acceptable. Pointing out that compulsory masking is not medical treatment per se does nothing to prove that it is acceptable under the 14th Amendment guarantee of due process or any other amendment. Making use of any medical device is a medical choice. Receiving medical treatments and using medical devices are both medical choices. Masks are medical devices, and thus compulsory masking constitutes a coerced medical intervention, and this is what arguments that compulsory masking is a form of medical treatment were getting at. The unalienable individual right, the moral and legal requirement for informed consent in medical treatment, is just one manifestation of the generalized right of every individual to the possession and control of his own person. As we have seen, protective due process clause precedent goes back to Supreme Court decisions ruling against compulsory medical examinations held in private, which are far less invasive than forcibly covering another person's nose and mouth with anything in public. It is easiest to simply use the U.S. Supreme Court's own words to explain the link here. Under the common law of torts, the right to refuse any medical treatment emerged from the doctrines of trespass and battery, which were applied to unauthorized touchings by a physician. At common law, even the touching of one person by another without consent and without legal justification was a battery. Forcibly covering someone's nose and mouth against their will, whether by indirect coercion or direct force, clearly falls under this common law umbrella, even if the person can still breathe. Actual physical harm is not a requirement for battery to have occurred. Any unauthorized forced touching can qualify, even in a medical context. As U.S. Supreme Court Justice Brennan wrote in 1990, "The right to be free from medical attention without consent to determine what shall be done with one's own body is deeply rooted in this nation's traditions, as the majority acknowledges. This right has long been firmly entrenched in American tort law and is securely grounded in the earliest common law." Pointing out that masks are not medical treatment is rhetorical misdirection that ultimately does nothing to justify compulsory masking. Masks are a medical intervention using medical devices involving medical choices. They are a highly visible physical embodiment of unwanted medical attention and coerced medical decision-making, and a particularly invasive form of limited bodily restraint. Masks are a modified quarantine. What the courtroom debates over masks as a form of medical treatment did help to do was to clarify by process of elimination what compulsory masking actually is for the purposes of 14th Amendment due process analysis. The preventative and isolating nature of compulsory masking is an important clue. Masking is a modified quarantine, and this has major implications for both substantive and procedural due process. Used in its general sense, the word quarantine refers to any measure that separates, isolates, or excludes, especially for prevention of disease, and includes the more technical uses of both isolation and quarantine. 19th and 20th century legal rulings often use the term quarantine to refer to isolation for a disease, and it is not wrong to do so. However, in the most precise usage, isolation refers to separation because of a known active infection, whereas quarantine involves individuals who are only possibly infected. According to the CDC's 2023 definitions, isolation separates sick people with a quarantinable communicable disease from people who are not sick. Quarantine separates and restricts the movement of people who are exposed to a contagious disease to see if they become sick. As we shall see in more detail later, when defending its infamous travel mask mandate, the CDC claimed that its authority to impose masks came from 42 U.S.C. Section 264, Quarantine and Inspection, and categorized masks under quarantine in its basic website organization, www.cdc.gov/quarantine/masks/masktravelguidance.html. Quarantine and isolation are both drastic infringements on individual liberty, but if anything, quarantine impinges on the right to liberty more than isolation, because even though isolation is more stringent, it is based upon definitive knowledge of infection and ends upon recovery, whereas quarantine is based upon mere suspicion and theoretical possibility. As a 2007 legal review summarized, the more sweeping the proposed isolation or quarantine in terms of number and geographic scope, the more factual support, such as clinical evidence or expert testimony, will be required to illustrate the necessity and warrant the liberty intrusion. In many ways, quarantine is akin to a type of pretrial detention, but without even being accused of a crime. Even when historical inquiry is limited to the United States, the history of quarantine is replete with examples where quarantine power was misused and abused in ways that were more moralizing, prejudiced, and punitive than could be justified by any purely protective purpose. Very early in U.S. history, the U.S. Supreme Court specifically listed quarantine as being among the police powers of the states. After the 14th Amendment was passed, the Supreme Court broadly declared in 1885 that the 14th Amendment of the Constitution does not impair the police power of a state. In 1902, in an immigration context, the Supreme Court held that state quarantine power could even be used to exclude healthy persons from a quarantined area, rejecting a 14th Amendment due process challenge in order to do so. However, the actual analysis the Supreme Court used to dismiss the 14th Amendment claim in this particular case was superficial and conclusory at best. The 1902 court majority reasoned in a single three-sentence paragraph that because the regulation was lawfully adopted and enforced, any invalidation on due process grounds would strip the government, whether state or national, of all power to enact regulations protecting the health and safety of the people. Such reasoning would invalidate virtually every other Supreme Court decision issued before or since which has relied on the Due Process Clause to overturn an unconstitutional state law. Many lower courts took these Supreme Court rulings in combination with 1905's Jacobson v. Massachusetts as a virtual carte blanche to dismiss 14th Amendment challenges against a wide variety of laws and ordinances, including or especially in the area of quarantine and public health. In a ruling that would have overjoyed COVID crisis politicians and public health officials seeking to squelch freedom of speech, association, privacy, and every other inconvenient individual right imposing limits on their ability to act in the name of public health, the Supreme Court of Washington State declared without qualification in 1918 that the public health is the highest law, and whenever a police regulation is reasonably demonstrated to be a promoter of public health, all constitutionally guaranteed rights must give way, to be sacrificed without compensation to the owner. During World War I, the rationale of protecting military efficiency and public health from venereal disease was used as an excuse to forcibly examine and quarantine thousands of women, prostitutes and otherwise, arrested on charges of prostitution or vagrancy, more often than not denying or depriving them of their fundamental rights of due process while doing so. After all, according to officials, prostitution was antisocial conduct. Venereal disease was a social pathology, and soldiers infected with venereal disease cost taxpayer money for treatment. So what better way to combat this threat in the name of public health than with the involuntary detention of any unmarried woman, and some married women, suspected of having a venereal disease? As Alan Brandt noted in his History of Venereal Disease in the United States, vice raids fell most heavily on working-class women, the unemployed, and the unescorted. During World War I, the Army took stringent punitive measures against soldiers who caught a venereal disease, including assignment to labor battalions and special shaming quarantine camps. A sign that hung over the camp at Givre announced, "This is a venereal camp. These men are helping the Hun." Additionally, whether from prejudiced diagnosis, generally poor pre-enlistment health care, recruiting efforts that focused on more affected communities, or some combination thereof, black soldiers in the American Expeditionary Force were diagnosed with venereal disease at much higher rates than average, and were subjected to quarantine procedures that were unequally harsh. Directing public health authority against particularly stigmatized groups and diseases led to some truly outrageous and unconstitutional court rulings even outside of wartime. Unfortunately, the excessive judicial deference to public health authorities during the COVID crisis was not new. Historically, many courts have been far too deferential to public health authorities. In 1919, women with venereal disease in Kansas were forcibly quarantined at an industrial farm, while their male counterparts were confined in a part of the state penitentiary which had been turned over to public health officials, in all but name, imprisonment without trial for having a sexually transmitted disease. When some of the men in Kansas challenged their detention under the 14th Amendment, the Kansas Supreme Court simply declared that no evidence of disease was required beyond the say-so of a public health official. It reads like something straight out of the COVID crisis. It is stated that the petitioners are not diseased. The question is one of fact, determined by practically infallible scientific methods. The city health officer was authorized to ascertain the fact. He has certified to the existence of disease, and, in the absence of a charge of bad faith or conduct equivalent to bad faith on his part, his finding is conclusive. When the men objected that even if they were diseased and isolation was necessary, they could obtain proper treatment in an isolated place in the city of Topeka, Kansas, rather than part of the state penitentiary, the court responded glibly, "The public health authorities are not obligated to take chances." While courts in some states mustered the courage to step in and put a brake on the worst of these violations, courts in other states helped grease the wheels by denying that such violations were at all offensive to the U.S. Constitution. In 1922, Montana Supreme Court Chief Justice Brantley baldly asserted in a solo at Chambers ruling that when it came to public health, the provisions of the 14th Amendment to the Constitution of the United States, to the effect that no person may be deprived of his liberty without due process of law, have no application to the case of one detained in quarantine because affected with a dangerous communicable disease. This particular ruling was all the more outrageous because the dangerous communicable disease in question was gonorrhea, certainly not life-threatening and quite straightforward for any truly concerned members of the community to avoid. In a separate ruling that same year, the Supreme Court of Ohio revealed the usually unstated reasoning behind targeting STDs in the name of public health, as well as the general judicial recalcitrance against upholding the constitutional rights of the individuals involved. The protection of the health and lives of the public is paramount, and those who by conduct and association contract such disease as makes them a menace to the health and morals of the community must submit to such regulation as will protect the public. The history of these campaigns reveals that public health officials at the time were prone to the same sort of irrationalities, biases, self-contradictions, and pretextual thinking as during the COVID crisis. Most detention houses and quarantine hospitals where the women received treatment did not permit visitors. Public health officials justified this regulation on the premise that the women were under quarantine. This, despite the well-known fact that venereal diseases could not be communicated through the air. This coercive, condescending, medico-moral paternalism provided fertile intellectual soil for the social hygiene lead-up to Buck v. Bell within the next decade. Not to mention that the diseases in question were already, understandably, quite stigmatizing. Such draconian measures only provided sufferers with an even stronger incentive to do everything they could to evade detection, including foregoing treatment by physicians who might be required to report cases to public health authorities. As late as the mid-20th century, some courts were still articulating the doctrine that even though the Constitution is the highest law of the United States and state constitutions are the highest laws of each state, somehow local public health exceptionalism supersedes the rights guaranteed by both. In 1944, the Illinois Supreme Court ruled, "Constitutional guarantees must yield to the enforcement of the statutes and ordinances designed to promote the public health." The California 2nd District Court of Appeals put it just as bluntly in 1966. Even drastic measures for the elimination of disease, whether in human beings, crops, or cattle, in a general way are not affected by constitutional provisions, either of the state or national government. In 1977, citing Jacobson v. Massachusetts, of course, the Fifth Circuit ruled in a case out of the Eastern District of Texas that a state should not be required to provide the procedural safeguards of a criminal trial when imposing a quarantine to protect the public against a highly communicable disease. One of the most egregious cases occurred in 1948, when the California 3rd District Court of Appeal went so far as to uphold an involuntary quarantine of women suspected of carrying unspecified venereal disease even after medical examinations by independent doctors came back negative for infection. Moreover, the women in question were forcibly quarantined in an overcrowded jail with prisoners accused of crimes at double the prescribed cell occupancy and 4 to a bed. The fact that any court was willing to permit this highlights the de facto quasi-criminal nature of public health quarantine, which, without admitting it, illicitly stripped targets of due process protections they possessed under the 4th, 5th, and 6th Amendments when accused of far more serious crimes than being sick. As during the COVID crisis, the fact that public health officials and law enforcement repeatedly got away with such self-evidently demented measures as forcibly crowding more people into smaller spaces in the name of preventing disease transmission reveals the irrationality, undue deference to authority figures, and pathological disregard for basic individual rights that repeatedly manifest like a chronic infection in the context of public health quarantine measures. Even so, as during the COVID crisis, there were judges who issued rulings that pointed in a far more constitutional direction. In the 1948 California case described above, presiding Justice Adams wrote in a lengthy and scathing dissent that a mere suspicion, unsupported by facts giving rise to reasonable or probable cause, will afford no justification at all for depriving persons of their liberty and subjecting them to virtual imprisonment under a purported order of quarantine. In his dissent, Justice Adams cited more than half a dozen previous cases demonstrating that the burden of proof in quarantine cases did not lie with the person being quarantined to show that they were not infected or infectious, but rather lay with the health officer to show probable cause of an infectious threat to public health. Justice Adams also affirmed that traditional rules of evidence and presumption of innocence should apply, calling much of the evidence purporting to justify the women's quarantine hearsay of the rankest kind. He additionally cited other cases where petitioners seeking relief against involuntary quarantine used habeas corpus to secure their release. Justice Adams concluded, even a prostitute is entitled to the protection of those fundamental principles of liberty which are the basis of our civil and political institutions, and the zeal of an officer ought never to be permitted to transcend the constitutional rights of an accused. Even the majority in this case conceded that, at a minimum, health officers had to have probable cause to believe an individual was infectious before they could impose an involuntary quarantine. The terminology used here is telling because police officers require probable cause rather than mere reasonable suspicion in order to make an arrest, and the justices clearly used this as a frame of reference when referring to public health quarantine. Judges like Justice Adams were not always in the minority. The Ninth Circuit struck down an openly race-based involuntary quarantine in San Francisco on equal protection grounds in 1900. In 1919, the Iowa Supreme Court asked rhetorically whether, even assuming involuntary quarantine is a wise and valid exercise of the police power for the general good, does it follow that a person not known to be so diseased, and, so far as here appears, showing no visible evidence, sign, or symptom of such disease, may be subjected to arrest, imprisonment, and violation of his person for no better reason than that he is suspected by someone whose identity is not revealed to be diseased, and to satisfy the Board of Health or some of its officers whether there is, in fact, any ground for such suspicion? The Iowa Supreme Court answered this question with a resounding negative. Mere suspicion of disease was nowhere near enough to justify minimizing the ordinary rights of a person which law and the usages of civilized life regard as sacred. At the very least, said the court, the use of any such invasive powers against a person can only be granted by the state legislature, which must do so expressly. On top of that, the Iowa Supreme Court drew the analogy that was studiously avoided by courts faced with Fifth Amendment claims during the COVID crisis, likening a man suspected of a crime to a man suspected of infection. Even when charged with the gravest of crimes, he cannot be compelled to give evidence against himself, nor can the state compel him to submit to a medical or surgical examination, the result of which may tend to convict him of a public offense. And if there be any good reason why the same objection is not available in a proceeding which may subject him to ignominious restraint and public ostracism, it is at least a safe and salutary proposition to hold that, before the courts will uphold such an exercise of power, it must be authorized by a clear and definite expression of the legislative will. In our judgment, the restraint of the petitioner, not as a diseased person, but solely as a suspect, and for the avowed purpose, in search of evidence of a loathsome disease which may or may not exist, is a deprivation of his liberty without due process of law, and he is entitled to be set free. We saw earlier in this book how forcing a mask onto someone's face was historically an especially ignominious form of restraint, even when used against slaves and accused terrorists, and it is also indisputable that during the COVID crisis, masking publicly gave symbolic evidence of disease, ostracizing all wearers from one another. In 1921, a three-judge panel in the California 2nd District Court of Appeal unanimously ordered that a woman held in an involuntary quarantine be released at once, holding that, paying just regard to the constitutional guarantees of the right to personal liberty and personal security, it must be asserted that more than a mere suspicion that an individual is afflicted with an isolable disease is necessary to give the officer reason to believe that such person is so afflicted. Despite the wide variance in earlier rulings, over the latter half of the 20th century, individual civil rights protections in the context of infectious disease quarantine law began to gradually accrue the components of a potential renaissance through the secondary effects of mental health and disability legislation and the resulting case law. Despite the fact that the U.S. Supreme Court has never ruled on the specifics of what the 14th Amendment Due Process Clause requires when individuals are involuntarily quarantined for a communicable disease, the court has addressed specific due process requirements in other medical contexts like mental health. The U.S. Supreme Court made rulings with indirect but substantial effects on quarantine case law in the 1970s and again in 1987. Two important Supreme Court cases, O'Connor v. Donaldson, 1975, and Addington v. Texas, 1979, involved 14th Amendment due process challenges to involuntary public health interventions for mental illness. In O'Connor v. Donaldson, a mental patient, Kenneth Donaldson, was confined to a mental health institution against his will for 15 years simply because he was diagnosed as mentally ill, with no findings that he was a danger to either himself or to others. Donaldson was not released until he finally got his case before a jury in civil proceedings, and to its credit, the jury awarded him damages. In O'Connor, the Supreme Court held that a finding of mental illness alone cannot justify a state's locking a person up against his will and keeping him indefinitely in simple custodial confinement. To anyone who lived through the lockdowns and compulsory masking of the COVID crisis, the Supreme Court's description of Donaldson's confinement sounds uncomfortably familiar. A simple regime of enforced custodial care, not a program designed to alleviate or cure his supposed illness. 4 years later, in Addington v. Texas, the Supreme Court clarified that before someone with mental illness can be quarantined from society against their will, due process requires clear and convincing evidence in civil proceedings that they are dangerous to themselves or others. The nation's highest court essentially used the same process of elimination familiar to anyone who has ever taken a multiple-choice test. Since it did not want to create any new standards for burden of proof, the U.S. Supreme Court was faced with 3 existing standards it could choose from. These were, in ascending order, a preponderance of the evidence, clear and convincing evidence, and beyond a reasonable doubt. The court reasoned that given the uncertainties of diagnosis and the other existing administrative safeguards against indefinite civil confinement, beyond a reasonable doubt was too hard of a burden for the state to meet in non-criminal proceedings. But it also reasoned that the preponderance of the evidence standard used in most civil proceedings did not adequately protect the critical individual rights involved. The only remaining choice was the clear and convincing standard of evidence, greater than a 51% preponderance of the evidence, but less than a 99% beyond a reasonable doubt. The impact of the Supreme Court's rulings in O'Connor and Addington extended beyond the mental health context. Multiple lower courts have applied the Supreme Court's Addington ruling to isolation for airborne respiratory infectious diseases like tuberculosis. In 1980, the West Virginia Supreme Court recognized that the involuntary isolation procedures of the West Virginia Tuberculosis Control Act and West Virginia's involuntary commitment procedures for mental health imposed the same deprivations of individual liberty using the same fundamental rationale of public health and safety. Consequently, the state court ruled that the established due process requirements for mental illness must also be applied to corresponding measures taken in the name of controlling infectious disease. The court required the public health officials to either release the plaintiff they were holding in quarantine against his will or show by clear, cogent, and convincing evidence in another hearing, a hearing where the plaintiff had to be provided the benefit of legal counsel, that he was actually infected and the health menace to others that they alleged. The New York Supreme Court ruled likewise in a 1999 case based on identical reasoning. The United States District Court for the Southern District of New York revisited the question yet again in 2003 with the same results. The Supreme Court, in the civil commitment cases, has set constitutional standards that must be met before an individual can be detained. The central requirements set out by the court are the right to a particularized assessment of an individual's danger to self or others and the right to less restrictive alternatives. Accordingly, the fact that an individual has active tuberculosis does not itself justify involuntary detention. The Supreme Court in Addington v. Texas 441 U.S. 418, 1979, held that to meet due process demands in a civil commitment proceeding, the standard of proof used must be greater than a preponderance of the evidence. In 1987, the U.S. Supreme Court further contributed to the refinement of infectious disease case law when it ruled that a person who is handicapped because of a disease is not removed from existing legal protections against discrimination based on disability simply because that disease happens to be contagious. The court made clear that disability protections would not require a school board to place a teacher with active contagious tuberculosis in a classroom with elementary school children. Rather, what disability protections would require was that prejudice, stereotypes, or unfounded fear be replaced with an individualized assessment and quantitative fact-finding, including possible reasonable accommodations and analysis of the actual risks involved. This ruling was effectively codified into the Americans with Disabilities Act of 1990, ADA. In 1993, New Jersey Superior Court Judge Donald S. Goldman authored what was probably the most conscientious analysis in this series of cases to date. He incorporated previous involuntary commitment case law, as well as the Supreme Court's 1987 ruling and the ADA. Judge Goldman concluded that a person with contagious tuberculosis could be involuntarily committed to hospital quarantine or isolation on the condition that the standards and procedures applicable to involuntary civil commitments must be followed. He proceeded with special care in his legal analysis because he recognized that the claim of disease in a domestic setting has the same kind of power as the claim of national security in matters relating to foreign policy. Both claims are very powerful arguments for executive action. Both claims are among those least likely to be questioned by any other branch of government, and therefore subject to abuse. The potential abuse is of special concern when the other interest involved is the confinement of a human being who has committed no crime except to be sick. Judge Goldman concurred with the West Virginia and New York courts that the closest legal analogy is provided by court cases that have reviewed the constitutionality of state statutes permitting the involuntary commitment of mental patients on the basis that they have a disease that causes them to be dangerous. Importantly, illness cannot alone be the basis for confinement. Accordingly, the ADA and its regulations require that a health officer seeking to infringe upon a diseased person's liberty by imposing detention, confinement, isolation, or quarantine must first establish by clear and convincing evidence that the person poses a significant risk of transmitting disease to others with serious consequences. The court is obligated to scrutinize the evidence before determining whether the government's justifications reflect a well-informed judgment grounded in careful and open-minded weighing of the risks and the alternatives, or whether they are simply conclusory statements that are being used to justify reflexive reactions grounded in ignorance or capitulation to public prejudice. Thus, proof that this specific person, and not similar persons, poses a significant risk to others, a risk that may not be merely speculative, theoretical, remote, or even elevated, is required. In his ruling, Judge Goldman only applied this analysis to those measures which the plaintiff in his case actually challenged, to involuntary hospitalization and quarantine. He did not extend it to any other measures imposed on the plaintiff. This is made clear by his casual remark that the plaintiff's right to outdoor activities may have to be curtailed if he refuses to wear his mask. This blemish does not, however, change the overall substance of the ruling, and even Judge Goldman's offhand mask comment mitigates against universal compulsory masking because he was referring to a single individual who had been definitively diagnosed, was known to be infectious, and does not seem to have ever formally challenged whatever individualized masking requirements the hospital may or may not have been considering. Had the plaintiff chosen to challenge any masking requirements at the time Judge Goldman handed down his decision, there was already ample, clear and convincing evidence, including Dr. Tuneval's studies conducted in hospital operating rooms, which we reviewed in Part 1, showing that masks do not reduce even bacterial transmission. On top of this, the risk of respiratory disease transmission outdoors has always been negligible, and this fact was reaffirmed by universal experience during the COVID crisis. The bottom line of Judge Goldman's 1993 ruling was that even in the context of an infectious, long-lasting, and historically deadly respiratory disease, the decisive consideration where personal liberty is involved is that each individual's fate must be adjudged on the facts of his own case, not on the general characteristics of a class to which he may be assigned. Consistently applied, this would completely preclude compulsory universal masking. A person who is not even infected cannot be subjected to any form of indefinite compulsory quarantine because there is zero risk of them transmitting a pathogen that is not even present in their body. Even if someone did have an infectious respiratory disease, compulsory masking could still not be imposed because the clear and convincing balance of scientific evidence regarding masks is that they have no statistically significant benefits when it comes to decreasing the transmission of pathogens. The above cases are helpful comparisons, but they are not perfect analogies to masking for COVID because they involved individuals who were demonstrably infected with a contagious respiratory disease. One legal analysis in the Buffalo Law Review summed up the implications nicely in 2007. Obviously, a suspected case, contact, or carrier should be afforded greater procedural protection than a diagnosed case, contact, or carrier. The length of a quarantine is not supposed to exceed the period of incubation and communicability for the disease in question. Inflicting an indefinite, involuntary, modified quarantine like compulsory masking on whole age groups or the entire population of a state covering thousands of square miles simply because a few dozen out of every 100,000 have a particular communicable disease ought to have been unconscionable under any ethic, medical or otherwise. During the COVID crisis, the rules lawyer method of getting around this basic common sense limitation was to either ignore it or to declare that anyone in the area of quarantine automatically counted as having been exposed, and then define the entire community as the area of quarantine. Every time a new infection in the community-wide area of quarantine occurred, the quarantine timer restarted. Sweet, simple, self-perpetuating. No way out. Politicians and public health officials during the COVID crisis added the further innovation of denigrating and denying pre-existing or naturally acquired immunity, so even full recovery from COVID was not enough to end the masking quarantine. Unfortunately, legal challenges to compulsory quarantine are relatively rare. Quarantines tend to be imposed against a background of great fear when public health officials are at their most powerful and courts are at their most deferential. Few plaintiffs have the legal savvy, time, or funding to initiate challenges. Health officials acting in their official capacities have qualified immunity. Remedies like the right of habeas corpus do not provide for damages, and even when damages are theoretically attainable, they are almost unheard of in practice. The short duration of quarantines also makes legal challenges perpetually vulnerable to dismissal for being moot. There is, additionally, the chronic chicken and egg problem that constitutional challenges to quarantines are dismissed on the grounds that no clearly established constitutional rights have been violated, but the constitutional rights cannot be clearly established in the absence of previously successful challenges. One individual who found herself willing to pursue such a challenge was Nurse Casey Hickox. In 2014, Ms. Hickox worked as a medical team treatment leader for Doctors Without Borders, helping to care for Ebola victims in Sierra Leone. As a reward for a month of this selfless service, upon arrival in the United States, she was immediately detained by New Jersey public health officials and held in an isolation tent with a portable toilet and no shower for 80 hours despite an absence of signs or symptoms. When she was finally released and driven straight to her home in the state of Maine by EMTs, Nurse Hickox immediately had to fend off Maine's public health officials. Maine's Department of Health and Human Services tried to subject Ms. Hickox to onerous and restrictive requirements that everyone who lived through the COVID crisis is intimately familiar with. Among other things, they asked the district court to virtually eliminate Ms. Hickox's ability to travel or leave the immediate vicinity of her house, to deny her all access to congregate public places such as shopping malls, movie theaters, and her workplace, and to require her to maintain a 3-foot distance from others when in non-congregate public activities like walking or jogging in a park. The fact that a 3-foot distancing requirement for Ebola progressed to a 6-foot distancing for COVID in just 6 years highlights the noxious tendency towards safety creep present in public health, as well as the lack of any real evidence behind many of the ritualistic and appearance-driven interventions. Fortunately for Nurse Hickox, District Court Chief Judge Charles C. Laverdiere had not succumbed to the popular hysteria surrounding Ebola. Judge Laverdiere held a hearing without delay, and clearly worked long past normal business hours to review all the competing parties' submissions before the hearing. His final common-sense court order effectively freed Hickox, simply requiring direct active monitoring and instructions to immediately notify public health authorities if any symptoms of Ebola appeared during the possible incubation period. In an example of what true public health transparency looks like, and which organizations like the CDC should have learned from, since Ms. Hickox waived her right to confidentiality, Judge Laverdiere ordered that all filings, orders, and hearings in this matter shall be open to the public. Casey Hickox filed 4th and 14th Amendment claims as well as tort claims challenging the lawfulness of her involuntary quarantine in New Jersey. Her case, however, had the bad fortune to be assigned to the same Judge Kevin McNulty who would later uphold compulsory masking for New Jersey school children against a 14th Amendment equal protection challenge in 2021. In Nurse Hickox's case, Judge McNulty held that the previous civil commitment cases were not directly relevant enough to clearly establish the same due process rights in quarantine cases. He also held that following the CDC's cookie-cutter matrix for evaluating risk and taking Nurse Hickox's temperature was enough to meet the requirements of individualized assessment for purposes of quarantine, and that the public health officials had probable cause to support Hickox's continued involuntary detention even after her blood work came back negative for Ebola. As for the idea that suspected cases should be accorded more due process rights than diagnosed cases, Judge McNulty arrived at the opposite conclusion, based on the rationale that quarantine is a shorter detention, and shorter detentions require less compelling evidence of dangerousness. By that reasoning, shorter prison sentences could somehow justify a lower standard of evidence for criminal conviction, or shorter involuntary mental health commitments could justify less than the Supreme Court's clear and convincing evidence standard. As a Nebraska Law Review article put it, the government may not intend for a quarantine to be punitive, but quarantine is nonetheless punitive. In fact, parolees in revocation hearings are afforded more procedural due process rights than a person facing quarantine, even though the former has been convicted of a crime. Casey Hickox was far from the only one subjected to onerous quarantine without due process, and neither Casey Hickox nor any of the more than 233 Americans subjected to quarantine or de facto quarantine in the name of Ebola ever contracted the disease. Casey Hickox's experience was a warning, but not a warning about disease or the need for a stronger public health establishment. Just 4 years after her case concluded in 2016, the 2020 COVID crisis brought every questionable ruling and unresolved issue of quarantine back to the forefront with a vengeance. Austin et al. V. the Board of Education of Community Unit School District No. 300. Casey Hickox's lawsuit contesting the due process violations of her quarantine failed, but as a result of the 2014 Ebola scare that led to Casey Hickox's experiences in New Jersey, the Illinois Department of Public Health, IDPH, updated its regulatory definitions to distinguish quarantine modified from quarantine isolated, and ensure due process protections for both. The definition of quarantine modified, which Illinoisans had due process rights to object to, included procedures and devices intended to limit disease transmission. The due process requirements for quarantine required that, among other things, no person shall be ordered to be quarantined or isolated except with the consent of the person or upon the prior order of the court of competent jurisdiction. Procedures falling under the definition of quarantine included tests, vaccines, and exclusion from school. Quarantine devices obviously included masks intended to limit disease transmission, as smart lawyers and parents who reviewed the official definitions quickly grasped. In February 2022, 8 months following the pivotal Florida ruling in Greene v. Alachua County won by Jeff Childers, Illinois Judge Raylene Grishow issued what was not only one of the best mask-related rulings of the whole affair, but also one which stands among the best rulings in the long history of tension between quarantine and due process in general. Once again, as in so many other places, the instigating lawsuits were brought on behalf of hundreds of parents seeking to protect their children from abuse by compulsory masking in schools. Judge Grishow's ruling consolidated not just one but 4 such lawsuits, the largest of which was spearheaded by attorney Thomas DeVore. Of course, during the COVID crisis, it was too much to expect that public health authorities would play fair and keep to their own rules when those rules started to work against them. With the incoming wave of litigation hitting and about to hit, the Illinois Department of Public Health executed the classic COVID crisis public health play of shifting the goalposts. Almost a year and a half into 2 weeks to flatten the curve, in September 2021, the IDPH deleted or changed its definitions of quarantine to shut down this avenue of recourse for due process, citing, what else, the emergency. Viable legal challenge was no doubt an emergency as far as the IDPH was concerned. The emergency was so urgent that the IDPH even decided to skip such trivial formalities as the legally required rulemaking process. Judge Grishow, however, was not among the many judges who let their state's public health agencies get away with such underhanded methods. Strictly speaking, as in Jeff Childers' Florida lawsuit challenging masking under the right to privacy, the Illinois school masking case was decided on grounds of state law rather than the United States Constitution, but the same is true of many quarantine cases implicating and upholding constitutional rights, and the principles involved went straight to the heart of the due process guaranteed by the 14th Amendment, as well as the separation of executive and legislative powers. Judge Grishow was unequivocal. The legislature has made it clear that citizens have individual due process rights, specifically the due process right to object to being subjected to quarantine, vaccination, or testing which is alleged to prevent the spread of an infectious disease. This court finds that masks are also a device intended to limit the spread of an infectious disease, and as such is a type of modified quarantine. Plaintiffs have a protectable interest to not be subjected to any mandates by the Governor, Illinois State Board of Education, or the school districts which interfere with the due process protections provided to plaintiffs under the IDPH Act in regard to masks as a type of quarantine, as well as vaccination or testing. A year and a half into 2 weeks to flatten the curve, Judge Grishow did not find the government arguments that due process should not apply because pandemic to be persuasive. Had our legislature intended that the various due process provisions, as argued by the defendants, were not to apply, the legislature would have specifically done so. The legislature certainly has had time to make any amendments. Judge Grishow's decision also touched on the equal protection issues that other judges had refused to acknowledge. When the legislature created our laws, they did so knowing individuals have a fundamental right to due process when one's liberty and freedom is taken away by forcing them to do something not otherwise required of all other citizens. Judge Grishow recognized that continued deprivation of due process through compulsory masking met the criteria for an irreparable injury. Her evaluation described millions of Americans and even more millions of people across the world. To demonstrate irreparable injury, the moving party need not show an injury that is beyond repair or compensation in damages, but rather need show only transgressions of a continuing nature. The court finds the plaintiff's legal rights to procedural and substantive due process are being sacrificed each and every day, especially when there has been zero evidence that those children are contagious or highly likely to spread a contagious disease. Due process of law is a guaranteed right to the plaintiffs under the Illinois Constitution and has been specifically codified for circumstances such as these. There is no adequate remedy at law because the loss of the continuous sacrifice of legal rights cannot be cured retroactively once the issues are decided on the merits. Where injuries are of a continuing nature, remedies at law are inadequate and injunctions should be imposed. There is no remedy available after trial in this case which would compensate these plaintiffs for the harm caused them by being forced to accept the masking mandate, which this court finds are, by definition, a type of quarantine, as well as the vaccination or testing policies being lodged against plaintiffs at the whims and caprice of the defendants, all without any procedural or substantive due process rights to object. It is worth noting here that at least one Ohio court ruled against compulsory masking on the assumption that masks are not a form of quarantine. In the summer of 2020, Ashland County Health Commissioner Heather Reffitt was threatening the food service licenses of restaurants that were unwilling to force masks onto their customers and employees. On July 15th, Commissioner Reffitt summarily revoked the food service license of Cattleman's Restaurant in Savannah, Ohio, claiming its unmasked employees were an immediate danger to public health, and insisting that face coverings must be worn at all times unless exceptions apply. With the aid of attorney Maurice Thompson of the 1851 Center for Constitutional Law, Cattleman's restaurant owner Mandy Close sued for injunctive relief on grounds of due process. Though, as with the Illinois case, this Ohio case challenging masking was not, strictly speaking, a constitutional challenge, the resultant due process ruling by Judge Ronald P. Forsthoeffel was one of the bright spots to come out of the early months of COVID panic. Judge Forsthoeffel started by applying the sort of common-sense skeptical inquiry studiously avoided by many of his peers. If the Dine Safe Ohio order recognizes exceptions to a blanket mask-wearing rule, and as such would not consider the lack of wearing a mask an immediate danger to public health, then it begs the question as to whether the failure to wear a mask for any reason could ever constitute or serve as the basis for finding an immediate danger to public health. The court further finds that plaintiffs have been denied a meaningful right to appeal and are therefore being denied their civil liberties, including the right to earn a living and operate a commercial enterprise, without due process of law. Apart from his refreshing affirmation of the right to earn a living and operate a commercial enterprise, which was run roughshod over during the COVID crisis, Judge Forsthoeffel discovered that the health authorities' actions had violated Ms. Close's rights to procedural due process from start to finish. No advance notice of violation, no order of corrective action, and no meaningful right to a hearing was afforded plaintiffs prior to revocation of their food service license. The progress of time did not improve the county health department's case either. In his April 2021 judgment, issued 9 months later after an extensive individualized assessment, Judge Forstoffel found that there was no meaningful evidence presented to this court to support a finding that the license revocation without a meaningful opportunity for hearing was based on an immediate danger to public health. Judge Forstoffel's ruling also contains one of the earliest judicial acknowledgments that the totalitarian and unconstitutional measures imposed in the name of public health did not work. The orders at issue in Erie County, Lake County, as well as the Dine Safe Ohio order in this case, fail to accomplish anything scientifically demonstrable or otherwise corroborated with empirical data to prevent the spread of contagious or infectious disease even if that purpose were authorized. Judge Forstoffel found that the invasive compulsory masking promulgated by the health department was not, in fact, authorized by law because the governing statute did not grant the director of the Ohio Department of Health and its subsidiary health authorities the power to issue or enforce any and every action to prevent the spread of infectious disease. Rather, the Ohio Department of Health only has ultimate authority in matters of quarantine and isolation. In other words, even taking the position that masks are not a form of quarantine, health authorities still do not have the authority to mandate masks unless they are expressly given that power by the state legislatures. And even if those powers were to be granted by the legislature, statutory due process protections must still apply. However, because masks are, in truth, a form of modified quarantine, due process protections that are even more fundamental apply. Either way, due process was and remains a real obstacle to universal compulsory masking, even when the 14th Amendment stays hidden in the background. Unless and until a dedicated medical freedom amendment to the U.S. Constitution is passed, the general right to not wear a mask apart from the protections for speech, religion, or any other affected fundamental right will remain part of the general right to liberty housed within the Due Process Clause of the 14th Amendment. The right to due process puts the burden on public health officials to show by clear and convincing evidence in an individualized analysis that the person or persons they are seeking to forcibly quarantine pose a direct threat with significant risk to others' health. In summarizing the body of pre-COVID legal scholarship on quarantine, a 2018 article by Professor Wendy Parmet, published in the Wake Forest Journal of Law and Policy, said, "The scholars who participated in this discussion disagreed about many points, but for the most part they agreed that the precedent that existed established that the quarantine power, although broad, is subject to significant constitutional restraints. At a minimum, these include the requirement that quarantine be imposed only when it is necessary for public health or is the least restrictive alternatives, and only when it is accompanied by procedural due process protections including notice, the right to a hearing before an independent decision-maker either before or shortly after confinement, the right to counsel, and the requirement that the state prove its case with clear and convincing evidence." As we saw in Part 4 of this book, prominent public health law professor Lawrence Gostin went full totalitarian for universal compulsory masking and vaccination during the COVID crisis. However, prior to authoring the Model State Emergency Health Powers Act in 2001 and his transition into a self-described sanitarian and collectivist, Professor Gostin's earlier scholarly work from the 1990s contained much excellent due process analysis of individual rights in the context of quarantine, as well as guidelines for the legalities of public health that ought to have been applied in the context of COVID, starting with the principle that public health statutes should be based on provisions that apply equally to all communicable diseases. This would have meant not treating COVID as some special threat that warranted throwing all previously established public health practice, scientific evidence, and essential individual liberties out the window. Prior to the COVID crisis, Professor Gostin stated, "The burden of proof should fall on the entity seeking to demonstrate significant risk." So, how do you determine when a risk is significant? Depending on who uses it, significant can be a real weasel word. In scientific studies, it is conventional to say that a finding is statistically significant when there is a less than 5% chance that the finding could have occurred by random luck. But the everyday and legal usage of the term significant is much more flexible, and is typically relative to some unstated gut-level standard of comparison. In the absence of hard numerical cutoffs somewhere in the standard, the final determination of whether or not a particular risk counts as significant says as much or more about the decision maker's individual situation, internal psychology, priorities, fears, and sacred values as it does about the risk they are evaluating. Psychological studies have shown for decades just how manipulable our sense of which risks are significant can be when making decisions, and the COVID crisis weaponization of behavioral psychology illustrated this truth on a global scale. If some hazard is terrifying enough, a less than 1 in a million risk can suddenly become significant. If some objective is desirable enough, a virtually guaranteed risk can suddenly become insignificant. In theory, the flexibility of the significant risk standard helps decision makers tailor responses to new or rapidly changing circumstances. But when people with the power to decide what counts as significant get scared or develop conflicts of interest, the standard becomes far more of a liability than an asset. The significant risk standard itself becomes a significant risk. It is helpful to start with a process of elimination. All significant risks are non-zero risks, but significant risks make up only a small subset of non-zero risks. Significant risks are, by definition, less than 100% certain. As 1990s Professor Gostin says, significant risk is not a remote risk, possibly not even an elevated risk. There must be a material, real, or substantial possibility that the disease can be transmitted. Risks that are remote, trivial, speculative, or theoretical are not significant. A slight or unlikely risk can still be significant, but most are not. Whether a slight risk is significant depends on how catastrophic the harm being risked is. The more treatable a disease is, the more transient, the harder it is to spread, the easier it is to detect and avoid, and the lower its infection fatality rate, the less significant is any risk associated with transmission. A 1% chance of a parachute not opening or of getting cancer from a one-time activity would be significant to most people, but a 10%, 20%, or even 30+% chance of catching a cold in any given year is not significant, even though there is no cure for a cold other than to recover the traditional way. I would agree with 1990s Professor Gostin when he writes, "Perambulation by people with the flu may be impolite, but it is not a major health threat." This remains true even though cold and flu viruses can and do act as the final disease that carries many people away each year. And I think most other people, would agree with 1990s Professor Gostin that significant risk must be determined on a case-by-case basis, and not under any type of blanket rule, generalization about a class of disabled persons, or assumptions about the nature of disease. This requires a fact-specific, individualized inquiry, resulting in a well-informed judgment grounded in a careful and open-minded weighing of risks and alternatives. A specific determination must be made that the person is in fact a carrier of a communicable disease, and that the disease is readily transmissible in the environment in which he or she will be situated. 1990s Professor Gostin also had some recommendations regarding coercive health measures. Specifically, statutes authorizing coercive health measures should include due process protections, both to protect individuals from unjustified restrictions on their liberty and to prevent erroneous or careless fact-finding by health officials. He affirmed that some narrow emergency exceptions could be justified, but once compulsory powers have been utilized, however, statutes should provide for an immediate hearing, a showing of current infectiousness, and evidence of the need for continued detention or isolation. Also, reformed law should condition the exercise of compulsory powers on a demonstrated public health need, such as when an individual poses a direct threat to others. Blink and you might miss it. A showing of current infectiousness. A direct threat. This is in diametric opposition to how compulsory powers were used during the COVID crisis, where masks and vaccines were mandated based on their supposed indirect benefits, yet people who refused these interventions were treated as direct threats without any showing of individual infectiousness, and often despite repeated demonstrations of non-infectiousness. 1990s Professor Gostin was not part of some fringe minority. If politicians, judges, public health officials, and 2020's Professor Gostin had followed the guidance of 1990's Professor Gostin and those who were like-minded, universal compulsory masking would never have been seriously contemplated, much less enacted with the cultish fervor it ultimately was. Though compulsory masking was on the defensive by early 2022, it remained deeply entrenched in many places. Even if the powerful effect of mask wearing on belief that we looked at in a review of mask psychology was non-existent, too many officials and politicized experts had already gone all in on their public commitment to masks. If politicians and experts had stopped at strongly recommending masks while leaving everyone free to choose whether or not to wear one, and limited themselves to persuasion, debate, social pressure, and moral criticism, backing out would have been much more feasible. But we all know that was not what happened. Masks were forced onto the willing and unwilling, men, women, and children, using every available oppressive tool from administrative penalties to job loss to civil and criminal penalties to shameless public demonization of conscientious objectors. Judge Grishow's February 2022 temporary restraining order against masking Illinois schoolchildren was another major step in the direction of sanity and constitutional quarantine-related jurisprudence, and another nail in the coffin for COVID mask mandates. After the Board of Education lost at the district level, the appellate court dismissed the board's appeal as moot. Less satisfyingly, once the mask mandate was no longer in place, the parents' claims were formally mooted as well. The next major setback for compulsory masking would come just 2 months later, when the CDC airline mask mandate finally failed rational basis scrutiny by a different name.
Arbitrary and capricious. Ending the CDC's travel mask mandate. Everyone has a non-zero risk of getting hit by a car when crossing the street, but that does not make it rational to mandate that everyone has to wear a fluorescent safety vest at all times when outside their homes based on the speculation that doing so will achieve some marginal decrease in pedestrian risk, even apart from the risk trade-off of creating that kind of widespread visual distraction. Even in a military context, simply showing or positing a non-zero risk of something, including infectious disease, is not on its own enough to pass even rational basis review. The D.C. Circuit Court struck down a long-standing military ban on the deployment of HIV-positive service members based on rational basis review, saying, "It is irrational to categorically bar the deployment of every asymptomatic HIV-positive service member with an undetectable viral load who is otherwise fit to serve based on speculation about aberrant conduct." Becoming non-deployable is a career-ending designation for military service members. Yet otherwise fit HIV-positive service members were automatically designated as non-deployable until the D.C. Circuit Court took the Army and Air Force to task for their flawed belief that any non-zero risk of HIV transmission to other service members is sufficient to justify a categorical bar of HIV-positive individuals from deployment. Though HIV is blood-borne and harder to transmit, the same reasoning applies just as strongly to SARS-CoV-2. SARS-CoV-2 is airborne and easier to transmit, but it is eminently treatable for the minority of the population that even needs treatment. It does not require daily medication or periodic blood testing, and total recovery is the rule rather than an exception. If it is irrational to categorically bar the deployment of individuals who are known to have a particular chronic communicable infection, it is even more irrational to mask everyone based on speculation about possible vulnerability to and transmission of a particular transient infection. This is especially true in the case of people who already recovered from the disease in question. One of the most aggravating features of the mask mandate regime, apart from its characteristic self-righteousness and dogmatic adherence to the pronouncements of chronically yet shamelessly wrong institutional experts, was its perpetual game of hide the responsibility. Agencies like the CDC and expert bodies issued what they called guidelines or recommendations, which were then turned into mandates by authorities and senior public health officials. Mandates which were finally enforced by people who were either true believers in masks, afraid of savage ad hominem attacks and accusations from the true believers in masks, or simply desperate not to lose their jobs like other victims of the response to COVID. Agencies like the CDC could claim to not be issuing any orders. Politicians and other authorities could claim to just be following the science, and on-the-ground enforcers could console themselves, or take pride in, just doing their jobs. If there was one single indispensable cornerstone to the reign of compulsory masking and COVID crisis terror in general in America, it was the CDC. With its incessant, meticulous, and ever-changing guidelines and recommendations, the CDC was like a bellowing administrative beast crouching at the center of a legal labyrinth. Most of the CDC's powers are conferred by the Public Health Service Act, enacted in 1944 and revised many times since. Most often, the CDC issues guidelines and recommendations, and these are given force of law by other branches of government. For example, the Department of Defense gave the CDC's guidelines and recommendations regarding masking for COVID-19 force of law as orders in its Consolidated Department of Defense Coronavirus Disease 2019 Force Health Protection Guidance. Masking of patients, visitors, and personnel working in DoD healthcare facilities, including military medical, dental, and veterinary treatment facilities, will occur in accordance with CDC guidelines. Masks were forced on travelers throughout the majority of 2020 based on CDC guidelines and recommendations, but things went a step further starting on January 21, 2021. 9 months into the COVID crisis, newly sworn-in President Biden issued Executive Order 13998, effectively making the CDC's word into law by requiring masking in accordance with CDC guidelines in virtually all public transportation contexts, including airports, commercial aircraft, trains, train stations, buses, and even maritime vessels like ferries. Just over a week later, on February 3rd, the CDC's now infamous travel mask mandate requiring masks in virtually all public conveyances and transportation hubs was published in the Federal Register. Apart from forcing masks onto travelers in virtually every travel context and conscripting transportation companies, operators, and their employees into the role of monitoring and enforcement whether they liked it or not, the CDC mask mandate went so far as to require instructing persons that federal law requires wearing a mask on the conveyance and failure to comply constitutes a violation of federal law. In so many words, civil and criminal penalties were prominently on the table. For scientific justification, the CDC cited a handful of the same weak, cherry-picked sources referenced in its science briefs on masks that we examined in the first part of this book. Mask mandates in America and across the globe cited to the CDC's pronouncements for legitimacy. A legal judgment against the CDC's own overreaching mask mandate would dramatically weaken the others. Multiple citizen litigators, among whom Lucas Wall deserves special recognition for his leadership, hard work, and tenacity, filed suit to challenge the CDC's travel mask mandate. Numerous congressmen, led by Representative Thomas Massie and Senator Rand Paul, also filed a joint suit. The most successful suit against the CDC's travel mask mandate, however, was filed in July 2021 by Health Freedom Defense Fund, HFDF, led by founder Leslie Manookian and attorneys Brant Hadaway and George Wentz. On April 18, 2022, after 9 months of legal fencing, HFDF received a ruling from Judge Catherine Kimball Mizell in the Middle District of Florida that had passengers everywhere breaking into spontaneous maskless celebration thousands of feet in the air. Judge Mizell vacated the CDC's mask mandate as exceeding the CDC's statutory authority and violating the procedures required for agency rulemaking under the Administrative Procedure Act, APA. Exceeding its statutory authority and violating the rulemaking procedural due process required by the APA was the CDC's COVID crisis modus operandi. For its travel mask mandate, the CDC seized on the first paragraph of Title 42 U.S.C. 264, Quarantine and Isolation, to claim that it possessed the authority to force all travelers to wear masks pursuant to the President's executive order. The statutory paragraph in question reads, "The Surgeon General, with the approval of the Secretary, is authorized to make and enforce such regulations as, in his judgment, are necessary to prevent the introduction, transmission, or spread of communicable diseases from foreign countries into the states or possessions, or from one state or possession into any other state or possession. For purposes of carrying out and enforcing such regulations, the Surgeon General may provide for such inspection, fumigation, disinfection, sanitation, pest extermination, destruction of animals or articles found to be so infected or contaminated as to be sources of dangerous infection to human beings, and other measures as in his judgment may be necessary." The CDC unilaterally claimed that forcibly masking all travelers fell under either sanitation or other measures. Masking every traveler wasn't all the CDC claimed this paragraph gave it the power to do either. Right at the start of the crisis, in March 2020, the CDC had used Section 264 to issue no-sail, later conditional sailing, orders that completely stopped cruise ships from operating for more than 6 months. In September 2020, the CDC cited Section 264 to issue a mandate barring landlords from evicting non-paying tenants, covering all residential properties nationwide and imposing criminal penalties on violators. Florida Judge Stephen Merriday enjoined the CDC's unlawful cruise ship orders in June 2021, and an incredulous U.S. Supreme Court finally ruled decisively against the CDC's eviction moratorium 2 months later in August, saying, "The CDC has imposed a nationwide moratorium on evictions in reliance on a decades-old statute that authorizes it to implement measures like fumigation and pest extermination. It strains credulity to believe that this statute grants the CDC the sweeping authority that it asserts." Though both of these other unlawful CDC mandates were rightly struck down, they did considerable damage while in force, and the legal process to end them took long months. The same was true of the CDC's 15-month-long travel mask mandate. Judge Mizell's shutdown of the CDC's travel mask mandate came in 2 parts. First, she analyzed the statute cited by the CDC and determined that the statute did not actually say what the CDC claimed it said as far as powers granted. Second, she showed that even if the CDC had possessed the statutory authority to issue a mask mandate, the CDC's travel mask mandate was still invalid and should be vacated because the way it had been issued violated the rulemaking processes required under the Administrative Procedure Act. Judge Mizell quickly realized that whether masks fell under the term sanitation, as the CDC argued, depended on whether sanitation in the statute was being used in the sense of cleaning something or in the sense of keeping something clean. Masks could not fit under the definition of actively cleaning something, but they could arguably fit under the umbrella of keeping something clean. The statute itself did not define which sense it was using the term sanitation in, whether cleaning, keeping clean, or both. The CDC, of course, argued for the broadest possible definition, but after a careful analysis, Judge Mizell ruled otherwise. Apart from the CDC's recent overextension and abuse of Section 264 that couldn't help but render any further newly discovered wide-ranging powers within the statute, including a mask mandate, highly suspect, Judge Mizell identified 4 additional reasons why the narrower sense of sanitation as cleaning something was the most accurate statutory reading. First, there was the written context. The words accompanying sanitation in the statute, inspection, fumigation, disinfection, pest extermination, and destruction, all involved identifying and removing sources of disease rather than maintaining a non-diseased status. Second, a search of the corpus of historical American English for the 15-year period leading up to the original passage of the statute revealed that at the time the statute was passed, by far the most common use of sanitation referred to making something clean, whereas only about 5% of the documented uses of sanitation referred to maintaining cleanliness. Third, interpreting sanitation in the broadest possible sense of the term to include anything that promotes hygiene and prevents disease, as the government contended, would make the use of other terms in the statute, e.g. disinfection and fumigation, pointless and redundant, which violated basic rules about how to read and interpret statutes. If Congress had wanted to give the CDC power to do anything that promotes hygiene and prevents disease, it would have said so clearly. Fourth, the federal government's historical use of inspection and quarantine power was as a secondary adjunct to assist the states, and this was how Section 264 had previously been interpreted. The CDC's sudden, broad interpretation of sanitation to justify forcing masks onto all travelers both reversed these historical roles and extended the mandate to settings that had little, if any, effect on interstate disease spread, e.g. city buses and ride-sharing Ubers. These reasons also made it highly unlikely that a mask mandate would fit under other measures either. Based on the overall context, then, Judge Mizell ruled, sanitation and other measures refer to measures that clean something, not ones that keep something clean. Wearing a mask cleans nothing. At most, it traps virus droplets, but it neither sanitizes the person wearing the mask nor sanitizes the conveyance. And if Congress had not clearly delegated this power, the agency did not have it. The CDC's travel mask mandate was therefore ultra vires, beyond the scope of its legal power and authority. Judge Mizell went on to point out that the portion of the statute the CDC was invoking to justify its mandate referred to procedures applied to property, not procedures applied to persons. As implemented, the requirements to wear a mask bore far more resemblance to a performance requirement for conditional release to avoid a more stringent quarantine, subjects covered elsewhere in the statute, than they did to sanitation.
Anyone who refuses to comply with the condition of mask wearing is, in a sense, denied or partially quarantined by exclusion from a conveyance or transportation hub under authority of the mask mandate. They are forcibly removed from their airplane seats, denied boarding at the bus stops, and turned away at the train station doors, all on the suspicion that they will spread a disease. Indeed, the mask mandate enlists local governments, airport employees, flight attendants, and even ride-sharing drivers to enforce these removal measures. In short, their freedom of movement is curtailed in a way similar to detention and quarantine. As a result, the mask mandate is best understood not as sanitation, but as an exercise of the CDC's power to conditionally release individuals to travel despite concerns that they may spread a communicable disease, and to detain or partially quarantine those who refuse. Why might the CDC prefer to anchor its mask mandate on sanitation rather than the more directly applicable quarantine and conditional release sections of the statute? Having read to this point, you likely already suspect the answer. Quarantine implicates individual rights to due process. As Judge Mizell highlighted, the section of the statute avoided by the CDC allowed detention of an individual traveling between states only if he is reasonably believed to be infected and is actually found upon examination to be infected. The mask mandate complies with neither of these subsections. It applies to all travelers regardless of their origins or destinations and makes no attempt to sort based on their health. But Judge Mizell was not done. Even if the CDC had possessed the statutory power to issue a mask mandate, the way it did so violated the rulemaking requirements of the Administrative Procedure Act, and this was, on its own, enough to void the mandate. Initially, the CDC tried to claim that its mask mandate was not a rule subject to the rulemaking procedures, even though it self-evidently was exactly that. The CDC then tried to claim it had good cause to skip the required public notice and comment period for rulemaking because COVID was such an urgent emergency. That transparent excuse probably would have worked in March 2020, but by January 2021, the CDC had waited more than 9 months after COVID hit to issue its travel mask mandate, showing that the real emergency was far more likely a political desire to avoid giving the public notice and having to deal with the public's comments. This alone would have been enough to vacate the mask mandate or at least stay it pending the required procedures. But what was arguably the best part of Judge Mizell's ruling came next, when she demonstrated for all to see what real rational basis scrutiny is supposed to look like. Technically, what Judge Mizell applied to the CDC's mask mandate is called arbitrary and capricious review, rather than rational basis scrutiny. But as we shall see, this is a distinction in terminology rather than core substance. Under the Administrative Procedure Act, agencies are required to engage in reasoned decision-making. If an agency rule is arbitrary and capricious, then the agency has not engaged in the required reasoned decision-making, and the agency's rule can and should be vacated. Technically, arbitrary and capricious review is distinct from rational basis scrutiny. Rational basis scrutiny is a test applied to laws, while arbitrary and capricious review is a test for the actions and rules of agencies like the CDC, especially under the Administrative Procedure Act. But this is a distinction without a real core difference. Reasoned decision-making requires a rational connection between the facts found and the choice made. If something is arbitrary and capricious, it is by definition irrational, and irrational actions by definition lack a rational basis. If a mask mandate is arbitrary and capricious, it is irrational and cannot hold up under true rational basis scrutiny. Rules, orders, guidelines, and recommendations that are arbitrary and capricious have a number of telltale hallmarks, and the list that follows is not exhaustive. Any single hallmark may be enough to render the rule arbitrary and capricious, and the more that are present, the greater that likelihood becomes. Every mask mandate involved many of these at the same time, and the CDC's mask-related excretions were among the worst offenders in this regard. Every mask mandate that relied on the CDC's mask mandates, rules, orders, guidelines, or recommendations took on their fatal deficiencies. The most basic way to fail the test of reasoned decision-making is to fail to satisfactorily explain the reasoning behind the rules being imposed. In other words, the articulated rationale must also be adequate to explain all major aspects of the decision. Failing to supply a requisite reasoned analysis and explanation is enough on its own to render an order arbitrary and capricious. Of course, if there is no real reasoning behind the rules, no reasoning can or will be laid out. Mask mandates as a whole provided little, usually no, explanation for their choices. Mask mandates, including the CDC's mask mandate, never truly explained why all masks, from cloth to N95 respirators, were sufficient to meet their requirements. They simply asserted or assumed that any mask was better than no mask, regardless of how it was worn, cared for, or disposed of. This was and remains a giant red flag to anyone knowledgeable about the topic. When relevant data and evidence exist, adducing substantive evidence and engaging with objections, alternatives, and opposing evidence is an essential part of reasoned decision-making. Excluding viable alternatives or large bodies of evidence from consideration is arbitrary and capricious. It is also arbitrary and capricious to entirely fail to consider an important aspect of the problem which a rule, order, guideline, or recommendation is meant to address. Mask mandates failed to consider, arbitrarily rejected, or outright omitted any real explanation for rejecting obvious alternatives or reasonable accommodations such as random surveillance testing or engineering controls. Over 100 years of established scientific evidence that refuted the presumed efficacy of masking was willfully ignored by the majority of policymakers, not just in America but across the globe, and I have yet to find a single mask mandate which considers and addresses potential substitute or supplementary requirements to masking such as surveillance testing, HEPA filters, ventilation improvements, hand hygiene, temperature checks, or simply quarantining symptomatic individuals. Failing to narrowly tailor interventions in the furtherance of a compelling interest is arbitrary and capricious. Mask mandates, as we have seen, were never narrowly tailored. Mask mandates ignored their own underlying rationale of infection control in favor of procedures and processes specific to one particular method of disease prevention, e.g. mandating mask wearing but not hand washing. The broad scope of mask mandates was applied regardless of individual risk factors, making them over-inclusive while at the same time being under-inclusive through making exceptions for activities of comparable risk. They made no effort to explain why their purposes, preventing transmission of serious illness, allowed for the exceptions they included but not other potential exceptions they left out, especially when the exceptions they included cumulatively called into question the mandate's overall efficacy and indispensability for infection control. Age cutoffs ranging from 2 years old to 5 years old were never explained because the judgment was purely arbitrary gut-level reasoning, or at best political science rather than medical science. Mask mandates never addressed why people in low transmission risk indoor settings suddenly became high transmission risk to one another simply by virtue of walking into particular buildings when the occupancy of those buildings was entirely composed of similarly low-risk individuals. A prime example of this was masking requirements in dental clinics. If the risk to public health from COVID could permit no unmasking, then by the nature of what dental treatment must always entail, generating copious aerosols from multiple unmasked patients' open mouths for hours on end in close proximity all day every day, no routine dental treatment whatsoever could have been justified. The most outrageous example, however, was the dismissive, unsupported, anti-scientific, and ultimately inexcusable rejection of natural immunity as a basis for exemption. In the same vein, widespread efforts to forcibly eliminate the non-intervention control group of conscientious objectors were not just unscientific but anti-scientific, apart from being a gross violation of essential individual liberties. Failure to consider inescapable trade-offs is arbitrary and capricious. Mask mandates failed to specify and quantify, or at the very least specify and exemplify, how the hypothesized effect of masks on public health outweighed the constitutionally fundamental rights that were violated in the process, including but not limited to freedom of speech, freedom of religion, and the rights to privacy and due process. Moreover, even a cursory utilitarian analysis shows that many of the CDC's own recommendations ostensibly aimed at combating COVID-19 did far greater damage to public health than universal unmasking could ever have done, even assuming masks worked. The presence of a pretext, post hoc justification, or an explanation that runs counter to the evidence are all dead giveaways that a policy is arbitrary and capricious. As Judge Mizell pointed out, under the APA, the court may only consider the grounds that the agency invoked when it took the action. Mask mandates were ideology pushed on a pretext of public health. Mask mandate rationales were often flagrantly pretextual, part of a broader program aimed at increasing fear of COVID and providing evidence that something effective was being done. Lastly, an order not being the product of agency expertise is yet another sign of being arbitrary and capricious. Most mask mandates were issued by parties that had no expertise in infection control. They simply proffered a vague administrative excuse and then pointed to the CDC, despite intense public debate and a trove of easily accessible scientific data on the strength and durability of natural immunity from COVID-19, as well as the overwhelming scientific evidence that masks do not work. They took for granted that appealing to CDC guidelines was legitimate reliance. Judge Mizell laid out in her ruling how the CDC's travel mask mandate miserably failed the requirement for reasoned decision-making in multiple ways. Under the Administrative Procedure Act, agencies like the CDC are required to identify the considerations they found persuasive when making policy judgments. The CDC totally failed to do this in its travel mask mandate. The CDC provided zero explanation for rejecting possible alternatives to masking and for its system of exceptions. As described above, an obvious starting point was the total lack of explanation why homemade and medical-grade masks were both considered sufficient. Categorical exceptions for children under 2 years old and those with ADA-recognized disabilities went completely unexplained. As Judge Mizell said, the mandate makes no effort to explain why its purposes, prevention of transmission and serious illness, allow for such exceptions, nor why a 2-year-old is less likely to transmit COVID-19 than a 62-year-old. According to the CDC, identification, eating, drinking, and taking medication all permitted at least temporary mask removal. But if even the mere possibility of COVID were such a grave threat to public health, why could these activities be permitted at passengers' convenience? The CDC did not say, and the CDC's additional exceptions for persons who were experiencing difficulty breathing or who were feeling winded undermined its claims that masking does not significantly impede breathing. After a thorough review, Judge Mizell ruled, because our system does not permit agencies to act unlawfully even in pursuit of desirable ends, the court declares unlawful and vacates the mask mandate. Indoctrinated devotees and institutional supporters of compulsory masking greeted her ruling with horrified cries of judicial overreach and predictions of widespread COVID outbreaks caused by unmasked travelers. No such outbreaks, of course, ever materialized, as a brief filed by airline workers 2.5 months later pointed out. This result was entirely predictable based on the scientific studies we reviewed in the first part of this book. The majority of Americans, especially those who had done any real research, responded with celebration, approval, and quiet relief. Judge Mizell's ruling on the CDC travel mask mandate was another major milestone on the road to a real recovery. One would think that if COVID was such a great threat to public health and masks were so effective and essential, then the CDC would have appealed Judge Mizell's decision and sought a stay of her injunction at the earliest possible date. One would think that. Yet, after Judge Mizell's ruling, the CDC declined to seek a stay of the injunction, and ended up waiting nearly a month and a half before it actually filed its appeal in the 11th Circuit Court of Appeals. In fact, the CDC's delay in filing its appeal was longer than the notice and comment period which the CDC had tried to bypass by claiming COVID was too much of an emergency. In the interim, on April 29th, less than 2 weeks after Judge Mizell's ruling, another judge in the Middle District of Florida, Paul Byron, issued a ruling in Lucas Wall's lawsuit against the CDC's travel mask mandate. Judge Byron's ruling was, in many ways, the antithesis of Judge Mizell's, which he had clearly read, and traveled the same well-worn rut of reasoning that dominated too many courts during the COVID crisis. First, Judge Byron denied that the CDC's mask mandate implicated any constitutionally protected due process liberty interest, or that it involved an infringement on the fundamental right to travel. A mere inconvenience caused by a reasonable government regulation is not enough to amount to a denial of this fundamental right. To Judge Byron, sanitation in the statute the CDC cited clearly included keeping something clean. It was right there in the dictionary, and the statutory language should be interpreted according to the CDC's broad reading. Mask mandates were a legitimate extension of the agency's quarantine and inspection authority, which applied to pre-communicable individuals and were a matter of common sense. Courts should defer to the CDC's expertise. After all, the CDC had cited to 7 different studies that confirmed the benefit of universal masking in community-level analyses. This extensive scientific research was clearly good enough to meet the requirements of reasoned decision-making. The CDC's failure to precisely follow administrative requirements, like trying to call a rule an order or bypassing notice and comment, was either appropriate or immaterial when it came to an ongoing public health emergency like COVID, which had taken so very many lives and which was so very transmissible, continued to mutate, and from which no one was safe. As an aside, it is not completely clear which 7 studies Judge Byron was referring to in his ruling, but the most likely candidates from the CDC's travel mask mandate list of references are Uik et al. 2020, Wang et al. 2020, Mitze et al. 2020, Galloway et al. 2020, Liu and Webby 2020, Hatzius et al. 2021, and Kara Ivanov et al. 2020. We covered all of these in the science section. 4 intervention with trend analysis studies, including the infamous Massachusetts General Brigham study, 1 surveillance study, 1 laboratory study, and 1 modeling study. Forcing masks onto millions of Americans based on these studies barely worthy of the name was a sick joke. The studies on the list included no control groups. None of the more than 20 randomized controlled trials available in January 2021, probably because none of those randomized controlled trials supported mask efficacy, none of the multiple meta-analyses of these randomized controlled trials, and not even so much as a retrospective cohort study with a meaningful control group or comprehensive literature review. When Judge Byron threw out his offhanded comment, he may have intended to highlight how strong the CDC's evidential basis for its travel mask mandate was. But all he really did was illustrate the indefensible weakness underlying the CDC's reasoned decision-making for anyone willing to do a modicum of digging, as well as its inexcusable cherry-picking of the literature and his own lack of due diligence in deferring to the agency. Meanwhile, he made Judge Mizell's ruling look better by comparison. Unmentioned were any of the many more references that plaintiff Lucas Wall had submitted providing evidence that masks do not work. The CDC made fools out of many judges during the COVID crisis. Fortunately for Americans, Judge Byron's refusal to grant relief in Lucas Wall's case could not override Judge Mizell's injunction, and both cases proceeded to the appellate level. With these 2 conflicting rulings, and the CDC and Lucas Wall both appealing their district-level verdicts, the cases went up to the 11th Circuit Court of Appeals, where Judge Mizell's injunction remained intact until the final ruling. The lawsuits against the CDC's travel mask mandate attracted a great deal of attention, both in the form of news coverage and in the form of amicus briefs. Amicus briefs are legal briefs filed in a lawsuit by third parties to support one side or the other, or to inform the court about another facet of the case pertinent to its final decision. Even at the appellate level, only a tiny fraction of legal cases involve amicus briefs. Amicus briefers are not directly involved in the case, but may have an interest in the final outcome or take a strong position on the legal question at hand. Mask cases in general, and the cases challenging the CDC's travel mask mandate in particular, involved multiple amicus briefs on both sides. Industrial hygiene experts, disabled passengers, and a group of over 300 airline workers filed amicus briefs supporting Lucas Wall's lawsuit. In HFDF v. Biden, the American Medical Association filed a brief supporting the CDC. As another side note, while it was better written, the AMA's brief was even worse evidentially than the CDC's mask mandate or mask science brief. A large group of public health and public health law experts, including Wendy Parmet and Lawrence Gostin, who we met earlier, also signed on to a joint brief in support of the CDC's statutory reading. Supporting the Health Freedom Defense Fund in opposition to these were the industrial hygiene experts, disabled passengers, and airline worker amici who supported Lucas Wall, as well as congressmen, the Association of American Physicians and Surgeons, America's Frontline Doctors, and the Liberty, Life, and Law Foundation. On top of this, 23 states and state attorneys general led by Florida filed a joint amicus brief supporting Health Freedom Defense Fund. This last was an indication of just how much the political tide had turned against compulsory masking, as well as the growing awareness among state leadership of the CDC's malfeasance and manipulative evidential presentations. States challenge masks. Louisiana v. Becerra. In an August 2020 Viewpoint article published in the Journal of the American Medical Association, Lawrence Gostin acknowledged that it is not clear whether the CDC has the authority to mandate face coverings nationwide. He also warned that a federal mandate might provoke political opposition to face coverings rooted in state sovereignty. Professor Gostin's prediction was accurate. Many states rightly perceived the mask mandates implemented through executive agencies to be an attempt at bypassing the legislative branch of government and preempting state law altogether. Texas Education Code, for example, forbade obstructing the student's airway, including placing an object in, on, or over the student's mouth or nose, or placing a bag, cover, or mask over the student's face, as an abusive form of aversive behavior management. This was ignored during COVID, but is still very much on the books. Many state governors, like Florida's Ron DeSantis and Texas' Greg Abbott, had already rescinded and largely banned mask mandates in the spring and summer of 2021. South Dakota's governor, Kristi Noem, never implemented a statewide mask mandate in the first place. By the fall and winter of 2021, many state governments were actively joining the fight on behalf of their citizens, pushing back on compulsory masking with lawsuits of their own. In November 2021, after a great deal of work by multiple state attorney generals, a Fifth Circuit Court of Appeals stayed enforcement of the Occupational Safety and Health Administration (OSHA) Emergency Temporary Standard vaccine mandate that, among other things, required employees to be vaccinated or take weekly COVID tests and wear a mask. Undeterred, other executive agencies and localities at the federal and state levels shoehorned their own mask and vaccine mandates onto whoever was unlucky enough to fall under their power. On November 30, 2021, the Office of Head Start, OHS, Administration of Children and Families, ACF, and the Department of Health and Human Services imposed the Head Start mask mandate on hundreds of thousands of toddlers, volunteers, and staff nationwide as an administrative standard. Never mind that the risk COVID posed to children was negligible. Because children 2 to 5 years old could not be vaccinated, they would have to wear the masks. And of course, by November 2021, the emergency was still so great that HHS decided to bypass notice and comment, while pointing to CDC guidance and a smattering of studies that appeared in the CDC's mask science brief, studies which we already looked at in detail in the science section of this book. 23 states, with Louisiana as the head plaintiff, filed suit in December to stop this latest abuse. 9 months later, in September 2022, Judge Terry Doty freed more than 500,000 of America's toddlers, issuing a permanent injunction against the Head Start mask mandate and vaccine mandate in Louisiana v. Becerra. Like the CDC, HHS exceeded its statutory authority. HHS attempts to justify masks and vaccine mandates under program performance standards, administrative and financial management standards, or standards relating to the condition and location of facilities, all crumpled like wet tissue paper on critical examination. After carefully reviewing the agency's rationale and legal defense, Judge Doty said, "There is nothing which would allow agency defendants to make medical decisions for employees and volunteers and or to require 2, 3, and 4-year-old students to wear masks the majority of the day." When HHS passed its toddler mask mandate, public health officials in states like New York were either rushing into lockstep or had beaten it to the punch. On November 17th, New York City's health commissioner signed an order masking children ages 2 to 5 indefinitely. But by this time, the spell had been gradually breaking even in strongholds of the masking mentality like New York. A group of parents found one brave lawyer willing to help them file a challenge. On April 6, 2022, nearly 2 weeks before Judge Mizell ended the CDC's travel mask mandate, Judge Ralph Porzio declared the New York Health Commissioner's indefinite order to mask toddlers void and unenforceable for being akin to a law and a measure which usurps the authority of the legislative branch, not to mention failing rational basis type scrutiny for being arbitrary and capricious. In fact, there has been no demonstration or empirical data submitted by respondents that unmasked children in daycares or schools outside of New York City face increased risk of severe COVID-19 infection. Capricious action in a legal sense is established when an administrative agency on identical facts decides differently. The respondents have done exactly this. They have made different decisions on identical sets of facts and statistics, such as granting exemptions to unvaccinated athletes and performing artists, or allowing unvaccinated children over the age of 5 to unmask. This toddler mask mandate that is slated to continue indefinitely is not in accordance with the CDC guidance, nor is it rational or reasonable in light of the ever-changing data. This is the very definition of arbitrary and capricious. Judge Porzio's opinion was non-published, meaning it was not binding precedent, but it was an indication of the undercurrents of liberty and a return to sanity gradually building below the surface even in places long dominated by the masking mentality. Technicalities versus fundamentals. Health Freedom Defense Fund v. Biden and Louisiana v. Becerra, the lawsuits that ended the CDC's travel mask mandate and HHS Head Start mask mandate, exemplify what are primarily administrative or statutory rather than direct constitutional challenges to masks. The provisions of the Bill of Rights stand in the background, but these cases were not so much won on whether masks could be mandated, but on whether masks could be mandated by the specific authorities that did so in the specific way that they did so. The distinction is subtle but critical. On a pragmatic level, this more modest type of challenge had a much higher average chance of success. One of many things that fear drove out of most people's minds in 2020 was that emergency powers are not open-ended. Even emergency powers are limited and definite. Emergency powers are specifically enumerated in the relevant statutes and charters that confer them. Emergency powers do not extend to every possible area which might conceivably be helpful to deal with an emergency. As several of the cases discussed in this section show, a close examination of the relevant statutes for a particular jurisdiction reveal that its public health authorities have limited granted powers, and these do not extend to things like confining all people to their homes, broadly forbidding travel, closing most businesses, and mandating masks. The details of what powers agencies and executives have under states of emergency are usually confined to a specific list, often under some heading like Official Authority or General Powers and Duties. A good example of this at a local level comes from Jeff Childers' appellant brief in Green v. Alachua County. Childers argued that the county did not show that it had authority to issue the mandates because the legal authority conferred on the county through its charter or Florida statute did not include mask mandates. Alachua Charter 27.08 reads, "Executive orders shall be limited to those necessary to eliminate or contain conditions that threaten the health, safety, or welfare of the citizens of the county." In his brief, Childers drew attention to how the trial court described Alachua County's mask mandate as potentially reducing the spread of COVID-19. Something which is potentially helpful cannot fall under emergency orders that are limited to those necessary to eliminate or contain a pathogen. As Childers put it, shall be, limited, necessary. These are not words of expanded powers. Just the opposite. They are explicit words of limitation. Unbiased judiciary? You decide. In 2020 and 2021, most judges simply took assertions by state and public health officials regarding masks' efficacy and necessity at face value, citing a need to avoid judicial overreach and not second-guess the experts, regardless of how tissue-thin, post-hoc, or outright manufactured the evidence underlying masks and other COVID crisis policies actually was. The real underlying attitudes behind many judicial decisions upholding mask mandates in 2020 and 2021 became clear when executive and legislative bans on mask mandates finally appeared. In 2020 and 2021, it was almost impossible to find a lower court willing to second-guess legislative and official expertise on mask mandates. But when the shoe was finally on the other foot, there were plenty of lower courts who not only found that plaintiffs suddenly had standing to sue against bans on mask mandates, but also did not hesitate to stay or enjoin those bans. When the Arkansas legislature passed a bill in April 2021 banning mask mandates in state entities and public schools, but allowing private businesses and schools to impose their own mandates, Judge Tim Fox was quick to grant an injunction against it, citing equal protection, saying that the legislature's ban on mask mandates discriminates without a rational basis between minors in public schools and minors in private schools. So, because private schools could still mandate masks, public schools must be able to do so as well. Equal protection twisted into equal abuse. When Tennessee's Governor Bill Lee issued an order in August 2021 that parents could opt out of masking their children in schools on an individual basis, parents of students with disabilities sued to allow schools to mandate masks on other parents' children, claiming that a ban on mask mandates forced them to choose between their children's health and safety and their children's education, as though forcing every other parent's child to wear a mask against their will could somehow be a reasonable accommodation for those students with disabilities who were supposedly at increased risk. Picking up the torch for masks, District Judge Ronnie Greer ordered the Knox County Board of Education to enforce the mask mandate that had been in effect from 2020, ruling that failure to prospectively adopt a mask mandate, the alleged reasonable accommodation, is an injury, a concrete, actual, and ongoing injury. By contrast, Judge Greer insisted that the court can identify no harm to others that would result from a mask mandate. In South Carolina, Judge Mary Geiger Lewis did the same thing, admonishing South Carolina's governor and attorney general that federal courts routinely enjoin state officials from enforcing unconstitutional state laws. According to Judge Lewis, the mere threat of COVID was irreparable harm, but actual forced masking of children in violation of all the rights described in this book was no such thing. It takes a special kind of mental contortionist to justify giving schools the power to force masks onto students against their will in the name of individual rights. but Judge Mary Geiger Lewis somehow managed it. Emergency powers exist against the backdrop of individual rights and liberties, including the right to be free from discrimination. Such rights are sacrosanct. This is not a close call. The General Assembly's COVID measures disallowing school districts from mandating masks discriminates against children with disabilities. So, preventing schools from forcing masks onto students was somehow unconstitutional, but allowing schools to mandate masks for students in the name of non-discrimination was constitutionally kosher. The fact that the American Academy of Pediatrics filed amicus briefs in support of allowing schools to force masks onto children in this and other cases should tell readers all they need to know about that particular body of organized medicine. The ACLU likewise supported this and other suits to maintain mask mandates on children. Fortunately for most of South Carolina's school children, the governor's order was a reflection of how much the masking mentality was beginning to ebb. In January 2022, 2 out of 3 judges on a Fourth Circuit Court of Appeals panel ruled that the plaintiffs did not have standing to sue for the simple fact that even with Judge Lewis' temporary injunction in place, the overwhelming majority of South Carolina school districts still did not reimpose universal masking for students and staff, so a favorable ruling would not grant the relief the plaintiffs were seeking. Judge James Wynn wrote what was actually an excellent dissenting opinion. If Judge Wynn's reasoning had been applied consistently throughout 2020, as it should have been, multiple cases challenging compulsory masking would not have been dismissed for lack of standing. A plaintiff need not show that a favorable decision will relieve their every injury. Rather, a plaintiff need only show that they personally would benefit in a tangible way from the court's intervention. For that reason, removal of even one obstacle to the exercise of one's rights, even if other barriers remain, is sufficient to show redressability. A parallel case in Iowa followed the same pattern, with a group of parents claiming that preventing mask mandates violated their disabled children's civil rights. The ACLU and American Academy of Pediatrics supported this effort to remask Iowa school children as well. It was, at bottom, the same argument heard throughout the COVID crisis. These people over here are more vulnerable than you are to a disease you might theoretically carry. Therefore, you must wear a mask. The plaintiffs had no difficulty finding a pediatrician willing to opine that there's no evidence that wearing a mask has any negative impact whatsoever on that child's physical, social, or mental well-being. District Court Judge Robert Pratt quickly issued a temporary restraining order and then a preliminary injunction against Governor Kim Reynolds and Education Director Ann Lebo's enforcement of the Iowa legislature's ban on school mask mandates. Unlike in South Carolina, many school districts in Iowa rushed to remask, at least for a few more months. The masking mentality at its finest, executive mask mandates under questionable emergency powers were totally fine, but bans on mask mandates passed through the normal legislative process somehow violated basic civil rights. Not all judges were so quick to grant such injunctions against mask mandate bans, however. During the same time period, Florida federal judge Michael K. Moore ruled against blocking Governor DeSantis' ban on mask mandates, saying the parents who filed the suit had not exhausted their administrative remedies first. By this point, more than enough of the studies that we reviewed in detail in the science section of this book had been published to show decisively that masks made no difference to COVID-19 infections in schools or anywhere else. The speculated special threat posed by SARS-CoV-2 to individuals with disabilities was further undermined when a group of UK researchers published their findings of a nationwide prospective study of SARS-CoV-2 in immunocompromised pediatric patients recruited from 46 hospitals in November 2021. From March 2020 to March 2021, of the 1,527 immunocompromised participants, only 38 cases of SARS-CoV-2 were diagnosed. Of those 38 cases, 4 were admitted to the hospital, but in none of the 4 cases was SARS-CoV-2 the cause of the hospital admission. The authors concluded, SARS-CoV-2 infections have occurred in immunocompromised children and young people with no increased risk of severe disease. No children died. And yet judges like those mentioned here continued to enable forced masking for school children in the name of the science and a truly twisted concept of equality. In May 2022, a month after Judge Mizell stopped the CDC's travel mask mandate, the Eighth Circuit Court of Appeals declared the attempt to remask students in Iowa to be moot. However, Judge Pratt still got the last word. In his November 2022 judgment, Judge Pratt declared in so many words that if a school district concludes that requiring masks is a reasonable modification to protect the safety of the student making the accommodation request under federal disability law, then, according to Judge Pratt, the governor, and by extension the legislature, must permit the imposition of a mask mandate. The case is moot. Or is it? If you happen to have a tyrannical or highly authoritarian bent, or even just the sort of anxious personality that copes with anxiety by trying to control other people as much as possible, and if you want to impose a mandate to get everyone else to do the right thing, for everyone's collective good, of course, part of gaming the courts 101 is getting a feel for whether the court is going to favor you, and then using that information to determine how you implement your mandates. If the court is clearly favorable, you can run any legal case to its natural conclusion and get a ruling that will give you a useful precedent. If you're not sure, or if the court is looking more and more skeptical, and plaintiffs challenging your mandate might, heaven forbid, get a fair hearing and subject your mandate to fatal review, you can still maintain your power and long-term potential to try your agenda later by withdrawing or modifying restrictions you imposed, and then claiming the issue is now moot. When a case is said to be moot, it means that the controversy is no longer applicable, and the case is effectively ended because there is nothing left that needs to be decided. A ruling on the controversy would have no practical effect. As an example, if two people claim ownership of the same property and sue each other, the case becomes moot if one of them suddenly decides for whatever reason to relinquish all claims to the property under dispute. In the case of mask mandates, and legal challenges to those mask mandates, ending the mandate being challenged might moot the case if there is no reasonable possibility that the mask mandate would be reissued. If you happen to be the party that issued the mask mandate, the odds will favor you on any mootness claims, because if the mooting decisions in multiple mask mandate cases are anything to go by, courts tend to give governmental parties a stunningly generous benefit of the doubt when deciding whether mootness applies. I'm not referring to the usual good faith required to do business and make for smooth administration. I'm referring to benefit of the doubt that often equals or exceeds what most people would give close friends and family. Additionally, if you happen to be a judge who, for whatever reason, really does not want to rule one way or the other on a case, then drawing out the case until it becomes moot is an especially attractive and useful evasion tactic when it's an option, because it is almost impossible to prove. After all, judges are very busy, and giving both parties all the time they need to make their strongest case is only fair. If that means the case drags on until it becomes moot, that's too bad, but it was the only fair thing you could have done. The trajectories of many of the legal challenges to compulsory masking discussed in this book are consistent with, if not outright highly suggestive of, the hypothesis that multiple courts avoided ruling on the issue of masks by delaying proceedings until they could dismiss the case as moot, particularly in cases where plaintiffs made pleadings using unusually strong arguments or evidence that ought to have gotten their claims to strict scrutiny or some form of success. Then again, that could just be the way completely innocent timelines appear when viewed through a recently acquired lens of mistrust. Of course, the mere fact that a case or controversy technically no longer exists does not mean that a court cannot still rule on the issue if it wants to definitively resolve the dispute for future reference. If courts were unable to rule on controversies after the fact, then a large subset of cases in which the wrongdoing involved was too short in duration to be litigated would be excluded from the possibility of redress. Fair-minded judges long ago recognized the potential abuses inherent in the possibility of mootness. In response, they articulated a number of exceptions, including what are known as the voluntary cessation exception and the capable of repetition yet evading review exception. These two classic exceptions to mootness target the same basic abuse: a defendant continually mooting a challenge to his conduct by ceasing the challenged behavior to end the litigation, but then returning to the allegedly wrongful conduct after the litigation is dismissed as moot. U.S. Supreme Court Justice Neil Gorsuch alluded to this type of underhanded gamesmanship in Roman Catholic Diocese v. Cuomo. The governor has fought this case at every step of the way, to turn away religious leaders bringing meritorious claims just because the governor decided to hit the off switch in the shadow of our review would be, in my view, just another sacrifice of fundamental rights in the name of judicial modesty. Capable of repetition yet evading review is the classic exception to mootness, even or especially in COVID-related cases. As the United States Supreme Court has acknowledged, even if the government withdraws or modifies a COVID restriction in the course of litigation, that does not necessarily moot the case. If the possibility of giving plaintiffs the minimal redress of some meaningful sense of closure does not provide enough motivation to carry a case to its definitive conclusion, the mere reasonable possibility that the controversy will recur provides sufficient legal justification. One would think that when authorities insisted that they maintained the power to mandate masks, that alone would have been enough to automatically create a reasonable possibility that mask mandates would recur. Once mask mandates were lifted, however, many courts suddenly upped the bar for what it takes for something to count as reasonable possibility. Courts' gymnastic flexibility in determining what counts as a reasonable possibility when it came to masks working, no evidence needed, versus mask mandates being reimposed, anything short of a direct confession of intent is insufficient, is astonishing. Astonishing, that is, until one realizes that the common thread is an exorbitant willingness on the part of too many judges to give the entities that mandated masks far more benefit of the doubt than they ever deserved. Then it simply becomes depressing. 2 challenges to compulsory masking were dismissed as moot by the Minnesota Supreme Court and Sixth Circuit Court of Appeals. The courts said there was no reasonable possibility that Minnesota and Michigan state governors or agencies would reimpose mask mandates comparable to those being challenged and which had just been lifted. The Minnesota Supreme Court acknowledged that Governor Walz has not instituted another mask mandate or peacetime emergency in response to COVID-19, but he maintains that he retains that power. Despite the governor's insistence that he retained the power to mandate masks, and the experience of nearly 3 years during the COVID crisis, the Minnesota Supreme Court still ruled that mask mandates are not, however, issues of statewide importance that require immediate resolution. Although the constitutional rights at issue are important ones, there is no serious harm or uncertainty that requires immediate resolution. Similarly, the Sixth Circuit Court of Appeals said, "We are unlikely to see this mandate in a similar form again. We see no reasonable possibility that the state will impose a new mask mandate with roughly the same exceptions as the one originally at issue here." What evidence could be so persuasive that it was able to convince high court majorities in these 2 cases that there was no reasonable possibility that mask mandates would recur? It certainly wasn't because the parties that imposed the mandates were willing to give any kind of guarantee of non-repetition. The state governors' offices and public health agencies argued strenuously that their mandates were constitutional and that they retained the power to impose them again. The mask mandates, they claimed, had been lifted for reasons unrelated to the litigation, specifically high vaccination rates, low case counts, new treatment options, and warmer weather, such that COVID-19 conditions continued to improve. Never mind the fact that even taking all of those reasons for lifting the mandates to be true, and assuming a lack of hidden motives, it would still do nothing to prevent future mask mandates the moment those trends reversed. These kinds of arguments might have held water after the mask mandates of the Spanish flu, which were much shorter and a first-time occurrence, but in light of the COVID crisis mask mandates, which were often explicitly justified with reference to the Spanish flu mask mandates, it was wishful thinking at best for any court to even suggest it was entirely speculative that there would be a recurrence of comparable mask mandates in the future. Yet courts across the country credulously did just that. Health Freedom Defense Fund's lawsuit against the CDC's travel mask mandate suffered the same fate, dramatically weakening the precedent created by Judge Mizell's excellent and much-needed April 2022 ruling. On April 10, 2023, President Biden signed a joint resolution of Congress that officially terminated the COVID-19 national emergency. The HHS Secretary's Public Health Emergency Declaration expired on May 11th. Consequently, a 3-judge 11th Circuit panel ruled, "The mandate has expired on its own terms. There is no longer any mandate for us to set aside or uphold." The fact that the CDC continued to unapologetically defend the legality of its mandate made no difference. Indeed, this may have been part of the CDC's legal strategy once it started to lose. As one commentator observed, the administration's real priority may have been to preserve the CDC's power. By stringing out the case until it became moot, they avoided a precedent that might have tied their hands in the future. Many judges, to their lasting credit, recognized that the arguments for mooting challenges to mask mandates were dubious at best, and argued strenuously against doing so. Judge John K. Bush wrote a vigorous and cogent dissent against mooting Resurrection School's challenge to the compulsory masking of its students in Michigan. "Our collective experience with 2 years of on-again, off-again masking mandates demonstrates that there is at least a reasonable possibility this dispute could recur." Judge Bush emphasized that the Supreme Court's own precedents instruct that a challenge to a rescinded policy is unlikely moot when the defendant mounts a vigorous defense of the policy's lawfulness. Not only did the Michigan Department of Health and Human Services continue to insist on the constitutionality of its mask mandates for school children, but when asked at oral argument whether the state would commit not to reenact its earlier mandate, the state's counsel bluntly responded, "Absolutely not." Unfortunately, judges like John K. Bush were too often in the minority. If one is not willing to stand on principle during a crisis, at a time when such stands are most needed, then at the very least, issues raised during the crisis should be definitively adjudicated once the panic has finally faded and the disastrous outcomes from coercive and unconstitutional policies are more visible and still at the forefront of public consciousness. Local governments across the United States and many other countries repeatedly imposed and then fought to maintain or reimpose plenty of their own mask mandates even after statewide mandates were lifted. I am sad to say that my home city of El Paso, Texas, was among them. Even among those governors who lifted their mandates voluntarily, few formally relinquished or denied that they still retained the power to issue mask mandates in the future. Fewer still supported legislative safeguards against repeat COVID mandates. For many courts, future prevention of COVID-style mandates and current psychological closure for the plaintiffs was not enough of a practical effect to justify ruling on such a politically hot issue, especially one that was rapidly receding into the rearview mirror. In the name of judicial modesty, multiple rulings against state governor COVID crisis mask mandates, which would have gone a long way towards making local governments and future governors think twice about trying an encore performance to the mask charade, wound up marred by mootness. The ending of effective challenges to mask mandates before they could reach the binding precedent finish line ensured that many successes like HFDF v. Biden were not as strong and durable as they should have been, and many issues remain unresolved. Some plaintiffs who stuck to their guns, like Idaho church deacon Gabriel Wrench, arrested in the summer of 2020 for gathering with others to worship outside while refusing to wear a mask, were finally vindicated. In February 2023, Senior United States District Judge Morrison C. England, Jr. ruled that Wrench should never have been arrested in the first place. But even these vindications were often based on technicalities rather than the fundamental rights which were violated. Gabriel Wrench and his co-worshippers were arrested in violation of their First Amendment rights to freedom of speech, free exercise of religion, and right to expressive association, and more. Yet their arrest was ruled wrongful simply because the arresting police and prosecuting city officials had failed to honor their own mask mandate carve-outs for the First Amendment. Kicking this can down the road until the next hysteria will condemn future generations to suffer guaranteed abuses on similar grounds in the future. Good COVID crisis precedents exist alongside bad ones, often providing enough citations for judges to rule in whichever direction they are so inclined in the future. Nevertheless, many well-articulated and well-fought legal actions challenging compulsory masking now exist in publicly available forms, and can be consulted by any future litigants willing to take the time to read them. Those wins against compulsory masking in definitively completed cases like Green v. Alachua County in Florida have become all the more important. Other COVID crisis mask cases not mentioned in this book are still in progress, and the arguments they involve are nowhere near exhaustive. More strong arguments against compulsory masking are still waiting to be thoroughly researched, articulated, tried, and ultimately won by determined plaintiffs. Conclusion and general thoughts for those considering legal action. Personally, the experience of the COVID crisis has convinced me that a dedicated medical freedom amendment is needed to more fully secure the fundamental right to not be subjected to a medical intervention in the name of some greater good. Even without such an amendment, though, we have seen that many other long-established components of the Bill of Rights still provide substantial direct and indirect protections for individual liberties when it comes to issues like compulsory masking. For anyone who feels called to use any formal mechanism, including the legal system, to push back on compulsory masking, the next few pages are intended to be a summary of experiences and pitfalls others have encountered to provide you with a leg up and hopefully save you a few dozen or a few hundred hours of work. As stated previously, this is not legal advice or practicing law. The first step in pushing back against a mask mandate using any formal mechanism involves figuring out exactly where the mandate in question came from and exactly what it says. Fortunately, this is not nearly as difficult as it sounds, though it is time-consuming. When someone tells you some mask requirement is the law, do not assume they are correct. As one commentator aptly put it, Laws are passed by legislative bodies. Around face masks, there are orders, policies, statements, guidances, letters, protocols, and many other official-sounding words that do not mean the same as laws. Most mask mandates precisely cite the laws they rely on, and since those laws are publicly available, it becomes a simple matter to read them and find exactly what they do and do not authorize. Do not give the issuing authorities any benefit of the doubt when it comes to the accuracy of their statutory interpretations. Look up the statutes they cite and read them for yourself. They are publicly available by law. Cases like HFDF v. Biden show how important an analysis of statutory minutiae can be to the outcome of a case, and how prone to overreaching interpretations authorities tend to be when that kind of interpretation stands to increase their power. Do your research before filing anything. Search for a lawyer before going pro se. If you do go pro se, expect to be trading a lot of your time for any monetary savings. As you might expect, success is never guaranteed, but your chances are directly proportionate to the amount of work you are willing to put in. Whether or not finances dictate that you end up going pro se, a good starting point is to read the initial complaints and rulings of successful challenges to compulsory masking, probably including one or more from cases covered in this book. Most of them are publicly available, whether on Court Listener, Justitia, individual plaintiff websites, or are linked from news articles. Some are linked directly in the footnotes of this book. Don't stop there. Review the motions to dismiss, the responses to the motions to dismiss, the appellate briefs, and anything else that you think may be helpful. Looking at failed challenges can also be useful. During the COVID crisis, many challenges to compulsory masking simply did not get a fair shake. And besides, failure tends to teach more than success. Make sure you know where you are filing and what statutes you are filing claims under. Making a basic error like filing under the wrong statute, or filing a federal claim in state court, or filing a state claim in federal court would get your efforts off on the wrong foot, and a number of pro se challenges to compulsory masking foundered on this, e.g. Dennis v. Ige. For example, the 11th Amendment bars suits against state officials on the basis of state law being brought in federal courts. 42 U.S.C. Section 1983 is the statute that permits federal courts to hear claims for injunctive relief brought against state officials under federal law. Constitutional claims against state officials are Section 1983 actions, whereas claims against federal officials fall under Bivens. Considerations like this take time and mental effort to sort out correctly. It is easy to be an armchair general or a backseat driver after the fact. The truth is that lawyers drafting challenges to compulsory masking during the COVID crisis performed yeoman's service under incredibly difficult conditions even when not successful. For many of these lawyers, it was akin to a general practitioner MD suddenly finding themselves dropped into the emergency room during a mass casualty event with no trauma surgeons available or likely to be coming anytime soon. Many of the lawyers who were willing to challenge mandates came from other specialties and had to get spun up on the relevant law while drafting the complaints and dividing their limited time among other challenges to the multiple outrageous overreach measures all clamoring for their attention. Prior cases on masks were mostly obscure and indirectly applicable, and previous mask cases that were directly applicable had to be located and read carefully, which took hours. Once a suit was finally filed, judges in general tended to disproportionately default to experts and other professionals or governmental institutions, and the poisoned legal atmosphere of the COVID crisis meant that most legal challenges to compulsory masking were brought in covertly or overtly hostile courts. Even good arguments were met with derision, whether they were about the law or the science involved. Jeff Childers recalled, "My arguments were met by lazy, scoffing lawyers who didn't bother doing any research of their own, who mostly dismissed my cases as just being about awful Ku Klux Klan behavior. Wrong. Not one single case cited in my brief was a Klan case. I left all the many Klan mask cases out of my brief on purpose, knowing my opponents would get too distracted by the racial issue to wrestle with the underlying logic, even though the reason Klan members shouldn't mask in public is exactly the same reason nobody else should either. When I pointed out to my opponents there were tons of mask cases having nothing to do with the Klan, it was like their brains suddenly malfunctioned, sparked out, and everyone just moved on to their next arguments. It was vexing." Despite the frustrations and many failures, even unsuccessful legal challenges to compulsory masking served a useful function. Failed lawsuits are like failed scientific hypotheses or range-finding artillery rounds. They still provide valuable information that helps rule out what doesn't land on the mark so that you or some future challenger can try a different approach that does work or find a more fruitful channel for your efforts, legislative reform, for example. Moreover, Even in cases where failure is practically a foregone conclusion, it is important to make the bar as high as possible for the other side, and not all of the rulings that dismissed legal challenges to compulsory masking were illegitimate or purely pretextual. If you or someone you know is thinking about challenging masks in court, put in the effort to thoroughly prepare. Even in normal times, poorly framed initial complaints can be fatal for otherwise viable claims, and judges in cases challenging masks were rarely inclined to do the plaintiffs any discretionary favors. Citing references to substantiate allegations of fact was essential, and vague generalizations were called out as grounds for dismissal. Lawsuits targeting the lowest level of mandate the plaintiffs encountered seem to have been more successful on average than those which aimed higher. Remember that successes like those in Florida, Ohio, and Illinois were aimed at county, local public health, and school district mandates, respectively. By contrast, multiple lawsuits that aimed at governors' statewide mask mandates were dismissed because the requested relief would be too speculative. After all, if the governor's mandate was enjoined, a municipality or private actor could still theoretically impose one. As with many, but not all, civil rights cases throughout American history, preemptive challenges against mask mandates without a showing of direct harm tended to get dismissed. Some courts said the claims were not reviewable due to a lack of subject matter jurisdiction, depending on exactly what challenge was brought. Many plaintiffs challenging compulsory masking were ruled to have no standing to sue, often by failure to state a cause of action or failure to state a claim, such as failing to allege either personal intent to violate a specific mask mandate by entering a public space without face coverings, or failing to allege having been personally punished for refusing to wear a mask. The more the plaintiffs had directly suffered from the enforcement of the mask mandates, the further their lawsuits typically got. The initial complaints and responses to the motion to dismiss also had to be thorough. In at least one case, raising a new argument for the first time at oral argument was considered a form of forfeiting that argument. Many, though by no means all, mask challenges were low on scientific references. When references were cited to contest the efficacy of compulsory masking, they tended to be secondary sources rather than primary scientific articles. This made it easy for judges inclined to uphold compulsory masking to claim that the science was on the side of masks, though, as we've seen, plenty of these judges set the evidential bar for defending mandates scandalously low. Lawsuits that included direct quotes from whoever officially put out the mandate, either written or spoken, e.g. at a press conference, typically got farther than those which didn't, especially when those quotes pointed to an ulterior or mixed motive on the part of whoever was mandating the masks. Evidence that showed the public health officials were not acting in good faith or being inconsistent, arbitrary and capricious, or disproportionately burdening one group, like churches, made things especially clear. Some First Amendment speech claims challenging masks failed to allege an actual burden on speech, either speaking or expressive conduct. First Amendment religious claims against masks needed to articulate the core religious beliefs involved and explicitly allege a substantial burden on those beliefs through compulsory masking. A free exercise claim against masks, at a minimum, needed to identify the plaintiff's religion and describe its tenets that conflicted with wearing a mask. Failure to do so made dismissal easy, as happened in Dennis v. Ige in Hawaii. The complaint does not even identify his religion. It certainly does not describe the tenets of that religion or explain how the mask mandates affect any religious practice. Without more, this court cannot determine whether the mask mandates coerce Dennis to act in a way that is contrary to his beliefs. Even if Dennis had sufficiently alleged a substantial burden on his exercise of religion, he has failed to allege that the mask mandates were an irrational response to COVID-19. The right to exercise one's religion freely does not relieve an individual of the obligation to comply with a valid and neutral law of general applicability. Dennis has never asserted that the mask mandates are not neutral laws of general applicability. Accordingly, the mask mandates only violate the free exercise clause if they fail to survive rational basis review. As we can see from the example above, it was also important to specifically allege that the mask mandate was not neutral and generally applicable. Absent this specific allegation, most courts automatically found that mask mandates were neutral and generally applicable and then applied rational basis scrutiny. Even when plaintiffs made this allegation, most courts ultimately insisted that the mandates were neutral and generally applicable and applied rational basis scrutiny anyway, but at least alleging that the mask mandates were not neutral and generally applicable pushed the bar and effort necessary to do this that much higher, and built more support to help prepare for the inevitable appeal. As we have seen, it is possible to successfully challenge a mask mandate even under what is essentially a rational basis standard. Alleging that mask mandates per se are irrational is a non-starter because rational in rational basis is defined so broadly that it includes intuitive and no evidence needed. But alleging that a specific mask mandate is irrational or arbitrary and capricious, at least as implemented, can be viable. This is a subtle but critical distinction. Every COVID crisis mask mandate was self-contradictory or violated common sense in multiple ways. What took effort was spotlighting and spelling out those internal contradictions. The key pitfall to avoid was not to argue that all mask mandates are arbitrary and capricious, but that the particular mandate being challenged was arbitrary and capricious. This lesser burden is much more feasible to meet. Judges who think mask mandates in general are rational and justified may still be open to the idea that the mask mandate immediately in front of them is irrational and unjustified. Remember that challenges brought against state and local governments under the federal Constitution's Bill of Rights only have a chance at success insofar as they allege violations of rights which have been specifically incorporated against the states under the 14th Amendment. Remember also that challenges to compulsory masking brought under the Due Process Clause of the United States Constitution were generally less effective than challenges brought under the state constitutions or due process requirements from specific statutes, as in the Ohio and Illinois cases we reviewed earlier. Each state has its own Bill of Rights, some of which, like Florida's, contain provisions protecting certain individual rights that are stronger than those in the United States Constitution. Jeff Childers' critical 2021 win against masks came because of Florida's Constitution. Procedural and statutory lines of attack were often the most effective options available to challenge compulsory masking, as in the successful statutory due process challenge brought by attorneys Brant Hadaway and George Wentz against masking Illinois schoolchildren. Masking was a form of modified quarantine because it involved devices intended to limit disease transmission and had been imposed and then reimposed without any of the due process required by quarantine laws. Many state and local health codes contain detailed due process procedures and guarantees. When courts were reticent about 14th Amendment and state due process clause challenges, these procedural due process requirements were sometimes able to act as surrogates, though they needed to be read carefully because due process protections for custodial detention and non-custodial orders often differed. The 14th Amendment should not be left out, but it benefits greatly from some local assistance, at least where challenges to masks are concerned. Any legal win against compulsory masking is a major achievement and cause for celebration, but some wins are more decisive and durable than others. In a sense, it was actually a good thing that purely science-based challenges to masking were legal non-starters, because contesting compulsory masking based purely on the science implicitly granted the utilitarian premise that individual rights turn on a numbers game, that they are contingent on how many people may benefit from violating them. If you find yourself arguing purely on the science of masks, you've likely already implicitly conceded the most important ground. On the other hand, because the science of masks is so far removed from the deeper arguments that are already entrenched and get people riled up, sometimes arguing purely on the science can be an effective foot in the door. Beliefs about the science can be as dogmatic as the most fanatical religions, but people's beliefs about what the science says are generally more open to change than their beliefs about what they should do based on what the science says. In theory, an administrative or procedure-based win against masks could simply have the net effect of making mask mandates more robust by forcing the issuing authority to dot all their I's and cross all their T's. In many cases during COVID, the mandating authority was simply given a procedural pass because of the ongoing emergency, and the mandate was allowed to remain in force while going through the processes required to make it kosher. This lenient deference is what Supreme Court Justice Alito referred to when he wrote that, at the dawn of an emergency, and the opening days of the COVID-19 outbreak plainly qualify, public officials may not be able to craft precisely tailored rules. Thus, at the outset of an emergency, it may be appropriate for courts to tolerate very blunt rules. Judges were subjected to the same psychological blitzkrieg that everyone else was. On top of this, people with credentials tend to have a pro-credential bias. Courts are no exception, and default to the assumption that any emergencies have been declared with good reason. Judges who imposed mask mandates in their own courts often looked very dubiously, if not with outright hostility, on anything which even indirectly implied that they may have been wrong to do so. Still, as we have seen, a portion of judges resisted the mass hysteria just as a portion of people among the general population did, and panic will wear off eventually as long as it doesn't penetrate too deeply. None of the potential drawbacks should prevent using administrative and procedural grounds to challenge masks. Sometimes these are the only tools available, and an administrative or procedural win can still be decisive in practice. Even a temporary reprieve from masking is beneficial. Also, if the only authority that issued the mandate is also its primary or only proponent, then stopping that mandate may be all that is needed. Even if it is simply a matter of doing more work to make their mask mandate stick, if the issuing authority is too lazy or has too many other demands on its time to put in that work, they may just decide it's not worth the effort of dotting all those I's and crossing all those T's. If you are willing to put in more effort than the opposition, then you already have a big advantage. Administrative and procedural challenges to compulsory masking also have a number of advantages. Procedure-based challenges can sometimes be the most straightforward. If one can show that the issuing authority simply did not have the legal power to do so, then that's that. Authorities that may have the power often have a list of procedures that they have to follow if the rules they put out are to be valid, and it is usually a pretty black and white question as to whether or not they did that in the case of their mask mandate. The CDC's habit of bypassing notice and comment is a prominent example of how authorities often failed to follow their own rulemaking procedures when mandating masks. Furthermore, if an authority has overstepped their legitimate domain to issue a mask mandate, then the odds are good that they have done so by encroaching on some other institutional authority's territory, as when federal agency mask mandates encroached on state prerogatives. Even if the second authority generally holds the bad philosophy that allows compulsory masking, they may not agree that compulsory masking is warranted in this particular case, and they are more than likely to jealously guard their powers and prerogatives, which means their interests and yours may both align against the particular mask mandate you are opposing. Also, from a judge's point of view, it is a much more comfortable decision to say, Authority B cannot mandate masks, while leaving it an open question as to whether or not Authority A can mandate them. The most successful lawyers and plaintiffs set the bar for the judges to rule in their favor as low as possible. A good starting point was not seeking any monetary redress. In Dennis v. Ige, the plaintiff sued for over $600 million. That was a mistake. Smart lawyers and plaintiffs made it clear that the judge knew what ruling in their favor would not amount to. No judge in 2020 was, and only a rare judge is at any time, willing to make a finding of fact that contradicts an organization like the CDC. In Green v. Alachua County, Jeff Childers made sure the judges were aware of exactly how low the bar for ruling in favor of his client actually was. He started by making it clear that his case was not about whether or not masks actually work. Childers also emphasized that granting a temporary injunction in his client's favor did not amount to striking down the mask mandate, because it was still possible the mask mandate would survive a hearing on the merits. He repeatedly pointed out that showing Alachua County lacked authority to require face masks was not the same thing as striking down all mask mandates, because the higher authorities of the governor or the state legislature could still potentially have the authority to mandate masks. Jeff Childers' reminders about these things apparently did not fall on deaf ears because the appellate court's ruling was careful to highlight this distinction. To be clear, we are not saying that the mask mandate in fact was unconstitutional. If, however, Green persists in his challenge to some new mask mandate that the county adopts, the trial court would have to start its analysis with this presumption of unconstitutionality. In other words, we're not saying the county's mask mandate is unconstitutional. We're saying it's presumptively unconstitutional. For that stage of the case, this was the correct call, and presumptively unconstitutional is often all that is needed to stop measures based in fear, bad science, manipulative psychology, and bad philosophy. Another good example comes from the challenge to masks out of Minnesota. This court need not reach any conclusion about the effectiveness of face coverings in Minnesota, but it should conclude that absent evidence that masks are actually necessary to slow the spread of COVID-19, there is no compelling state interest in forcing people to wear masks of wildly varying types. Note that finding that the mandating authority failed to provide enough evidence that masks work and are necessary is not the same thing as finding that masks do not work at all. It is also far less of a stretch for any court to reach than a finding that masks do not work. At the time of this writing, the CDC and other federal agencies are still very much exploring alternative avenues that they can use to reimpose mask mandates, and there are plenty of judges who would be happy to rule in their favor. The legal duels over compulsory masking have abated, but they are far from over. In a sense, they will never be over, because the mentality underlying compulsory masking mutates, renews, and resurfaces in every generation. Trying to forcibly inoculate the entire population against it by imposing ideological conformity would be immoral even if it could be done effectively. The only real answer is to strengthen enough individuals on a voluntary basis that a sort of societal immunity prevents the next panic from gaining the same foothold compulsory masking did during the COVID crisis. In the final section of this book, we will look at ways you can personally make a difference in how the final denouement on masks turns out, as well as to how this general cycle plays out the next time around.